orders of the day. Oh, yeah. It is my duty to lay before the House, pursuant to subsection 7.5 of the Auditor General Act, additional 2026 reports of the Auditor General of Canada. Pursuant to Standing Order 1083G, these documents are deemed to have been permanently referred to the Standing Committee on Public Accounts. Comme il est 11 heures.
It being 11, the House will now move to private members' business pursuant to today's agenda.
Members' business, consideration at report stage of Bill S-228, an act to amend the Criminal Code sterilization procedures, standing in the name of Mr. Schmale.
The Honourable Member for Halliburton, Kawartha Lakes. There being no motion at report stage, the House will now proceed without debate to the putting of the question on the motion to concur in the bill at report stage. Mr. Schmale, seconded by Ms. Lewis, Haldeman Norfolk, moves that Bill S-228, an act to amend the Criminal Code sterilization procedures, be concurred in at report stage. If a member participating in person wishes that the motion be carried or carried on division, or if a member of a recognized party participating in person wishes to request a recorded division, I would invite them to rise and indicate it to the chair. I therefore declare the motion carried on division. Well, when shall the bill be read a third time? Now. It's a good time. Mr. Schmale, seconded by Ms. Lewis, Haldeman Norfolk, moves that Bill S-228, an act to amend the Criminal Code sterilization procedures, be now read a third time and do pass. Debate. The Honourable Member for Halliburton, Kawartha Lakes.
Thank you very much, Mr. Speaker. I rise today at third reading of Bill S-228, an act to amend the Criminal Code regarding sterilization procedures. At this stage, we are no longer debating whether the issue deserves attention. We are deciding whether Parliament will act. Bill S-228 asks us to confront a reality that is difficult, uncomfortable, and deeply troubling. That forced and coerced sterilization has occurred in Canada, that it has caused profound harm, and that it has not been confined to the past. The legislation exists because survivors came forward and asked us to act. And today, we must answer that call. I'd like to, of course, thank Senator Boyer for all her work ushering this bill through the Senate, and also groups like the Survivors Circle for Reproductive Justice for all their work, as well as groups like Community Justice and Health Equity, and my colleagues here on all sides of the House, actually. It's been remarkable to see the support from every single party in this House, and those that are not official parties like the NDP and the Greens, who have supported this as well. Beginning in the early 20th century, eugenics politics shaped public institutions and legislation. Provinces such as Alberta and British Columbia enacted sterilization laws that allowed the state to permanently prevent individuals from having children. These laws disproportionately targeted Indigenous peoples, persons with disabilities, and those deemed by authorities to be unfit. Thousands of procedures were carried out, lives were permanently altered, and communities were deeply affected. While those laws were repealed by the 1970s, the attitudes that enabled them did not simply just disappear. Evidence presented to Parliament through Senate committee studies, academic research, and survivor testimony demonstrates that forced and coerced sterilization continued after the repeal of those laws and continues to be reported today. Many Canadians believe this practice belongs to history, but the truth is far more difficult. Survivors continue to come forward with accounts from modern hospitals describing experiences that echo the very same patterns of coercion, pressure, and disregard for autonomy. We have heard clearly what these experiences look like. Women have described being approached for sterilization at moments of extreme vulnerability during labor, immediately after childbirth, while medicated, exhausted, and in no position to provide meaningful consent. Some were presented with consent forms they did not understand. Some were told the procedure was reversible when it was not. Some were pressured through fear of losing access to care, fear of child welfare intervention, fear of being judged or dismissed. And some were never given a choice at all. These were not isolated incidents. They are part of a pattern, and they reflect a deeper problem. At the heart of the issue is the concept of consent. In Canadian law and in medical ethics, consent must be free, informed, and voluntary. It must be given by a person with capacity. It must be based on full disclosure of risks and alternatives. It must be given in circumstances where the individual has time, the clarity, and the ability to make a decision without pressure, and it must be free from coercion. When those conditions are not met, consent is not valid. And what we have heard from survivors is that these conditions were often absent. Consent obtained under duress is not consent. Consent obtained during misinformation is not consent. Consent obtained through fear or authority is not consent. It is coercion, and coercion has no place in healthcare. The consequences of forced and coerced sterilization are profound. This is not a temporary harm, it is permanent. It alters the course of a person's life. Survivors speak of the grief over the children they were unable to have. They speak of trauma, of anger, and the loss of identity. They speak of a violation that they carry with for the rest of their lives. For Indigenous women, the impact extends even further. In many Indigenous communities, the ability to bring children into the world is not only a personal decision, it is deeply connected to culture, to family, language, and the continuity of community. When that ability is taken without consent, the harm is not only individual, it is collective, and it is intergenerational. We must also recognize that this issue does not occur in isolation. It exists within a broader context of systemic discrimination, colonial history, and structural inequities in our institutions. Witnesses before committees spoke about the power imbalance between patients and medical professionals. They spoke about language barriers, cultural barriers, and geographic isolation, particularly for Indigenous women traveling from remote communities to access health care. They spoke about the fear of child welfare systems and the long history of state intervention in Indigenous families, and they spoke about the erosion of trust. When individuals feel powerless within a system, when they feel they cannot question authority, when they feel they must comply in order to receive care, the conditions for coercion are created. While Indigenous women have been disproportionately affected, it is important to recognize that the issue extends way beyond one individual group. Historically, men and boys were also subjected to sterilization under eugenics policies. Today, other vulnerable populations, including persons with disabilities, racialized individuals, intersex persons, and those facing systemic barriers may also be at risk where consent is not properly obtained. At its core, this is not solely a women's issue, it's a human rights issue. It's about the fundamental right of every person and their bodily autonomy. And Parliament has studied this issue very carefully. The Standing Senate Committee on Human Rights conducted multiple studies. The Standing Committee on Indigenous and Northern Affairs has heard from survivors and experts and reached a clear conclusion. Forced and coerced sterilization is ongoing, it is underreported, and it requires legislative action. The committee's first recommendation is that the legislation be introduced to specifically address the issue in the Criminal Code, and Bill S228 is that response. This bill builds on the work of Senator Yvonne Boyer, who has been a tireless advocate on this issue. Its predecessor, Bill S250, was studied extensively, refined, and passed unanimously in Senate before it died on the order paper. Bill S228 contains that same carefully developed framework. It is again passed in the Senate and is here in the House of Commons. It has already received strong all-party support and was expedited through committee consideration. And that level of consensus does speak volumes, Speaker. So what does this legislation do? It's focused and it is precise. Bill S228 makes it explicit for greater certainty that performing sterilization, a sterilization procedure, without a person's valid consent constitutes aggravated assault under the Criminal Code. It does not create a new offense. It clarifies the application of existing law. It ensures that sterilization without consent is recognized as conduct that causes serious and permanent harm, and is meant to offer clarity to this issue, because that's essential. And while existing assault provisions may technically apply, they have never been used to prosecute forced sterilization in Canada. Survivors have told us that the absence of clear legal recognition has contributed to silence, confusion, and a lack of accountability. And this bill addresses that gap. It is equally important to be clear about what this bill does not do. It does not restrict voluntary sterilization. It does not interfere with reproductive choice. It does not affect gender-affirming care, and it does not criminalize legitimate medical practice or emergency interventions. Existing criminal code protections remain in place, including those that protect physicians acting to preserve a patient's life or health. The consent framework remains unchanged. Consent is not valid where it is obtained through force, threats, fraud, duress, or the abuse of authority. Bill S228 does not alter those principles. It actually reinforces them. There has been thoughtful discussion about whether criminal law is the appropriate tool to address this issue. It is true that legislation alone cannot solve every aspect of the problem, but ending forced and coerced sterilization will also require improvements in medical training, stronger consent practices, and continued engagement with communities and survivors. But clarity in the law matters. Criminal law sets boundaries. It signals what conduct is acceptable and provides a mechanism for accountability. Without that clarity, enforcement becomes uncertain, and without accountability, trust cannot be restored. Trust is central to this issue. The relationship between a patient and a medical professional is built on trust. When that trust is broken, the consequences extend far beyond a single incident. People lose confidence in the healthcare system, they delay care, they avoid seeking help altogether, and the impacts on health outcomes are significant. And rebuilding that trust requires attention. This legislation is also a step forward towards reconciliation. Forced and coerced sterilization must be understood within the broader context of policies that have sought to control Indigenous lives, families, and communities. Reconciliation requires more than acknowledgement. It requires action. It requires structural change, and it requires ensuring that such harms do not continue. And Bill S228 is a step in that direction. And before I conclude, I'd like to again recognize the individuals whose courage has brought us to this point, and this legislation exists because survivors spoke out and shared their stories. They relived painful experiences so that others would not have to, and they asked Parliament to act. We must honor that courage. And at third reading, the question before us is clear. Will we ensure that Canada's criminal law reflects the seriousness of this violation? Will we affirm that sterilization without consent is not a misunderstanding, not an oversight, but a grave breach of human rights? Will we act to protect future generations? Bill S228 affirms a fundamental principle. No one's reproductive future can be taken from them without their free, prior, and informed consent. No one's body can be permanently altered through coercion or pressure, and no one's dignity is negotiable. The evidence is clear, Speaker. The need is urgent. Survivors have waited long enough, and I encourage all members of this House, if I can get my tongue untied, to support Bill S228 at third reading. Let us act decisively, let us act responsibly, and let us ensure that this injustice has no place in Canada now or ever again. Thank you very much, Speaker.
Questions and comments. Question et commentaire. The Honourable Parliamentary Secretary, the Government House Leader.
Yes, so thank you, Mr. Speaker, and I appreciate many of the words that the member has put on the record with respect to such an important issue. And I think that I would like to highlight in the form of the question comment is in regards to the brevity and the courage that it would have taken survivors, individuals that have gone through this experience, and continue to raise the profile of the issue to the degree in which we actually have legislation before us, which I am anticipating will be passing at the very longest after the second hour of debate on it. And if he could just provide his thoughts in terms of recognizing those outstanding individual Canadians.
The honourable member for Haliburton, Kawartha Lakes.
Thank you very much, Speaker, and thank you to the member opposite for that question. I'd also like to thank the government for supporting this piece of legislation, not only this piece of legislation, S228, but also the previous version that was lost when Parliament prorogued during the last Parliament, coming upon a year from now, actually. And yes, hearing from those survivors was something that relived a lot of trauma for a lot of people. It wasn't easy in a lot of circumstances for these witnesses to come forward, these survivors to come forward, to speak about it openly and on camera about it. It was very difficult for them, but the fact that they drew on that courage, they wanted to ensure that future generations were not impacted by this. They wanted to ensure that there is a correction here. It shows the importance and speaks to their courage with this topic.
Questions et commentaires.
Questions and comments. The honourable member for Abitibi-Témiscamingue. Thank you, Mr. Speaker. And a sincere thanks to the member for Haliburton-Kawartha Lakes for his sensitivity. We can feel it. And his commitment to this issue. In the circumstances, these are horrendous issues. But I think he is standing here and speaking to these issues with great dignity. And I think here we are at third reading. We just did report stage quickly, but at report stage, it's important to talk about the testimony of victims, specifically Nicole Rabbit, who was to have a cesarean section. She was at Saskatoon University Medical Center in September 2001. That says not 30 years ago. She said she trusted the medical team, but she knew something wasn't going well when she smelled burning flesh. These were foreigners strangers that I didn't know who imposed this on me. The medical team forced this on me when I was in a vulnerable state. No one asked me what I wanted. No one told me why I needed this. I didn't sign any forms. I had no clear ideas of my options or any reasons why I should be sterilized. I now know that sterilization is irreversible in this case. My colleague was talking about reconciliation and structural issues. What can we do to ensure real reconciliation?
Thank you very much, Speaker. And I want to thank the question from my friend from the bloc. Although he's not on the Indigenous and Northern Affairs Committee anymore, I did appreciate working with him during the many years of that committee. He was a great asset to that group. Do miss his contribution greatly, but I do appreciate his support, both of S250, the previous bill, and also S228, this current bill. And the member from the bloc did articulate some of the comments we heard and the testimony we heard at committee, and just in that little segment, that was just one witness testimony, but you could feel the trauma that person endured, hearing that story. And as he mentioned, it's not as if it happened many years ago. That's in recent memory. That's some trauma that is still fresh in someone's mind, and someone will have to live without the knowledge that they'll be able to have any children. So I think this touches everyone, and I think we need to act right now.
Questions and comments. Time for a brief question. Questions and comments. The honourable member for Waterloo.
Thank you, Mr. Speaker. Mr. Speaker, I want to thank the member for his work on this file and the importance of bringing this issue forward. And I think what we know is that, these individuals weren't always believed. And luckily, society is advancing. We've just seen a case in Ontario where 48 women came forward and the judge had no problem suggesting that there was no credibility to any of their testimonies. I would like to hear the member on the work that we need to do and how we ensure that survivors are believed, and when they're coming forward, that they receive the dignity and respect that they deserve. Thank you, Mr. Speaker.
Member for Haliburton-Kawartha Lakes, a brief response.
Okay, thank you very much for the member opposite for this the question. And that's something we heard during testimony during the committee process, that many times the victims did not know what was happening to them. The survivors weren't sure what the procedure meant, and this legislation here is a way to correct that wrong. Thank you, Speaker.
Resuming debate, reprise débat. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. And, before I get started, I just wanted to briefly make mention of the significance of tomorrow. Tomorrow is a Red Dress Day. Across our great nation, individuals will be recognizing the tragedy that occurred with the murdered and missing women. And for me personally, I think it's important not only to highlight it, but also to recognize that even today we still see young girls and women in particular from the Indigenous community that continue to go missing, continue to be murdered. And we have to be diligent and support Indigenous leadership, like my colleague from Churchill, who has a beautiful red brooch on, I notice, in recognition of tomorrow's special day. So I want to start off by just making mention and reminding members of the significance of tomorrow. And in part, Mr. Speaker, the legislation that we're talking about for Private Members' Hour is a form of discrimination in many ways that had taken place here in Canada. And not very many people are aware of the type of discrimination that I'm actually referring to right offhand. And that is when you deal with the issue of sterilization. Many women, we're talking about hundreds of women, Mr. Speaker, were coerced or forced in one way or another and convinced that the sterilization was absolutely essential for that person to do, Mr. Speaker, at a substantial cost. And I'm not talking about money. I'm talking about human rights at a substantial cost. And it's really quite unfortunate that it took so long for us to recognize as a nation that it was actually being done in some provinces. You see, in Canada, there's a joint responsibility related to many different portfolios, jurisdictional responsibilities between Ottawa and the different provinces. And we actually had some provinces, I know BC was one, and there were others, Mr. Speaker, that actually had a law that supported actually having forcing women, in essence, through coercion and others, to become sterilized, Mr. Speaker. That is a very serious violation of human rights. And when I look at the core of the issue, it is about trust. The question that I had posed to my colleague across the way was to recognize the terror and the horror that an individual would have experienced as a survivor. Because I suspect what you will find is that many of the women that were put through this tragedy, Mr. Speaker, had no sense of what was being done to their body. And then to find out at a later point in time that they were actually sterilized, I can only imagine how difficult that would have been to address. The emotions, the fact that you're not able to have a child. Often individuals were completely misled to believe that, you might be able to, or you can change it into the future. Some people today still think that a sterilization is something in which you can just reverse, a few years later. And that's just not the case, Mr. Speaker. It was devastating, in particular, to some communities more than others. Our Indigenous people were targeted, if not intentionally, and I would suggest it would have been intentionally, Mr. Speaker, by many, to have sterilization. The same thing in terms of people with disabilities, where I believe the line was crossed. It is an issue of trust. When we go and seek assistance or getting advice, Mr. Speaker, we have faith in the people that are around us, in our institutions, that they are going to give a balanced approach in providing advice. One based on medical conditions, some social factors, no doubt, and other considerations. And we have faith that ultimately was displaced, where there was another agenda that was being served over and above the interest of the woman that was having to make a difficult decision, or in many ways, a decision was actually made on her behalf. One can only appreciate how it is that someone's human rights, a very basic one, has actually been violated in a situation like that, Mr. Speaker. Coerced sterilization is a serious violation of a bodily autonomy. And whether one likes it or not, the bottom line is the realization that it is the woman's right to decide, Mr. Speaker. And we as a society need to support that in every way. And that means the legislation that we have today before us, S228. This legislation is not the first time that we've attempted it to get through, but I believe now, given the current political situation, having it at that third reading, we are now talking about maybe another hour's debate, hour and a half's debate before its ultimate passage. The support that the legislation has received from the Senate, from members of Parliament, current and past, there is no doubt in my mind, Mr. Speaker, that this legislation will in fact not only pass, but receive royal assent. That's a good thing. It's taken a long time, Mr. Speaker. As has been pointed out, these sterilization policies were impacted generations ago. You're probably talking, 60, 70 years ago, Mr. Speaker. And at the end of the day, the House of Commons is providing clarity on an important issue. And the only reason why it is possible, why it is that the House is actually recognizing this, is because we have a situation where survivors have had the courage and the brevity to continue to talk about it. I remember in the Manitoba legislature years ago, when I was first made aware of the issue. And there was even issues that were being raised back then in regards to sterilization and crossing the line. What is advice? What kind of consent versus coercion? And it still happens today, Mr. Speaker. But it's because of those brave and courageous women from the past that had to live through that experience and then continue to share that experience, that we've had the public and parliamentarians at all levels become enlightened about the issue and ultimately have led to the legislation that we have before us. So it's to recognize that survivors, particularly Indigenous women, that have been clear about the harm that it caused by forced or coerced sterilization. Those are the ones that I would like to be able to recognize in particular and thank them for their persistence on the issue. And that is the reason why the legislation is passed. Indigenous leadership, individuals in particular within our disability communities, and others, people that see human rights advocates, that have seen the violations that have taken place and recognized it for what it is, a lack of consent and disinformation, discrimination, all these type of negative things that have taken place. It's important that we recognize it. It's also important to recognize that in many different ways or forms to be diligent so it doesn't continue to take place. Thank you, Mr. Speaker.
Resuming debate. Reprise du débat. L'honorable député de Shefford.
The honourable member for Shefford. Thank you, Mr. Speaker. First of all, this is not directly related to today's topic, but this is an issue that's tangentially related. I'm wearing the red dress brooch. Tomorrow, May 5th, is the National Day of the Red Dress, and we should all remember missing and murdered Indigenous women and girls. And Mr. Speaker, there are some topics that are hard to talk about. When I was elected in 2019, Senator Miville Dechaine told me about the multi-party group on modern slavery and human trafficking. I couldn't believe that in 2019 there was still modern slavery and human trafficking. It was naive of me, but it's hard to believe that today in 2026 I'm having to rise to speak about the topic of forced sterilization. There are issues that are very sensitive and that are hard to talk about. Nonetheless, I am going to talk about this. There is a fundamental principle. The right to make decisions about your body. That right is at the heart of any free and democratic society. Let's be clear. Forced sterilization is a violation of human rights. It constitutes irreversible injury. It's a type of institutional violence. This is not a theoretical debate. In 2026, this is still a lived reality, unfortunately. And behind this bill, there are real women who have lost their capacity to freely choose whether or not they want to bring a child into the world. This is hideously cruel. As the mother of a 4-year-old girl, I am deeply disturbed by this, but it is part of a dark history, this reality. This is part of our historical and colonial heritage. Between 1966 and 1976, there were 1,200 sterilizations, 1,150 Indigenous women. Indeed, Indigenous women are overrepresented. This is part of the legacy of eugenic colonial policies. There were 580 cases that were documented between 1970 and 1975. These practices seek to control certain bodies that are considered, quote-unquote, undesirable. This is systemic racism, and it's an example of health inequality. So despite what one might think, this is still an issue that still plagues the country today. There are some class actions. More than 100 women in Saskatchewan, 5 class actions throughout Canada and Quebec, 22 cases that were documented. There are 30 Atikamekw women who are currently before the courts, 35 recent cases that have been reported. And we know also that often consent for these procedures are asked for when the patients are in pain, vulnerable, and under pressure. You can't get real consent when someone is in a vulnerable situation and they are under pressure. This is not something that we can bury in the past. This is something that's still before the courts today. Why do we need to legislate on this? Well, because indeed there already have been these offenses. But currently there's no clear way to frame the definition of the action or to start prosecutions because it's very hard to punish something that's not clearly defined. Let me give an example. Sexual assault. It needs to be clearly defined or you can't do anything about it. We need political will. We need to send a clear signal. We need to show institutions that there is zero tolerance on this. We need to specifically name what's going on in order to protect these women. So we need to clarify that sterilization is a type of serious assault and mutilation, and the definition should include enough detail to make it clear that it's any intervention that prevents procreation. We need to make sure that there's free, prior, and informed consent. Of course, we need to consider the intention of the procedure, and we need to protect necessary medical procedures. We need to protect doctors when there is valid consent. We know that there are emergency situations that are covered under Clause 45. This bill would protect patients without penalizing good faith professionals. That's what we want here, Mr. Speaker. Because sometimes there are criticisms, and people say that this might criminalize doctors. But this is clear legislation that would protect professionals, medical professionals. It creates protocols, strengthens consent. It's the same logic as medical assistance in dying and health care for people with disabilities. We do not want to leave we do not want to leave gaps in the law, because we can see from reports that there are issues in the current situation. If you have theoretical rights with no real application, that doesn't protect anyone. What ends up stigmatizing people is the silence and the lack of recognition around the issue. That's a problem. This is a taboo topic that is rarely discussed. In order to recognize something, you need to name it. And in order to protect these women, we need to recognize what's going on. That way, these women can continue to make decisions about their own bodies. This is a systemic and social issue. Some specific groups are more affected than others. Indigenous women, racialized women, people with disabilities. This has a great deal to do with power, as I was saying. And what's particularly disturbing is to think about all the consequences of this: trauma, lack of trust, loss of trust, intergenerational impacts. This is not just an injury to the body. This type of action injures someone's entire life. Because if a woman can no longer bring a child into the world, that affects her choice to have a child or not have a child. It ends up affecting her entire life. She will have to live with the physical and psychological impacts of the action forever. And there are many impacts. So, of course, our position in the Bloc Québécois is that we support this bill. We firmly support it. Of course, there are some things that we would just like to point out. We want this to be done while respecting Quebec's health jurisdiction. We also would like to underscore that it's important to cooperate with Indigenous nations. That's, again, this is something we care about in the Bloc Québécois, nation-to-nation relationships. We want to make sure that Indigenous nations are involved. We do not want the federal government to engage in an inappropriate level of centralization. This is something we say frequently, because constantly this federal government, it's always trying to go too far with centralization. We want to protect rights while respecting jurisdiction. We want to protect Indigenous women and girls. It's not enough to have legislation. We need to train professionals. We need a monitoring mechanism. And we need cultural adaptation. Look at what the Quebec College of Physicians did. It's making sure to cooperate with all stakeholders. And despite the criticisms that have been made from doctors' perspective, this bill actually seeks to protect doctors as well. So we appreciate what the College of Physicians is doing, because we need to make sure that this isn't just an abstract theoretical law. It needs to also be embodied in practice. We need to reduce stigma. We need to eliminate taboo around the topic of forced sterilization. This is still happening. My colleague for Abitibi-Témiscamingue mentioned it earlier in his question. We've heard about it at committee. My colleague cares a lot about this, and he raised a specific issue. He talked about a specific case of a woman who went through this and everything that she suffered physically and psychologically. In conclusion, Mr. Speaker, these women have been ignored and silenced. We need to remember what these victims have gone through as a result of these heinous actions. Today, collectively in this House, we are all responsible for taking action. This is a call to justice, to dignity, and to recognition. That's the goal of this bill. The last thing I would say is that this bill is a step towards reparations, and it is a commitment to never tolerate the unacceptable again. Increasingly, we are talking about reconciliation, and in that context, I think this bill is part of that. We need to put partisanship aside and move forward to support victims. Thank you.
Debate. Reprise débat. The honourable member for Parliament-Norfolk.
Thank you, Mr. Speaker. I'd like to first mention that, say thank you to the member from Caribou, Prince George, who actually gave up his time today so that we could debate this very, very important issue. Mr. Speaker, forced sterilization is a clear violation of human dignity. It is not simply just a failure of policy by a nation. It is not just a mere error in judgment. It is an assertion of control over someone else's ability to procreate in the future. And when we examine the history of this country, we have to be honest about systemic violations of this nature. And we have to actually recognize that these violations, where it corresponds and relates to Indigenous people, have not occurred in isolation. It exists within a broader and deeper troubling pattern, a pattern of dehumanization of Indigenous women. Mr. Speaker, the international community has already recognized the importance of informed consent. And so I want to just highlight on that principle and how it relates to what we're speaking about today in this House. In the aftermath of the Second World War, during the Nuremberg trials, the world was forced with reckoning with medical experimentation carried out on human beings without their agreement or consent. Out of that reckoning came the Nuremberg Code, which established a principle that has long shaped modern medical ethics. This code recognized that the voluntary and informed consent of an individual is essential. And this principle is not just theoretical in nature. It was drawn from real abuses in the international era, where human beings were treated as objects rather than as persons. It established a boundary that no government, no institution, and no professional should ever cross. And yet, Mr. Speaker, we're here today debating a very similar issue, even after standards were set. We must confront the reality that similar violations occurred within our very country. In 1940s and 50s, the federal government, through the Department of Indian Affairs, and in collaboration with leading researchers, conducted a series of nutritional experiments on Indigenous children in residential schools. These studies were overseen in part by a doctor, the superintendent of Indian Affairs, Medical Services, and prominent pediatricians known for developing infant nutritional products. And I raise this issue to just show that the issue of forced sterilization is not in isolation to policies that have been advanced in this nation, and so that we can understand the seriousness of having to legislate against such issues and natures of experiment. But these experiments were not designed to heal, these nutritional experiments. They were designed to observe. And the observation of these Indigenous children were done almost as we would do in experiments, watching lab rats. And I hate to use that analogy, but this is what was done within our very country. These children were among the most vulnerable at the time. They were already removed from their families and they were in residential schools. And they were deliberately studied to see how children would react to malnutrition. In these starvation human experiments, Essential nutrients were withheld from these precious, innocent children. In some cases, schools were divided into test groups versus control groups. And critical dental care was intentionally denied, not because it was unavailable, but because researchers wanted to see how this study of nutritional deficiency would impact on dental disease over time. Mr. Speaker, these were not isolated oversights. These experiments were organized and documented and funded by the Canadian government. Historical records later brought this to light through archival research by scholars, and it was shown that officials were aware of the conditions, and yet they still proceeded nonetheless. There was no meaningful consent, just like we see with the sterilization cases. Parents were not informed, and children were not given a voice. They were treated not as individuals, but as individuals who lacked inherent dignity, but were just subject to experimentation. Mr. Speaker, this is not simply a tragedy in the chapter of our past. It reveals a pattern in which Indigenous people were treated as objects of policy rather than as human beings deserving of care, protection, and the same respect that all Canadians receive. And that same pattern is reflected in the history of forced and coerced sterilization in Canada. For decades, provinces like Alberta and British Columbia operated under this eugenics legislation. The Sexual Sterilization Act of Alberta authorized sterilization of thousands of individuals, many without full understanding and meaningful consent. Those disproportionately targeted included Indigenous women, girls, and marginalized populations. Even after those laws were repealed, the practice did not end. In recent years, Indigenous women have come forth with accounts of being sterilized without full, informed consent. Some were approached during childbirth at moments of extreme vulnerability, and some were pressured into signing forms that they didn't fully understand, and often at their most vulnerable moment. Others reported that procedures were performed without their knowledge. Mr. Speaker, this is not healthcare. It is not care at all. It is control. It is control over a woman's ability to decide in the future that she may want children. And under Canadian law, it constitutes bodily harm. In any other context, we would recognize this as an aggravated assault. And we must understand that this issue sits within the broader systemic context. And we have heard about this context within the National Inquiry into Missing and Murdered Indigenous Women and Girls. That inquiry concluded that violence against Indigenous women was not random, it was systemic, and it was rooted in generational marginalization, dispossession, and erosion of dignity. Forced sterilization must be understood within this continuum. It reflects a history in which decisions about Indigenous women's bodies were made by others, and without respect for their autonomy, their dignity, and their humanity. Bill S-228 is necessary. It affirms clearly that forced and coerced sterilization is a criminal act. It reinforced that non-consensual sterilization meets the threshold of aggravated assault under the Criminal Code, and it draws a clear line that no authority, no medical institution, or no government has the right to override when a person can decide to have a child in the future. If we are to move forward with dignity, we must confront history fully. We must recognize that policies, once justified, the language of progress caused real harm and lasting harm. And we must ensure that our laws reflect different standard, a standard rooted in dignity. This bill is this bill is a step towards that standard, Mr. Speaker, and for that reason, it deserves to be supported. Thank you.
Resuming debate, reprise du débat, the honourable member for St. Catharines, and the member will have exactly 10 minutes before we proceed to the next matter.
That's just the right amount of time, Mr. Speaker. Thank you so much. Here, thank you. Thank you. Thank you. I rise today in strong support of Bill S228, following its careful study by the Standing Committee on Indigenous and Northern Affairs. At the outset, I want to recognize the important work of the committee. Members heard from 19 witnesses, including advocacy groups, Indigenous leaders, and legal experts. Their testimony was powerful, grounded in lived experience, and essential in ensuring that this legislation reflects the realities of those most affected and the seriousness of the harm we are addressing. Their work has reinforced the urgency of its adoption. Bill S228 addresses the reality that is both deeply troubling and, unfortunately, ongoing: the forced and coerced sterilization of Indigenous and racialized women, girls, and 2S LGBTQI persons in Canada. Survivors have come forward with accounts of being subjected to sterilization procedures without their free and informed consent, sometimes through coercion, sometimes through misinformation, and often at moments of profound vulnerability, including during childbirth or institutional care. These are not isolated incidents. They reflect a broader legacy of systemic discrimination, rooted in colonialism, racism, and deeply gendered assumptions about who is deemed fit to have children. And while some may be tempted to view this as a historical injustice confirmed to another era, the evidence heard at committee makes it clear this harm has not been relegated to the past. It persists. And that's why this bill matters. At its core, Bill S228 is a clarifying measure, but it is no less significant for that reason. It makes explicit what is already implicit in our criminal law, that sterilization procedures carried out without valid consent constitute aggravated assault. Aggravated assault is the most serious form of assault under the criminal code. It applies where a person is wounded, maimed, disfigured, or where their life is endangered. Because sterilization procedures inherently involve the alteration of the human body in a permanent and profound way, they fall squarely within the framework when performed without consent. What this bill does is remove any ambiguity. It sends a clear and unequivocal message. Non-consensual sterilization is not merely inappropriate, it is not merely unethical, it is criminal. And it is among the most serious forms of violence recognized by our law. Mr. Speaker, this bill does not create a new offense. It does not alter the law of consent, and it does not interfere with legitimate medical practice. That distinction is critical. Canada's legal framework already requires that consent be free, informed, and given by a person with the capacity to understand the nature and consequence of the medical procedure. Consent obtained through coercion, manipulation, or abuse of authority is not valid consent. Bill S228 simply clarifies how well established these principles apply in the context of sterilization procedures. It preserves the right of individuals to make their own reproductive choices, including the choice to undergo sterilization. What it protects is the integrity of that choice. Mr. Speaker, the committee's study also underscored an important reality. Despite existing legal protections, no criminal charges have been laid in Canada in cases involving alleged coerced sterilization. That fact alone raises serious concerns. Concerns about clarity, concerns about accountability, and perhaps more importantly, concerns about trust. For many survivors, particularly Indigenous women, the absence of legal consequences has contributed to a profound erosion of trust in institutions, trust in the healthcare system, in law enforcement, and the justice system itself. Bill S228 is not a complete solution to that broader challenge, but it is an important step. It provides clarity to police, to prosecutors, and to courts. It reinforces the seriousness of the offence, and it signals to survivors that Parliament has heard them. Mr. Speaker, we must recognise that the harm caused by non-consensual sterilisation extends far beyond the physical. It is a violation of bodily autonomy. It is an infringement on reproductive rights, and for Indigenous communities, it carries deep cultural and intergenerational consequences. The ability to have children is not only a personal matter, it is tied to identity, to family, and to the continuity of community. To deprive someone of that ability without their consent is to inflict harm that reverberates across generations. That's why this bill is also consistent with Canada's broader commitments, including the United Nations Declaration on the Rights of Indigenous Peoples and the National Action Plan to End Gender-Based Violence. S228 reflects a commitment to address systemic discrimination and to take concrete steps to prevent this harm from occurring in the future. Mr. Speaker, I also want to highlight the collaborative nature of this legislation. This bill was introduced in the Senate Mr. Speaker, I just want to highlight the important work done by members of this place and would like to thank the opportunity to speak in this regard. Thank you.
Resuming debate. Reprise du débat, the Honourable Minister of Northern and Arctic Affairs, and the member will have about 3.5 minutes.
Okay, thank you, Mr. Speaker. Thank you, Mr. Speaker. Right now in Ottawa, leaders, survivors, families, and frontline workers are gathering for the 3rd National Summit on Missing and Murdered Indigenous Women, Girls, 2S LGBTQ+, and they are coming together under a powerful theme, Mr. Speaker, from principles to policy, from resolution to action. And tomorrow, May 5th, is Red Dress Day. So across this country, what we're going to see are red dresses in windows and trees, on Parliament Hill, each one representing a life that was taken, a voice that was silenced, or a family that has forever changed. So this is not symbolic alone, Mr. Speaker, it's a call to action. Because the violence against Indigenous women and the violence they face is not random. It is systemic. It is rooted in policies. It is rooted in institutions and decisions, both past and present. And that is why I want to speak about Bill S228. Bill S228 is a criminal code amendment that makes something unmistakably clear. It is forced and coerced sterilization, and that is a crime. It defines sterilization without consent as an act that wounds or maims, making it prosecutable as aggravated assault. So let's be clear about what that means. It means that what happened to Indigenous women in hospitals, in medical systems, often without their full informed consent, is not just unethical, it is violence. And not historical violence. Reports have confirmed that forced coerced sterilization has continued into modern times within our own healthcare system. So when we talk about MMIWG, we must understand this. It is all connected. The National Inquiry called the crisis of missing and murdered Indigenous women and girls a genocide, not because of one issue, but because of a pattern, a system that has for generations devalued Indigenous women's lives, controlled Indigenous women's bodies, and failed to protect Indigenous women. So I wholeheartedly support Bill S228, and I thank my members for bringing this forward to the House. Thank you.
Order. Resuming debate. Reprise du débat. There is about 1.5 minutes left before we go to the next matter. Resuming debate. Reprise du débat. The Honourable Member for London West on resuming debate. A little more than a minute.
Thank you, Mr. Speaker. For the sake of utilizing our time correctly and talking about the importance of Bill C-228, I want to build on what my colleague was talking about, the importance of making sure that women across Canada have the opportunity to be consulted when they need to make decisions about how their family planning. Obviously, this issue is an issue that's affected women in Canada, Indigenous women disproportionately, Black women. And I also want to take this opportunity, Mr. Speaker, to talk about the fact that tomorrow is Red Dress Day, a day that addresses an important day for Indigenous women, where we remember the missing and murdered Indigenous women across Canada. This is an opportunity for everyone in Canada to be aware of the issues that are within the Indigenous communities, within the issues that affect disproportionately Indigenous women. So, Mr. Speaker, as I use my time, I don't have a lot of time left, and also people with disabilities as well. Thank you to my colleague for making sure that important comment is made. Sterilization affects disproportionately marginalized women, women that people think nobody's going to look for them. No, they don't have the support system.
I'm afraid I do have to interrupt the honourable member. She will have about 9 minutes left the next time the House considers this matter. Order à l'ordre. La période prévue pour l'étude des affaires émanant des députés.
The time for private members' business is expired and will be at the bottom of the order paper.
Government House Leader on a point of order.
Speaker, I move, seconded by the Minister of National Defence, that in relation to Bill C-11, an act to amend the National Defence Act and other acts, not more than one further sitting day shall be allotted to the consideration of the report stage, and not more than one sitting day shall be allotted to the consideration of the third reading stage of the said bill, and that 15 minutes before the expiry of the time provided for government orders on the day allotted to the consideration at report stage and on the day allotted to the consideration at the third reading stage of the said bill, any proceedings before this House shall be interrupted if required for the purpose of this order, and in turn every question necessary for the disposal of the stage of the bill then under consideration shall be put forthwith and successively without further debate or amendment.
Order. Order. Mr. McKinnon-Gatineau, seconded by Mr. McGuinty, moves that in relation to Bill C-11, an act to amend the National Defence Act and other acts, not more than one further sitting day shall be allotted to the consideration of the report stage, and not more than one sitting day shall be allotted to the consideration of the third reading stage of said bill, and that 15 minutes before the expiry of the time provided for government orders on the day allotted to the consideration at report stage, and on the date allotted at the consideration at the report's third reading stage of said bill, any proceedings before the House shall be interrupted if required for the purpose of this order, and in turn every question necessary for the disposal of the stage of the bill then under consideration shall be put forthwith and successively without further debate or amendment. Order. Pursuant to Standing Order 67.1, there will now be a 30-minute question period. Members will recall that the preference for questions during the 30 minutes is provided to the opposition, but not to the exclusion of some members on the government side. Members should keep their interventions to a brief, and they may speak more than once. I now invite honourable members who wish to ask questions to rise or to raise their hands function so this chair can have some idea of the number of members who wish to participate. Order. There's two questions. Questions and comments. The order. Questions and comments. I'm a member for Selkirk, Interlake, Eastman.
Well, thank you, Mr. Speaker. And you know, it's disgusting to see that the government actually using closure to shut down debate on such a serious issue of sexual misconduct within the Canadian Armed Forces. It's disgusting that they are taking away the voice of veterans, of people that are surviving military sexual trauma, and not listening to them in the amendments that they're bringing forward on Bill C-11. I don't know why the government is in a hurry on this when we brought it through committee in a relatively organized manner, that we had cross-party support of the Bloc, the Conservatives, and the NDP to make amendments based upon the testimony that we heard at committee. And now the government wants to ignore all that, shut down debate, and use their sneaky majority to stifle democracy right here. Why is the minister ignoring veterans and survivors of military sexual trauma to make sure that they have a choice of what justice system that they want to use, whether it is the military justice system or the civilian system?
The Honourable Minister of National Defence.
Thank you, Mr. Speaker. Let me begin by thanking you and thanking my colleagues for being here to debate this important issue. I would remind the member across the hall that for 10 years, Mr. Harper did nothing about this issue. They did not bring a single proposed legislative amendment or change to the whole question of this regime. So what we've decided, Mr. Speaker, is that delivering culture change is not only the right thing to do, but it's critical for our operational needs for national security. It's not a partisan issue. As hard as he would like to make it so, my colleague does not recall that we introduced C11 to codify in law key recommendations from two distinguished judges of the Supreme Court, Justices Arbour and Fitch, and to rebuild victims' and survivors' trust in the Canadian Armed Forces, Mr. Speaker. Most importantly, Justice Arbour's fifth recommendation calls for the removal of Canadian Armed Forces jurisdiction to investigate and prosecute criminal code sexual offences. So through Bill C11, we are implementing this recommendation exactly as we promised. What we heard from former Supreme Court Justices Fish and Arbour, and from the Chief of the Defence Staff, from military justice experts, from victims and survivors, is that these changes are long overdue.
Questions and comments? The honourable member for Newtown-South Gwillimbury.
Well, thank you, Mr. Speaker. And I'm looking at this bill now, and I'd like to know why this Liberal government is prioritizing speed over getting this legislation right for veterans and survivors. I mean, this government had 10 years to do something. 10 years, Mr. Speaker. And now we see them again moving for closure. If the minister could comment, please.
Honourable Minister of National Defence.
Mr. Speaker, it's interesting. We went through a process in committee, an important process. I appeared on this bill. And unfortunately, almost virtually every substantive amendment put forward by the opposition parties has been ruled out of order by the Speaker's office, by the Speaker. So as a result of that, we're in the position now where we are basically moving forward. There's a lot at stake here for the women and men of the Canadian Armed Forces, Mr. Speaker. The discussions around political interference, it's unfortunate talk. The important thing here is that we are going to be making changes to address long-standing concerns raised by victims and survivors of the Canadian Armed Forces community. It's a suite of targeted amendments to modernize the military justice system.
Question et commentaire.
The honourable member for Rimouski, la Matépédia. Mr. Speaker, in Bill C11, we're having an obvious example of a lack of leadership from the Liberal government. They've been in power for 10 years. A majority, in fact, from 2015 to 2019. They waited for a public scandal to reform the military justice system. The Arbour report shows that the system simply wasn't protecting victims. One question, why wait for a public scandal before taking action? The Honourable Minister. Mr. Speaker, it is a bill that we brought before the House of Commons once again. It went through the legislative process, the ordinary, regular process, and Madame Arbour herself predicted it would take a number of years to bring about these fundamental changes, and that's where we're at today. The member knows this full well. He's aware. We would like to move forward today.
Commentary, the honourable member for Sandwich Gulf Islands.
Thank you, Speaker. And as we're now debating not C11 itself, but time allocation, I'd like to remind my honourable friend, the Minister of Defence, and cast his mind back to when the Liberals were the third party in the House and the Harper Conservatives used time allocation over and over again. And those of us in those days back in this corner would say frequently that we don't need time allocation. We should properly debate and routine use of time allocation is anti-democratic. I hold to that view, no matter who's holding the reins of power. It's anti-democratic to shut down debate early, and that's why I'll be voting no to time allocation. I do support pursuing Madam Justice Arbour's recommendations, but I don't like being bulldozed.
The Honourable Minister of National Defence.
Mr. Speaker, it gives me an opportunity to talk a little bit more about what's in the bill. We'll be codifying in law that the Canadian Armed Forces no longer have jurisdiction over criminal code sexual offences committed in Canada. We're codifying in law that civilian authorities have exclusive jurisdiction for investigating and prosecuting these criminal code sexual offences committed in Canada. We'll be establishing a victim liaison officer to be provided to victims throughout the transfer of cases, regardless of jurisdiction. We'll be elevating the role of key justice actors to increase their independence. And some other fundamental changes, Mr. Speaker, which I know my colleague as a lawyer understands will be important in order to strengthen not only that justice be seen to be done, but it actually be done.
Questions and comments, the member for Provencher.
Thank you, Mr. Speaker. And You know, it sure didn't take long for these Liberals to show their true character. Time allocation, closure motions, like this is the kind of stuff that you do when you want to ram things through without proper debate. I know my constituents expect me to come here and to thoroughly debate every single piece of legislation so that every avenue has been explored and every rabbit hole has gone down, that we know that what we're ending up with is a product that we can all be pleased with. And I think the justice system needs to be modernized. That's become clear at committee. And I think it would be prudent for us to make sure that we listen to the survivors and victims of the sexual abuse that has happened in our military, to make sure that this act really represents the justice that they deserve. And my question would be to the minister that's going to be responding: has he personally met with any of the victims or survivors of sexual abuse in the military?
The Honourable Minister of National Defence.
Mr. Speaker, Justices Arbour and Fish conducted extensive outreach and consultations with victims, survivors, members of the Canadian Armed Forces, their families, military justice experts, and constitutional experts to get this right. In fact, the Chief of the Defence Staff, General Jenny Carignan, in her previous role as Chief of Personnel and Professional Conduct, also undertook extensive consultations, Mr. Speaker, with over 14,000 individuals. What Justice Arbour, Fish, and the Chief of Defence Staff heard and revealed in the reports: there's a lack of trust in the military justice system, caused in large part due to instances of real and perceived interference from the chain of command into sexual misconduct matters.
Comments. Honourable Parliamentary Secretary, the Government House Leader.
Thank you, Mr. Speaker. I think it's really important for us to recognize that it was the former Supreme Court Justice Arbour who put in a great deal of effort, literally consulted and worked and listened to hundreds, if not thousands, of direct or indirect opinions on the issue. The core of the issue is to transfer from the military into the civilian. This is something that's been on works now for a while. There has been all sorts of debates and discussion, whether it's second reading, standing committee, and there are those that are inside the chamber that would never see this legislation pass. My question to the minister is, does he not agree the principle of what the legislation is being supported in such a way that the legislation needs to pass the House of Commons?
The Honourable Minister of National Defence.
Mr. Speaker, after a year-long review of DND and CAF, Justice Arbour said this: the handling of sexual misconduct by military justice has eroded trust and morale among the organization. She recommended in recommendation number 5 that the civilian system be given exclusive jurisdiction. We agree. Bill C-11 addresses her recommendation number 5, that criminal code sexual offences alleged against CAF members in Canada should be investigated and prosecuted exclusively in the civilian system. Military justice experts tell us that this will provide greater legal clarity, greater legal certainty to all actors in the justice system, and better serve victims and survivors. My colleague is right. We've got to get this done on behalf of the women and men of the Canadian Armed Forces.
Questions and comments. Member Fort McMurray, Cold Lake.
Thank you, Mr. Speaker. We are just over a week into the Liberals' sneaky majority that they got through backdoor deals, and this is the piece of legislation that they've decided they are going to ram through, curtail debate. And what is this piece of legislation we're talking about? This is a piece of legislation about sexual assault, about listening to our veterans, and they're choosing to put political expediency ahead of the needs of victims, our veterans, or even listening to our military members. This is all part of the course. We've seen this. I've seen this in Cold Lake at Four Wing. We still don't have an answer as to when we're going to get all 88 of the F-35s in, because they don't seem to care. And this is just a pattern of abuse from this government of not putting veterans and our armed force members first. So the question is simple. Will they admit that they're wrong on this and let the debate continue?
For National Defence.
Mr. Speaker, I've had the chance to visit Cold Lake. This member has voted against every military investment, including $4 billion in that actual base. She's had a chance, Mr. Speaker. Bill C-11 has bolsters trust in the military justice system by providing, as I said, legal clarity. As recommended by Justice Arbour, it enhances the independence of key military justice actors, as recommended by former Justice Fish. For example, by elevating positions of key military justice actors to governor and council appointees, we are insulating them, Mr. Speaker, from real or perceived influence from the chain of command. The brave women and men of the Canadian Armed Forces are always there to keep Canada safe. It's our obligation, all of us in this House, to keep them safe from harassment and misconduct.
Questions and comments. The member for Cambridge.
Mr. Speaker, today Parliament opened up with the words freedom, opportunity and peace, something we all get to enjoy. Well, we're enjoying that because of the veterans and those who continue to fight for us, to protect all Canadians. And now they're asking for us to help them, to protect them, to speak on behalf of their voices. Why is this government shutting down their voices and shutting down and closing debate with their manufactured majority?
Minister of National Defence.
As I mentioned a moment ago, and I'll repeat it for the members' benefit, Mr. Speaker, this is entirely about trust. It's about trust for the women and men in our armed forces today to know that when it comes to criminal code sexual offences, they will be prosecuted, they will be investigated on the outside of the Department and the Canadian Armed Forces. In fact, Mr. Speaker, that has been the case since the fall of 2021. The member may not be aware, every new case has been referred to the civilian courts since the fall of 2021. So as a result, Mr. Speaker, we're seeing progress, trust is enhanced, and when we formalize this, it will give us more clarity and more certainty.
Question et commentaire. La députée.
The honourable member for Rimouski-Matapédia. Thank you, Mr. Speaker. The government is transferring sex offence cases through the civil courts, so outside of the military court system. But the problem is the government is having a hard time getting the justice system operational, even appointing judges. There's five missing judges in Quebec and many others in the rest of Canada. People need justice to be served. That's why the federal government needs to do its job, appoint judges. Will the government commit to appointing these judges as soon as possible and to provide the resources to the system, not simply to pass off the responsibility to someone else? The Honourable Minister. The member is raising an important question, Mr. Speaker. We are aware of the fact that transfer of sexual offence cases from the military justice system to the civilian side system is a complex process, and this is precisely why we are signing memorandums of agreement with the provinces to make sure that they have the means they need to deal with this additional caseload. We've already signed a memorandum of agreement with the province of Ontario, Mr. Speaker. It's fruitful, and the work is ongoing with other provinces.
Blake Eastman.
Mr. Speaker, the Minister of Defence admitted at committee that he took old Bill C-66 and brought it back in this Parliament, Bill C-11. He never talked to anybody in the veterans community. He didn't reach out and talk to members in the justice system within CAF. He never talked to anyone at the provincial level about the problems that they're having in carrying on these prosecutions. If he had listened to veterans and read the testimony that appeared at committee, they would have told you that they don't have faith in the civilian system, especially on low-level sexual misconduct, that they're going to be dismissed, and then there's no recourse within the military system on any sort of administrative or disciplinary measures against those offenders. If he had been listening, he would have heard from police stations and police organizations across this country, as well as lawyers, saying give victims the choice so that they can choose which system they believe they're most comfortable in, whether it was the military system or the civilian system. And if he had listened to his own members of the Canadian Armed Forces, like the Director of Military Prosecutions, like the Director of Defence Counsel Services, like the Provost Marshal General of the Canadian Armed Forces, they would have told you that they are all now in a better place 5 years since the Arbour report to actually bring in the changes that are needed to do what's right.
Honourable Minister of National Defence.
Except the member omits to tell the Canadian people watching this debate that as of the fall of 2021, All of these cases have been sent to civilian courts. So he can't have it both ways, Mr. Speaker. There has been important progress and tangible changes since 2021. This is precisely because the interim directive that put Justice Arbour's Recommendation 5 into place in a temporary manner until such time as legislation can be passed through the House continues. Work on cultural evolution inside the CAF has continued. We have now implemented 47 of Justice Arbour's 48 recommendations. To block Arbour recommendation number 5, Mr. Speaker, would be to undo the progress of the past 5 years. We don't have the intention of doing that. I think the member knows this is the right way to proceed. I put my trust in the work of Madame Justice Arbour, Mr. Justice Fish, and for that matter, the Chief of the Defence Staff.
Questions and comments. Question et commentaire. L'honorable député de Repentigny.
The honourable member for Repentigny. Mr. Speaker, there's a certain arrogance on the part of the government here. And I think that needs to be said. The Liberals removed a number of amendments, important amendments that the committee worked on. And now that they have this floor-crossing majority, the government has decided to completely brush aside the hard work of the committee. But we had a general election that led to a minority government. Now, because of the floor crossers, this government is trying to do whatever it wants, and it's ignoring the will of the public, which gave them a minority mandate, a mandate to work together. I do not understand why the government does not respect the idea that we need to work together, why it doesn't respect the work of the committee. So my question is simple. Can the government explain why it does not respect the work of parliamentarians at committee, elected parliamentarians who represent the public? Just because it has floor crossers that it used for a majority doesn't represent all points of view. And in a democracy, you want to bring voices in, but instead now it's excluding them.
De la Défense nationale.
The Honourable Minister of National Defence. Well, Mr. Speaker, a large majority of those amendments were considered not in order by the Speaker of the House of Commons. So this is not exactly useful. We have made progress to create cultural change. Over the past years, 47 out of 48 of the Arbour recommendations were applied. This bill seeks to apply transformative measures, ensuring that sexual offenses are transferred to the civilian system. This bill also implements the main recommendations of Justice Fish in order to strengthen the military justice system. This is the right time to move forward, Mr. Speaker.
North.
Thank you, Mr. Speaker. You know, I think it's important to recognize as a minister how it is that we've enhanced our military. Whether it's increasing the budget now to 2% of the GDP, whether it's providing support for members of CAF. I'm thinking in terms just recently the minister had the announcement of 7,000 plus new individual applicants to join the forces. It's all about credibility. You take a look at the legislation as the minister sees the value of bringing forward the legislation, and I'm disappointed that the Conservative Party of Canada is now in opposition to it. You know, it's interesting, 2 weeks ago I didn't hear them crying about it or saying that they were going to oppose the legislation. It's coming back into the House, and now they've taken a position, ultimately with full intentions on debating it endlessly so it doesn't pass. My question to the minister is, think in terms of the continuity, reinforcing confidence in the forces, and this is one of the reasons why.
The Minister of National Defence.
Mr. Speaker, we made a decision. We're going to be rebuilding, rearming, and reinvesting in the Canadian Armed Forces. Inherent in that rebuilding, rearming, and reinvesting is the important question of bolstering trust. Trust in the military justice system by providing legal clarity as recommended by Justice Arbour, and by enhancing the independence of key military justice actors, as recommended by former Justice Fish. We're moving forward, but the member makes an important point. The Canadian Armed Forces and all the work that we're doing there begins with our people. We need to make sure they can work at a safe transparent, robust workplace. And if there are challenges, members of the armed forces need to know that the legal system that's there to protect them will in fact work. Thank you, Mr. Speaker.
Questions and comments? Question commentary. The member for Chatham-Kent, Leamington.
Thank you, Mr. Speaker. The Prime Minister went to the Canadian people and said that he was going to move at speeds unseen in generations. We thought that was all for major projects, and that's what we've not seen. But now what we're seeing is speed moving and steamrolling over committees, over the cooperative work of this House. Is that what the Prime Minister meant by speeds moved or unseen in generations, ignoring the will of this House through their committee network?
The Honourable Minister of National Defence.
No, Mr. Speaker, that's not what he meant. What he meant was we would achieve 2% of our GDP spend in 10 months. We would get our members of the Canadian Armed Forces a significant pay raise in less than 6 months. We would increase recruitment by 61% year over year. We would be making billions of dollars of investments in our 33 bases. We would extend our presence in Latvia for 3 more years with 3,000 members in a forward operating location. We would announce $40 billion for investments in the Arctic, including for northern operational support hubs. Mr. Speaker, we're moving at breakneck speed, but the problem is, in every one of those cases, the opposition has opposed.
Questions and comments? Question commentary. Député de Repentigny.
The honourable member for Repentigny. Mr. Speaker, I mentioned this earlier. There is a new dynamic, a new arrogance on the part of the government. We are currently at committee, and no matter what we ask, we don't get answers. There is a new government that has become a majority with floor crossers, including an NDP floor crosser. They've obtained a majority. But that member, among others, was one of the parliamentarians who worked on these amendments. And some of these amendments were very constructive and improved the legislation. But the Liberals, without any good reason for it, got rid of a number of those amendments simply because they think they can do whatever they want now, and because they don't respect the will of the people who elected us, who we represent, and who want us to work together. I'd like the government to explain why it doesn't want to respect the will of the committee and all the work that was done by consensus at committee in order to improve the legislation. The Honourable Minister of National Defence. Mr. Speaker, creating cultural change is not only the right thing to do, it is also essential for our operational needs. This is not a partisan matter, and my colleague knows that. We presented Bill C-11 in order to enshrine in law the main recommendations of Justices Arbour and Fish, and in order to increase the confidence that victims and survivors can have in the Canadian Armed Forces. The 5th Arbour recommendation recommends that we remove jurisdiction over the prosecution of sexual offenses from the military justice system. And that's exactly what we're doing here. And we hope that our colleague will support us.
My commentary, the member for Hastings, Lennox and Addington, Tyann Denega.
Mr. Speaker, I'm a little bit confused. At committee, there was a number of different veterans that spoke and shared their heart-wrenching stories, and we heard time over time the importance of survivors wanting choice. Right at committee, the Minister of Defence said of the members of the Canadian Armed Forces that we have to be able to look them in the eye and tell them that we have a well-run and transparent system and that they can trust to help them when problems arise. Mr. Speaker, how is denying survivors choice and forcing them into an overburdened civilian system that doesn't understand the realities of military service compatible with the Minister's promise of a transparent, well-run system that they can trust?
Of National Defence.
Mr. Speaker, we're taking our lead from Madam Justice Arbour, one of our most distinguished Supreme Court of Canada justices. But here's really what's at stake here. Victims and survivors deserve legal clarity, transparency, and trust in the process. Justice Arbour herself called a victim's choice between military and civilian courts, quote, a false choice. This is because we would be placing a burden on a victim in a time of high stress, trauma, and in fact duress to choose between two unequal options. Asking victims and survivors to choose between two unequal options, one of which has the potential for chain of command interference in a criminal code case, does not provide victims with clarity, transparency, or certainty, Mr. Speaker.
Question commentaire, l'honorable député de Mirabel.
The honourable member for Mirabel. Mr. Speaker, we have a government that was elected as a minority. Then it bought a majority through floor crossing. It is demolishing the work that is democratically done at committee. And today it is using its bought majority for a gag order. But that's not the worst thing. We have a minister who's rising in this House and who just keeps repeating his talking points. And he can't seem to answer our questions without just reading the talking points that were written by his officials. I'd like him to get up, leave his piece of paper on the table, and tell us what's really happening. The Honourable Minister. Maybe I should repeat this from my colleague in French. Victims and survivors deserve transparency, legal clarity, and trust in the process. Justice Arbour herself stated that the choice between military and civilian tribunals was a false choice. And indeed, at a time when victims are experiencing stress and trauma, it places on the victims the difficulty of choosing between two unequal choices. It places on victims the burden of having to choose between these two unequal choices. And additionally, there are issues in the chain of command. This does not help victims.
About 45 seconds.
Thank you, Mr. Speaker. And again, another truly sad day for our democracy, our democratic institutions. The decline in democracy is continuing with this Liberal government. I know the Defence Minister keeps referencing the Arbour report. That was almost 7 years ago that report was actually established, and only 5 years ago did the government start implementing any of the recommendations in the report. This despite the fact that 7 years later, things have changed significantly. We had CAF members, stakeholders, veterans, all come to committee and talk about this, and yet this government continues to ignore the voices of those people who know better than government what type of system should be in place, and they're gutting every committee recommendation. Isn't it true that the government only wants an audience, not an opposition?
The Honourable Minister of National Defence, about 35 seconds.
Thank you, Mr. Speaker. Maybe in conclusion, I could remind the member. The Chief of Defence Staff in her previous position spoke to 14,000 individuals. I'm not sure where he's driving his numbers from. And as a result of that as well, Madam Justice Arbour actually conducted one of the deepest commissions of inquiry in this whole area. So the member knows better than to hurl this kind of invective of abuse. It's really not, it's not like him. It's not like him, Mr. Speaker. So as a result of that, I think what we should do is remind ourselves, this is about enhancing trust. Enhancing trust. That's what Bill C-11 will do, and that's why we're moving forward, Mr. Speaker.
Order à l'ordre. Il est de mon devoir d'interrompre maintenant le délibération.
It is my duty to interrupt the proceedings at this time and put forth with the question on the motion now before the House. The question is as follows.
No, seconded by Mr. McGuinty, move that, in relation to Bill C-11, an act to amend the National Defence Act and other acts, not more than one further... Shall I dispense? I guess not. Not more than one further sitting day shall be allotted to the consideration at report stage of the bill, and not more than one sitting day shall be allotted to the consideration at third reading stage of the said bill, and that 15 minutes before the expiry of the time provided for government orders on the day allotted to the consideration at report stage and on the day allotted to the consideration at third reading stage of the said bill, any proceedings before the House shall be interrupted if required for the purpose of this order, and in turn every question necessary for the disposal of the stage of the bill then under consideration shall be put forthwith and successively without further debate or amendment. If a member participating in person wishes that the motion be carried or carried on division, or if a member of a recognized party participating in person wishes to request a recorded division, I would invite them to rise and indicate to the chair. The honourable member for Selkirk, Interlake, Eastman.
Mr. Chair, we'd like to have a recorded division.
Call in the members. Convoquez les députés.
La question est la suivante, Monsieur.
Mr. McKinnon, Gatineau.
Loi modifiant la loi.
With respect to Bill C-11, one additional day be granted. May I dispense?
OK. La période de 10 minutes pour les députés votant par.
The voting period for members voting remotely has begun. We will start with individuals in the room. All those in favor of the motion, please rise.
Monsieur McKinnon Gatineau.
Mr. Ali.
Mr. Ali.
Madame Diab.
Madame Diab.
Mr. McDonald Malpeck.
Mr. McDonald Malpeck.
Mr. McGinty.
Mr. McGinty.
Mr. Hodgson.
Mr. Hodgson.
Madame Michel.
Madame Michel.
Mr. Fraser.
Mr. Fraser.
Mr. Solomon.
Mr. Solomon.
Mrs. Valdez.
Mrs. Valdez.
Madame Petitpas-Taylor.
Madame Petitpas-Taylor.
Ms. Chagger.
Ms. Chagger.
Mr. Guilbeault.
Monsieur Guilbeault. Ms. Jazik.
Mr. Fragascados.
Mr. Fragascados.
Ms. Gainey.
Ms. Gainey.
Madame Provo.
Madame Provo.
Mr. Belanger, Desnathan, Mississippi, Churchill River.
Mr. Belanger, Dessanethe, Mississippi, Churchill River.
Ms.
Chartrand.
Ms. Chartrand.
Ms. Chartrand.
Mr. Gerritsen.
Mr. Gerritsen.
Madame Chenette.
Madame Chenette.
Mr. Nur Mohammed.
Mr. Nur Mohammed.
Mr. Biddle.
Mr. Biddle.
Mr. Lewis Kitchener-Conestoga.
Mr. Lewis
Mr.
Kitchener-Conestoga.
Grant.
Mr. Grant.
Mr. Leitao.
Mr. Leitao.
Mr. Bardisi.
Mr. Bardisi.
Madame Kayabaga.
Madame Kayabaga.
Mr. Lamoureux.
Mr. Lamoureux.
Mr. Kellaway.
Mr. Kellaway.
Mr. Hogan.
Mr. Hogan.
Ms. Chi.
Ms. Chi.
Mr. Miles.
Mr. Miles.
Mr. El Khoury.
Mr. El Khoury.
Mr. Fergus.
Monsieur Fergus.
Ms. Suggs.
Ms. Suds.
Madame Desrochers.
Madame Desrochers.
Mr. Gasparo.
Mr. Gasparo.
Madame Fortier.
Madame Fortier.
Mr. Clausen.
Mr. Clausen.
Ms. Church.
Ms. Church.
Mr. McKinnon, Coquitlam, Port Coquitlam.
Mr. McKinnon, Coquitlam, Port Coquitlam.
Mr. Schiefke.
Mr. Schiefke.
Ms. Vandenberg.
Ms. Vandenbelt.
Mrs. Zaid.
Mrs. Zaid. Ms. Yip.
Madame Lapointe, Rivière des Mille-Îles.
Madame Lapointe, Rivière de Mille-Îles.
Ms. Idlout.
Miss Idlout.
Madame Lapointe, Sudbury.
Madame Lapointe, Sudbury.
Mr. Sousa.
Mr. Sousa.
Ms. Akan.
Ms. Akan.
Mr. Al Saoud.
Mr. Al Saoud.
Mr. Clark.
Mr. Clark.
Mr. Connors.
Mr. Connors.
Mr. Danko.
Mr. Danko.
Mr. Deschênes-Thériault.
Mr. Deschênes-Thériault.
Mr. Earl.
Mr. Earl.
Ms. Fancy.
Miss Fancy.
Mr. Fanjoy.
Mr. Fanjoy.
Ms. Harrison.
Miss Harrison.
Mr. Joseph.
Monsieur Joseph.
Mr. Lavoie.
Monsieur Lavoie.
Mr. McKinnon.
McDonald.
McDonald
Cardigan. Mr. McDonald Cardigan.
Mr. Malat Bay of Quinty.
Mr. Millet Bay of Quinty.
Ms. Miedema.
Ms. Miedema.
Madame Mingarelli.
Madame Mangarelli.
Ms. Nathan.
Ms. Nathan.
Ms. Wien.
Ms. Wien.
Mr. Tumba.
Mr. Tumba.
Ms. O'Rourke.
Ms. O'Rourke.
Mr. Saini.
Mr. Saini.
Mr. Sahi.
Mr. Sari.
Mr. Sawatsky.
Mr. Sawatsky.
Ms. Sodi.
Ms. Sodi.
Ms. Tessa Dirksen.
Ms. Tesser Dirksen.
Mr. Villeneuve.
Mr. Villeneuve.
Mr. Watchorn.
Mr. Watchorn.
Ms. Begum.
Ms. Begum.
Ms. Martin.
Ms. Martin.
Que tous ceux.
All those opposed to the motion will please rise.
Mr. Schmale.
Mr. Schmale.
Mr. Bazan.
Mr. Bazan.
Mr. Deltel.
Mr. Deltel.
Mr. Paulus.
Mr. Paulus.
Ms. Landsman.
Ms. Landsman.
Mr. Chong.
Mr. Chong.
Mr. Seaback.
Mr. Seaback.
Mr. Albus.
Mr. Albus.
Mr. Caputo.
Mr. Caputo.
Mr. Small.
Mr. Small.
Mr. Moore.
Mr. Moore.
Mr. Workington.
Mr. Workington.
Mrs. Cramp Nyman.
Mrs. Cramp Nyman.
Mr. Cooper.
Mr. Cooper.
Mr. Lloyd.
Mr. Lloyd.
Mr. Van Popta.
Mr. Van Popta.
Mr. Kelly.
Mr. Kelly.
Mr. Généreux.
Mr. Généreux.
Mr. Gould.
Mr. Gould.
Mr. Zimmer.
Mr. Zimmer.
Mr. Davidson.
Mr. Davidson.
Mr. Muse.
Mr. Muse.
Mrs. Cramp. Mr. Ho.
Mr. Ho.
Mrs. Cramp Nyman.
No, Mrs. Goodrich.
Mrs. Goodrich, pardon me.
Mrs. Goodrich.
Mr. Moore. Mr. Davidson.
Morrison.
Morrison.
Mr. Morrison.
Mr. Arnold.
Mr. Arnold.
Mrs. Gallant.
Mrs. Gallant.
Mr. Diot.
Mr. Diot.
Mr. Williamson.
Mr. Williamson.
Mr. Falk-Provencher.
Mr. Falk-Provencher.
Mr. Macaulay.
Mr. Macaulay.
Mr. Menegakis.
Mr. Menegakis.
Mr. Motz.
Mr. Motz.
Mr. Dalton.
Mr. Dalton.
Mr. Dowdle.
Mr. Dowdle.
Mr. Cram.
Mr. Cram.
Mr. Patzer.
Mr. Patzer.
Mr. Groslo.
Mr. Groslo.
Mrs. Anstey.
Mrs. Anstey.
Mr. Bexty.
Mr. Bexty.
Mr. Bonk.
Mr. Bonk.
Mrs. Cody.
Mrs. Cody.
Mr. Davies, Niagara South.
Mr. Davies, Niagara South.
Mr. Gill, Calgary Skyview.
Mr. Gill, Calgary Skyview.
Mr. Gill, Windsor West.
Mr. Gill, Windsor West.
Mr. Gunn.
Mr. Gunn.
Mr. Holman.
Mr. Holman.
Mr. Jackson.
Mr. Jackson.
Ms. Kirkland.
Ms. Kirkland.
Ms. Conans.
Ms. Conans.
Pardon me, Ms. Cronus.
Ms. Cronus.
Mr. Mantle.
Mr. Mantle.
Mr. McKenzie.
Mr. McKenzie.
Madame Normandin.
Madame Normandin.
Monsieur Bonnet.
Monsieur Bonnet.
Monsieur Savard-Tremblay.
Monsieur Savard-Tremblay.
Monsieur Blanchet-Jonca.
Monsieur Blanchet-Jonca.
Monsieur Lemire.
Monsieur Lemire.
Ms. May.
Ms. May.
Is we done here? La Chambre attendra maintenant la fin de la période de vote électronique avant de poursuivre.
The House will now wait for the electronic voting period to end before resuming its proceedings.
Je désire informer la Chambre que la période de
I wish to inform the House that the electronic voting period has ended. If members were unable to vote due to technical issues, they may raise their hand, and the Speaker will recognize them. I see no hand raised.
Oui, yes, honourable
I have
member.
technical difficulties, and I would like to record my vote as nay.
Ms. Corbina, nay contre.
I'm told that there is a technical issue involving the vote, so we will just wait it out.
Until you have a majority isn't a technical issue.
We'll have to take a few moments to get things straightened out, but we'll be back. Whip.
You may find unanimous consent to allow for members to leave and allow for the table and the speaker to resolve the outcome of the vote with members allowed to leave the chamber.
All those opposed to the honourable member moving the motion will please say nay. Agreed. The House has heard the terms of the motion. All those opposed to the motion will please say nay. Carried. The Honourable Chief Opposition Whip.
Thank you, Mr. Speaker. I think as the table is working feverishly to complete the vote count, we believe that all members have been accounted for that made attempts on the app to vote from our side, with the exception of the member from Carlton Trail Eagle Creek. We'd ask for unanimous consent to allow for that member's vote to count and be included in the vote.
All those opposed to the honourable member moving the motion will please say nay. Agreed. The House has heard the terms of the motion. All those opposed to the motion will please say nay. Carried. So just pro forma, if members were not able to vote due to technical difficulties, they may now use the raise hand function and the chair will recognize them. I don't see any hands raised. The table will now compile the results of the vote.
Yeas pour 169, 169. Nays contre 164, 164.
I declare the motion carried. Order.
Government Orders, Government Bills Commons, resuming debate at report stage of Bill C-11, Military Justice System Modernization Act, and on the motions in Group Number 1.
I wish to inform the House that because of the proceedings on time allocation motion, government orders will be extended by 30 minutes. The honourable member for Calgary, Crowfoot.
Thank you, Mr. Speaker. So sexual misconduct in the armed forces is a known, long-standing problem. It was known during the previous Conservative government, and the previous Conservative government received the Deschamps report, which recommended changes, some of which required legislation, in March of 2015. So the report was tabled, Mr. Speaker, and its recommendations are accepted just before the 2015 election. And if Conservatives had been re-elected in 2015, the legislative changes necessary to address investigations and prosecutions into sexual misconduct would have been taken care of 10 years ago, Mr. Speaker. But that's not how it turned out. The Liberals won the 2015 election, and during the entire 42nd Parliament, Mr. Speaker, the Liberals did absolutely nothing. They made literally zero effort to pass the legislation necessary between 2015 and 2019. But during the 42nd Parliament, I mean, we got to go through this, Mr. Speaker, to really figure out how we got here, where they're time allocating this bill today in 2026. During the 42nd Parliament, the Liberals' main contribution to the issue of sexual misconduct was to cover up for it. That's what it did when it touched the highest levels of the chain of command. Some will remember that Defense Minister Harjit Sajjan helped cover up known sexual misconduct by the then Chief of Defense Staff, Jonathan Vance, and along with some help from the Trudeau PMO. So after the next election in the 43rd Parliament, they still did absolutely nothing to implement the Deschamps report. They let new reports pile up, like the Fish report and the Arbour report, while a succession of senior officers continued to be publicly accused of sexual harassment. A third election in, they finally got around to tabling an earlier version of this bill in the spring of 2023. That was 8 years after the Deschamps report, and then they made almost no effort to move the bill in the House. It sat there collecting dust on the order paper for a whole year before receiving, I believe it was exactly 1 day of debate in the spring of 2024. Now, some are going to remember what the Liberals did in the fall of 2024. They sacrificed their entire legislative agenda in defiance of 2 orders of Parliament. They willingly did so rather than comply with rulings from the Speaker, finding prima facie evidence of contempt of Parliament related to the corruption of the Green Slush Fund and lies told about disgraced Minister Randy Boissonnault at committee and his conflicts of interest. That lost legislative session ended in the implosion of the Liberal cabinet, the resignation of the Prime Minister, the prorogation of Parliament, and it ended the Liberals' attempt, their first attempt, to legislate the changes recommended by Justice Deschamps. So Conservatives have always and continue to support the recommendations contained in the Deschamps report. We agreed with the recommendations when we were in government, and Conservatives agreed with them in opposition during the 42nd Parliament, the 43rd Parliament, the 44th Parliament, and now in the 45th Parliament. So, when the Liberals finally called this bill, they called C-11 last December on a Friday, Conservatives allowed it to pass at second reading without even 1 full day of debate. And so now we have the amendments. The amendments we're debating was the result of the Defense Committee's work earlier this year. The Defense Committee heard brave, courageous testimony from victims of sexual assault, abuse, and harassment within the armed forces. They heard traumatic, harrowing experiences. And this testimony that was heard at the Defense Committee was given serious consideration. If the appropriate jurisdiction of investigations and prosecution is not a simple question. And it's true that Justice Arbour recommended all cases being referred to the civilian system. But it is also true that many victims expressed a variety of concerns about access to justice within the civilian system. That's why Conservatives, Bloc MPs, and even the NDP all recommended that the best way to give victims their best shot at receiving justice is to allow the victim to choose which system makes the most sense in their particular case. So the simplicity of this recommendation speaks for itself. Nobody in all of the inquiries, and there have been other inquiries and studies done at the Defense Committee, none of the inquiries, the studies, the parliamentary reports disagree that there are barriers to justice within a system where the victim and the accused are part of the same chain of command. Nobody is disputing this. But as was pointed out by witnesses during the committee's study, the civilian system is also riddled with barriers to justice for victims. Official languages is an issue. If a member can't get service in the official language of their choice in the provincial system of where they are stationed. Delay is another one, Mr. Speaker. So that's why the committee recommended choice. It is not forcing anybody to have their case studied within the military system. It is giving choice. So this committee study, during this study, no party had a majority. All the MPs worked together, regardless of their party affiliation. There were many amendments proposed, and there was very powerful and compelling testimony that drove these amendments. And so that's what Parliament is all about. Hear from the witnesses at committee and work together to recommend improvement to the legislation. That's good opposition politics. That's good government party politics. But we know that now everything has changed. The Liberals have a majority, and they've already demonstrated the contempt that they hold with which they hold opposition MPs and ideas other than their own. In their arrogance and their unbridled hubris, Mr. Speaker, this Liberal government is ignoring the wisdom born of cooperation and collaboration. There were 14 amendments. They were all supported by multiple parties, and now they are intent on ramming this bill through that they spent, after spending almost 11 years, failing to introduce and pass it. So the member for Nunavut in particular, she contributed to this bill in a very meaningful, important way. This is what Canadians want to see. Her party didn't even have a seat at the committee table, but she as an MP produced a good, sound, principled amendment that was debated and adopted at committee. So Canadians say they want their elected representatives to be open-minded, they want them to work together, they want them to respect and cooperate with each other. That's what the Defense Committee did. They took seriously the amendments offered by an MP that didn't even have a vote at the committee. But between the clause-by-clause review at the committee and the present, today, when they now have a majority and have used time allocation to curtail debate on this, the member has crossed the floor and joined the Liberal caucus. So she had a history of principled opposition to government. She was one of the few NDP members that remembered that her duty was to oppose the government, not to hold the opposition party to account. So I hope that she will remember this and that she will not end up opposing her own contribution to this bill. Because she proposed the amendment that would allow choice and flexibility in cases of sexual misconduct in the military. She was doing her job, Mr. Speaker. So now that she sits in the Liberal benches, I hope that she will actually follow through and support her own amendment. But, she's not the only one. There are votes, there are those that have crossed. We now see the Liberals and their true colors: power at all cost, control at all cost, power concentrated entirely in the hands of the Prime Minister. And the Prime Minister's contempt for Parliament as an institution is becoming obvious to all. I'm actually concerned about his limited civic literacy, Mr. Speaker, when he speaks in English and calls other MPs his deputies and sets up photo op signings pretending to sign bills into law. It's almost like he needed to be told that it's actually the Governor General that signs laws, not him, and that she only does so after they have been agreed to by a majority of members of Parliament of both houses of Parliament. And none of those members in either chamber are his deputies. So I'm disappointed that the government took 11 years to deal with a well-known and long-standing problem, and that they are proposing to gut this bill after such clear and powerful committee testimony. I supported the bill in principle and sending it to the Defence Committee. I support the conclusions of the Defence Committee, who made important amendments to fix this bill, and I oppose the Liberals' attempts to undo the committee's work by gutting out the amendments today.
Questions and comments. Question and commentary. Honourable Chief Government Whip.
Well, thank you for that, Mr. Speaker, and I appreciate his comments there towards the end about the use of the word deputy, which, as he knows, means member of parliament in French. But I'm curious, is he equally as concerned about the time the member from Brantford Brant stood up in this House in the middle of question period when he was responded to in French, and he challenged the minister for responding in French, and he actually said, the member from Brantford Brant said, "I wish you had answered the question in English." He must be equally as outraged when that happened, correct, Mr. Speaker?
The member for Calgary Crowfoot.
I think he completely missed the point. I'm not even sure. I wasn't speaking of the Prime Minister's use of French or English. I was talking about his use of the English word deputy when clearly characterizing his MPs as his deputies. He thinks that the Prime Minister thinks that the MPs of his party are his deputies, just there to do his work. They are elected by the people of Canada. All MPs are elected by the people of Canada. Nobody is the Prime Minister's deputy around here.
Commentaire on
Questions and comments. The Honourable Member for Repentigny. Mr. Speaker, I thank my colleague for the speech. I'd like to hear my colleague's thoughts on the government's attitude. This government was not elected as a majority government during the last general election, but now, thanks to floor crossers, the government is taking ownership of all the work that was done in committee for days upon days. Parliamentarians worked hard in committee. They heard witness testimony. There were amendments. Conservatives supported amendments to enhance and improve this bill, but now this government is literally throwing into the trash all the committee's work, doing away with the committee's work and doing away with the people's will, because the people voted for consensus in the House, not for a majority government. So does my colleague agree with the government tossing aside all the amendments that the committee consensually supported?
I agree with what the government is doing, and I thank the member for the question and for the way he put it. That's exactly what we've seen and what is happening today. This government is undoing the work of a parliamentary committee that did good work on behalf of Canadians, MPs from different parties cooperating with each other, producing sound, principled amendments to actually deal with a real problem, and now the Liberals are undoing that work because they can.
Questions and comments. Question and commentary. The Honourable Member for Selkirk, Interlake, Eastman.
Well, thank you, Mr. Speaker. I want to thank my colleague from Calgary Crowfoot for his great intervention and to do a bit of a recap on the history, including pointing out the fact that in the previous Conservative government back in 2014, when sexual misconduct was becoming a major issue, commissioned Justice Deschamps to write a report that then sat on the Liberal minister's desk, Harjit Sajjan, who was in the process of trying to cover up the sexual misconduct of the former Chief of Defence Staff, John Vance. And the Liberals would rather cover things up than actually deal with the issues. And they ignored the 9 great recommendations from Justice Deschamps. As a point of interest, Justice Deschamps showed up on the committee study on Bill C-11. They always talk about Justice Fish appearing. He did appear as well, and then also submitted a written submission. All of them said that that choice is an option. The only justice that didn't show up, that the Liberals continue to use their shield, is Justice Arbour. And she didn't show up at the committee. She didn't defend her report, and that report has now been discredited by the testimony that we heard from veterans themselves, including the military justice system. So I just asked my colleague, why won't the Liberals listen to veterans and military experts rather than just try to push through on their own political agenda?
Member for Calgary Crowfoot, in about 45 seconds or less.
Yeah, I have no idea why. He's asking why they are doing this, why they are choosing to ignore all the testimony, choosing to ignore the substance of really all three reports. I mean, Justice Arbour's report, nobody is saying that sexual assault and misconduct cases must stay within the military justice system. Nobody is recommending that. So I have no idea why they are ignoring all of the witness testimony that they heard, and why they spent 11 years not solving and not dealing with the problem of legislation for dealing with misconduct and the sexual misconduct in the armed forces.
Resuming debate, reprise du débat, and before I give the floor to the honourable member for Thornhill, I'll just inform her she'll have about a little over 7 minutes for her intervention. The honourable member for Thornhill.
Mr. Speaker, there are bills that come before this House that are routine, and there are bills that remind us why we're here. And I think C-11 is the latter. And when Canadians put on a uniform, they place their safety and their very lives in our hands, and we owe it to them to create a justice system that is deserving of that trust. And today we have an actual chance to deliver one, but it seems that the government throughout this entire debate is choosing not to. The legislation before us is one of the most serious and sensitive, or tries to address one of the most serious and sensitive issues facing our country, delivering justice for victims of misconduct in the Canadian Armed Forces. Now, let me begin by clearly stating that Conservatives are proud of the brave men and women who serve in uniform. They put their lives on the line for Canada, and they deserve a workplace that is safe and respectful and worthy of that dedication, even after 11 years of not doing anything about it. And just as clearly, every victim of sexual misconduct in the Canadian Armed Forces deserves timely justice, real accountability, and above all, respect. After successive failures that have been outlined by my colleagues in this House of Liberal governments, the victims are still waiting. This bill is virtually identical to Bill C-66, which died in Parliament when it was prorogued in 2025 in January. Its recommendations trace back to 2 independent reports by former Supreme Court justices delivered in 2021. And 4 years later, survivors are still waiting for a system that they can trust. And these are the failures that we're confronting today. In the last year alone, just to put it in context, the Sexual Misconduct Support Resource Centre received over 1,400 calls, of which 588 were related to military sexual trauma. That's not an abstraction. They are real Canadian soldiers, sailors, aviators, who have been consistently failed by the system. And Conservatives approach this bill seriously and constructively. We studied it carefully at committee. We listened to survivors. We listened to experts on it. And we worked across party lines with colleagues from the Bloc and the NDP to improve this bill in a very meaningful way. One thing we heard over and over again from those who have lived through this system was the importance of choice. It was actually brought up by a member who's since decided to sit in those Liberal benches. And choice matters, because at the heart, it is about a compassionate, effective system with a simple principle. Survivors must have agency over their own path in justice. We heard it over and over again at committee, and we heard it over and over again by survivors. And it is like any other Canadian. It is like any other patient who is choosing their own doctor. Nobody should tell you, and nobody should tell a survivor which system and which doctor they should use. But the government's original approach to this legislation did exactly that. It did the opposite of what we're talking about here. And it seems that they're going to dig in their heels and go with that, despite all of the work that was done in committee, despite the legislative process working as it should, despite all of those survivors sitting in front of the committee and telling us exactly what they needed to have trust in this system. The bill before the amendments transferred all sexual assault offenses to the civilian justice system without exception and without survivor input. A survivor and a veteran told the committee that Bill C-11, as originally drafted, removes choice from survivors and reduces flexibility. And that survivor and that veteran was not the only one that said that. I want to say something in this House because I think people will listen. This is the exact definition of paternalism. Real, actual paternalism as we see it in our system today. And it is not the kind of empowerment that is needed to hold trust in a system. Advocates and survivors have also raised concerns about moving cases into an already strained civilian justice system. And we know that. Both systems have strengths, both have weaknesses. We heard that at committee. But survivors told us clearly that some prefer others, while others prefer a system that works for them. So we made that change. The committee made that change. And despite putting that bill forward with agreement from all three other parties and the witness testimony, the government is choosing to turn their back on that change, to present the original form of the bill that doesn't incorporate those changes. And for a government that has talked a big game about listening to survivors, particularly in this case, women in the military, after ignoring it for so many years, it is dumbfounding why they wouldn't listen in this case and why they would go ahead with the very system that they said doesn't work for survivors. Through these amendments, though, the committee, we secured the right for survivors to choose which justice system their case proceeds in. And again, this would be a fundamental shift towards respecting that autonomy, the autonomy that the government said that they hold dear. It's not just a procedural tweak. It is witness after witness that confirmed this to the committee. It is witness after witness that stood in front of members now who sit in the Liberal benches, who agreed with these committee members, who went out of their way, who made that change. We also worked to strengthen accountability in the system. We introduced timelines for key appointments. And because under this government, critical roles in the military and the justice system have been left vacant for months.
Sorry to have to interrupt the member. She will have 2 minutes and 50 seconds remaining after question period. We'll now go to statements by members. Déclaration de député, l'honorable député de Vaudreuil.
The honourable member for Vaudreuil. Mr. Speaker, I'd like to pay tribute to one of the pillars of our Vaudreuil community, Mr. Elwood Quinn, who sadly passed away earlier this year. A fifth-generation farmer, Elwood had a deep passion for helping people understand the importance of agriculture and the origins of their food.
Years ago, Elwood purchased a 130-acre plot of land in Notre-Dame-de-l'Île-Perrot and transformed it into a thriving farm and homestead. Since then, Mr. Speaker, hundreds of thousands of families have experienced agricultural life, with pumpkin, apple, and strawberry picking becoming an annual tradition for countless families, including my own. He was a tireless advocate for protecting the rich farmlands that sustain us, convinced that genetic diversity is essential to Canada's food sustainability, and was involved in raising awareness around the well-being and safety of farm families.
Thanks to the involvement of his children, including his son Phil, the farm continues to welcome thousands of visitors each year And to highlight his remarkable legacy, a celebration will be held this May to honor his extraordinary life. Rest in peace, our friend Elwood.
Our friend Elwood.
The honourable member for Simcoe North.
I rise to tribute a dedicated public servant and pillar of our community, Phil DeBrune, who passed away on April 13th at the age of 71. Phil's career was a testament to his unwavering commitment to justice and integrity. He found a passion for policing in high school, graduated from Georgian College, and began policing on the front lines at age 20 in 1974. He eventually joined as an instructor at the Ontario Police College, where he stayed until 2009. Phil returned to school to complete his studies in undergraduate and master's programs, while always maintaining a connection to teaching and policing. He contributed his expertise to the Penetanguishene Police Services Board and South Simcoe Police Service, as well as many local charitable causes. Phil was polite, kind, and generous. He cherished his family and his community. Ethics, honesty, and integrity defined him. His faith was his foundation, and his principles were his guide. Phil leaves behind a profound legacy cherished by his wife Susan, his stepchildren, and grandson. True leadership is found in the quiet, steady dignity of public service of one's community. Thank you for your service, Phil. May you rest in peace.
The honourable member for Spadina Harbourfront.
Mr. Speaker, from food banks and employment training to health services and community support, Canada's nonprofit and charitable sectors support people every single day. When families need help, when young people need opportunity, and when communities need connection, this sector is the first place that Canadians turn to. Canada's nonprofit and charitable sector generates $244 billion in annual economic activity, contributes 8.4% of our GDP, and employs nearly 3 million people across this country. These organizations are not only community builders, they are major economic drivers. In Spadina Harbourfront, we are proud to be home to organizations like Fora Network for Change, Movember, Eva's Initiatives, Waterfront Neighbourhood Centre, Taking It Global, Casa Foundation, and many more. These organizations deliver essential services, create jobs, build local economies, and drive social resilience. When nonprofits thrive, communities grow stronger, our economy grows stronger, and Canada prospers. I invite all colleagues to join me this evening at Imagine Canada's reception to celebrate this vital sector whose work strengthens our communities from coast to coast to coast. Thank you.
The honourable member for Calgary McKnight.
Mr. Speaker, after 11 years of this Liberal government, Canadians are facing the worst food price inflation, the least affordable housing, and the second highest unemployment in the G7. 2 million Canadians line up at the food bank each month, and Canada's happiness ranking has dropped from 5th in the world to 25th. And now the Prime Minister wants to put another $25 billion on the National Credit Card for a Liberal slush fund that will enrich Liberal insiders at the expense of Canadians. Conservatives know that Canada should be the richest and most affordable country on earth. We know that housing should be dirt cheap. We know that Liberal deficits drive up inflation and leave Canadian families to pay the bill. That's why we are calling on the Liberal government to cut the deficit, cut taxes on the work, cut taxes on home building, and to get rid of all federal taxes on gas and diesel for the rest of the year. That's right.
The honourable member for Hull Aylmer.
Last week we lost Dr. Julia Daniel, a remarkable scientist, mentor, and leader whose legacy will live on. Born in Barbados, she came to study at Queen's University, and she earned her PhD at UBC, and went on to become a full professor at McMaster University and a respected voice in her field. I had the privilege of meeting her in Ottawa, where she spoke about her research on triple-negative breast cancer, which disproportionately affects Black women. Her discovery of the gene KYSO, named after a type of calypso music, was a significant contribution to understanding how cancer spreads. My heartfelt condolences to her loved ones. Dr. Daniel, your time on earth was like a comet, brief yet unforgettable. Though our time together was short, I wish you eternal peace. May your legacy continue to inspire women and researchers everywhere.
The honourable member for Windsor West.
Mr. Speaker, yesterday I attended the commemoration ceremony for the Battle of the Atlantic in Windsor alongside veterans, cadets, and members of the HMCS Hunter. Young men sailed into danger so Canada could remain free, democratic, and sovereign. All Canadians are united by a belief in what this country represents: democracy, the rule of law, accountability, and the promise of a better future. Even new Canadians understand deeply the sacrifices made to preserve those values. But what do we see today? Young people are facing jobs crisis, food bank use is exploding, seniors are worrying about health care and affordability. We see a government drifting from crisis to crisis without a compass.
That's right.
The young Canadians we honored yesterday sacrificed themselves at the altar of democracy itself. If we will not defend democratic principles here in this place, then where are we going to honor the legacy of those brave souls? The generation that crossed the Atlantic under fire did so out of a sense of duty for king and country. After 11 years, the Liberal rule, Canadians are still waiting for that future.
The honourable member for Sydney Glace Bay.
Mr. Speaker, I rise today to honour Fred Courtney of Glace Bay, who passed away last Friday at the age of 90. Fred was a hockey legend in Cape Breton. As captain of the 1955-56 junior minors, he led his team to a Cape Breton and Maritime Championship, earning league MVP. His talents drew interest from the New York Rangers and Detroit Red Wings, yet Fred chose to stay home and serve his community. Beyond hockey, Mr. Speaker, Fred spent 22 years teaching, 22 more years coaching bantam hockey, and over 60 years serving the Salvation Army as Corporal Sergeant Major. The Glace Bay Minor Hockey Association, Mr. Speaker, proudly presents the Fred Courtney Trophy each year in his honor. Mr. Speaker, I ask this House to join me in celebrating Fred's life, and what a great life, and extending our deepest condolences to his family.
The honourable member for Edmonton Manning.
Mr. Speaker, 12,000 Canadians will be diagnosed this year with type 1 diabetes, joining the 300,000 already dealing with it in the system. T1D can occur in people of any age. It causes not only full known. Most of those diagnosed have no family history of diabetes. It isn't caused by diet or lifestyle. It isn't contagious or something that you can outgrow. It has no cure. For more than 50 years, Breakthrough T1D has been working to improve the lives of Canadians suffering from diabetes. Their 5-year plan, including $62 million proposed for budget 2026, is a part of a $100 million private-public project to translate Canadian medical research into therapies that can benefit Canadians. Mr. Speaker, I thank them for their tireless efforts.
The honourable member for Drummond. Mr. Chairman, yesterday in Montreal, SOCAN held its 35th gala to celebrate the exceptional contributions of our songwriters and music publishers. It was, in particular, an opportunity to pay tribute to two musical giants of Quebec culture, Margeau and Luc Plamondon, from Diane Dufresne to Céline Dion, from Charlebois to Dubois. From Starmania to Notre-Dame de Paris, Plamondon's lyrics have been with us for half a century, and his extraordinary world is now our own. As for Margeau, our magnificent Margeau, she received the Empreinte Award for her song Provocante, karaoke stable. Margeau and Luc Plamondon, two icons, two legends, and that represent our Quebec culture, and they are a great source of pride for us. On behalf of the Bloc Québécois, I pay tribute to Luc Plamondon and Margeau and to all laureates, including my friend Gaëtan Essiam, who won the National Television Prize at SOCAN. Long live to SOCAN and to our artists, and long live Quebec songs and music.
The honourable member for Toronto St. Paul.
Mr. Speaker, I rise today to remember the life of a dear friend and remarkable Canadian, Eric Rower. A leader in the field of education and labour law, Eric was at the heart of our community in Toronto St. Paul's. He was infinitely generous and warm and loved every inch of Canada so deeply, whether paddling up north or zipping along St. Clair in his Vespa. It was his love of community that drove him to serve as the president of Holy Blossom Temple, where 5 generations of his family continue to gather. But it was his infinite optimism which prompted him to open the door of his community and his home to my family and so many others. Eric knew that by bringing people together, by finding joy in each other, we could make the world a better place. This is Tikkun Olam, the Jewish commandment to leave this world better than you found it. And in that, Eric, I can proudly say that you were successful. To Eric's beloved family, his wife Beth, daughters Jessica, Rebecca, and Sophie, my heartfelt condolences are with you. May Eric's memory be a blessing to us all.
Hear, hear. Hear, hear.
The honourable member for Niagara South.
Mr. Speaker, despite the illusions with this Liberal Prime Minister, it's more cost, more carbon taxes, more of the same. Liberals blame $100 per barrel oil for high gas prices. But in 2014, oil was also $100 and gas was $1.38 a litre. Today it's $1.83. That's 45 cents more for the same global price. What's changed? Well, Liberal policy. Higher taxes, carbon taxes, and GST on top of the tax are driving up costs. And a weaker dollar, down roughly 20% since 2014, means Canadians pay more for fuel and food because our economy is weaker under Liberal leadership. Canadians are paying the price for bad policy. All of the taxes, we want all of the taxes removed all of the year. It's time for Liberals to take our common sense plan to remove them, unblock our oil and gas production, and make Canada affordable and strong at home.
The honourable member for Compton-Stanstead. Thank you, Mr. Speaker. I'd like to acknowledge the presence here in Ottawa of people from my riding, representatives from the municipal, community and business sectors, including the mayor, Esther Réfort, the president of UPA Estrie, and the directors of the Maison Estrie. They have come to share their concerns regarding cellular connectivity in our regions, whether it's for road safety when an emergency call doesn't go through, or for our small and medium-sized businesses that rely on reliable networks to deliver their services. The lack of coverage remains a real issue for public safety and economic development. The discussions in Ottawa serve as a reminder that behind the statistics lie very concrete daily realities in our communities and that we must provide solutions. I want to commend their commitment to bringing these issues to light here in the capital, and I reiterate my determination to continue raising them in the House. Thank you, Mr. Speaker.
The honourable member for St. Albert Sturgeon River.
Mr. Speaker, the Liberals' costly budget demonstrates once again that the Prime Minister's rhetoric does not match reality. The Prime Minister promised to spend less. It turns out he's spending more, way more than Justin Trudeau. In only 1 year, the Prime Minister has managed to double Trudeau's deficit, and now the Liberals are on track to rack up a record $1 trillion of new debt. It begs the question, for all of the spending and all of the debt, what do the Liberals have to show for it? Record food inflation, record housing costs, terrible productivity, and the second highest unemployment rate in the G7. Despite the Prime Minister's rhetoric, he's more of the same. He's just another costly Liberal.
That's true.
Honourable member for Ottawa Centre.
Speaker, today, along with parliamentarians, members of the Canadian Armed Forces, veterans and families, I had the honor of attending the groundbreaking ceremony marking the start of the construction phase of Canada's National Monument to the Mission in Afghanistan. A permanent memorial to the 158 members of the Canadian Armed Forces and 7 civilians who lost their lives. It is also a tribute to more than 40,000 Canadians who served during our country's largest military deployment since World War II. Nous modifions également la manière.
We are focusing on the way in which we pay tribute to these veterans.
Ottawa Centre, and to represent the community where this monument will reside. But at its core, this must be a space for all Canadians. It must be a space to honor our history, guide our future, and a place to inspire the next generation of remembrance.
The honourable member for Cloverdale Langley City.
The Parliamentary Budget Office released 4 reports on the Liberals' costly credit card budget this morning, and the picture they painted in our briefing with Annette Ryan was deeply concerning. Here's what she confirmed. We still don't have clear definitions on what counts as capital versus operating spending, so she can't verify if the government is meeting its own fiscal anchors. The $1 trillion investment plan still has no timelines, no performance metrics, no real reporting. Housing plan won't meet targets. The defense plan is a massive unfunded risk. The tens of billions in new spending has no clear government governance, no updated costing, and no transparency on delivery. And the money for the $25 billion sovereign debt fund will be coming from the Bank of Canada issuing bonds to finance it. And who's buying our debt? According to an IMF report in April, they flagged that volatile foreign hedge funds now make up a large share of investors, which puts Canada at serious risk. This morning's briefing was alarming, to say the least. So when will this Prime Minister get serious, stop the credit card budgeting, and let Canadians...
The honourable member for South Surrey, White Rock.
Mr. Speaker, in 2011, along British Columbia's Highway of Tears, a remote stretch of Highway 16 where far too many Indigenous women and girls have gone missing or been murdered, Paul and Raven Lacerte were moved to action, father and daughter co-founders of the Moose Hide campaign. It's an Indigenous-led movement grounded in love, ceremony, and accountability, calling on people of all backgrounds to take a stand against gender-based and domestic violence. Wearing a moose hide pin is more than a symbol. It represents a personal commitment to honor, respect, and protect women and children in our homes, workplaces, and communities. It's about building safer communities where everyone is responsible to speak up and support one another. On Thursday, May 14, Moose Hide Campaign Day, I'm asking all Canadians to renew that pledge, most importantly to take meaningful action, because ending violence is a responsibility we all share, every single
Oral questions, questions orales. The honourable member for Thornhill.
But then he spent $35 billion more in the last fiscal update alone. He promised to lower the debt. Instead, the deficit's doubled from just 1 year ago. And he promised fiscal brilliance. But the not even so conservative Globe and Mail calls that an inversion of reality. Once an expensive Liberal, always an expensive Liberal. This year, Canadian families will write a check for $3,400 just to cover the interest on the Liberal debt. Why won't the Prime Minister stop forcing Canadians to pay the credit card bill and just allow them to get by?
Hear, hear. The Honourable Secretary of State for Financial Institutions.
Mr. Speaker, Canada's new government is committed to build a strong, resilient and independent economy. Despite what we hear opposite, our economy is strong. The IMF projects our economy to be one of the most resilient, fastest growing in the G7. We're going to continue to build the economy. A spring economic update invests $6 billion in the trades. It invests in the Sovereign Wealth Fund. Mr. Speaker, on this side, we are continuing to build a strong economy. That side can continue with the rhymes and rhetoric. Thank you, Mr. Speaker.
The honourable member for Thornhill.
Debt fund. The Prime Minister actually told Canadians that he was the guy that you hired in a crisis and then spent double what the last guy spent. Just 5 years from now, the Liberal credit card bill will reach $1 trillion. All that spending has brought us the highest grocery prices, the worst housing prices, and a $2 a litre gasoline while everybody falls behind. The crisis guy is racking up more debt and promising somehow it's going to be different this time. When are they finally going to stop the credit card craziness and so Canadians can afford to live?
The Honourable Minister of Artificial Intelligence and Digital Innovation.
Speaking of credit, we have the best credit rating in the world. Wages have grown twice as fast as inflation. And what would this or the opposition cut? What would they cut? For example, would they cut support for our workers? Just today, Mr. Speaker, we have invested $1 billion to support the steel, the aluminum, the copper industries hit by a trade war that they deny, and another $500 million for good jobs like at Bow Rock where they're building with steel. Would these guys cut support for those industries? Ask them, Mr. Speaker.
The Honourable Member for Edmonton Gateway.
Mr. Speaker, despite the illusions, with this Prime Minister, it's more cost, more blocking our resources, more of the same, because he's just another Liberal. This Prime Minister said a pipeline was more probable than possible, but there's no proponent, there's no start date, no completion date, no route. There's no plan. If the Prime Minister wants Canadians to believe he's not just another Liberal, will the government tell us on what date will construction start on this new pipeline? Just a date, please.
L'honorable ministre de l'Industrie.
Mr. Speaker, my colleague in charge of natural resources will be able to also answer that question. What I can add to that is that the Conservatives in all their questions always forget something that all Canadians know, which is we're in a trade war. And a lot of workers their jobs are at stake. And that is exactly why today we announced $1 billion through the BDC to help our steel, aluminum, and copper workers. And that's also why we announced $500 million to support workers across the country. We've been there since the beginning of the trade war, and we'll continue to be there.
The honourable member for Eglinton Gateway.
Mr. Speaker, it's not the Americans that are blocking a pipeline to the West Coast. It's this government. The biggest barriers that we have facing in the industry is the Liberal government. This Prime Minister has not reversed a single Liberal anti-development law, reduced a single tax on our resource industries, or delivered a single shovel in the ground on a new project from his major projects office. It's more of the same because it's just another Liberal. They said that they would move at unimaginable speeds. So, on what date will construction start on the new pipeline? Just the date, please.
The Honourable Minister of Energy and Natural Resources.
Mr. Speaker, if instead of working on their social media clips, they actually spent some time talking to proponents, they would understand that we approved the Taylor to Gordondale pipeline and Pembina is building a pipeline. They would understand Enbridge approved the Sunrise pipeline. It is building a pipeline. And if they actually talked to the government of Alberta, they would understand Alberta is coming forward with a proposal by July 1st, Mr. Prime Minister.
L'honorable député de Mégantic-Lérable.
The honourable member for Mégantic-Lérable, Lobinière. 1 with 12 zeros. 1 0 0 0 0 0 0 0 0 0 0 0 0. $1 trillion. Mr. Speaker, that's the amount that the Liberals have added to the national credit card over 10 years. More zeros means more debt. More debt means more taxes. More taxes means less money in Canadians' pockets. This Prime Minister is just another Liberal. When will he start adding zeros to the national credit card? When will he finally let Canadians just pay the bills? The Honourable Minister of Industry. My colleague does not recognize that we are in a tariff war. We are here for our auto sector, our copper, aluminum, and steel sectors. And in fact, Quebec is very pleased with our announcement this morning of $1 billion for BDC and $500 million for economic development agencies. My colleague has to recognize that we have reduced government operating costs. Meanwhile, we are investing in order to create economic development. Our plan is working. The honourable member for Mégantic-Lérable-Lobinière. Well, I just add another zero to that, this time for the minister's answer. Because when a student piles up the zeros, they fail. This Liberal government is piling up the zeros and Canadians are paying for that failure. Costs are skyrocketing. Everything costs so much. Housing, food, gas. Why? Because the Liberal Prime Minister is printing more debt as if there were no tomorrow. But there is a tomorrow, and our children are going to have to pay the debt and the interests. This Prime Minister is just another costly Liberal. Is he finally going to put an end to his costly budgets on the national credit card? The Honourable Minister. I'd like to give my colleague an A+, for following his leader's instructions and just reading the question he was provided. He likes to make his little jokes. Well, we can give him a math lesson. Canada's growth is the second best in the G7. And we have the best fiscal position in the G7. Those are the facts. Those are the numbers. We have a plan. The honourable member for Saint-Jean. Mr. Speaker, the Liberals seem to have finally understood that it's terrible to just forget about our businesses and the tariff war in their economic update. But unfortunately, today's announcement seems to be very off the cuff. It's not going to really help the SMEs that are affected by new American tariffs. These businesses are clear. They don't want more loans. They already have too much debt. What they need is help modernizing, and especially what they need is liquidity to survive. This is a first step, but can the government confirm that there is more to come? The Honourable Minister of Industry, I'd like to thank my colleague for her important question. Indeed, we have announced good news for our businesses this morning, $1.5 billion to help with liquidity, and with extremely favorable debt, no interest for the first year, and then very low interest for years 2 and 3. And there's no need to pay the loan back until the end of the term after 3 years. We're doing this because our businesses need help. We are here to help them. We are getting good reactions from the manufacturers and exporters of Quebec and other organizations. We're meeting their needs. The Honourable Member for Saint-Jean, Mr. Speaker, we will cooperate with the government on this first step, but let me just quote the Federation of Chambers of Commerce. For businesses that are currently barely able to survive, this is not enough. They need liquidity to keep operating. They don't need more debt or to make investments that won't benefit them until the middle or long term. That's what the Federation says. Mr. Speaker, we need immediate help and we need wage subsidies in order to avoid layoffs. When is the government finally going to do something about this? Thank you, Mr. Speaker. I just spoke to the leader of the Quebec Federation of Chambers of Commerce, and she said she greatly appreciated what the government is doing here. Of course, there's always more to do, and we will do more. But I think this is good news for companies like PRP that have been affected by the new tariff calculation. Companies like Manac with thousands of jobs throughout Quebec and the rest of the country. And that's why my colleagues and I have been in solutions mode this morning. The Honourable Member for Joliette-Manawan. Mr. Speaker, the new American tariff calculation started on April 6th is a catastrophe for Quebec's manufacturing. Desjardins revealed that a quarter of all Quebec exports to the U.S. are being affected. This is a 160% increase, and it is affecting our small businesses, but they're not being helped by our government in this announcement. They cannot take on more middle-term debt when they are facing immediate bankruptcy. They need help today. Will our government do something about this? The Honourable Minister for Canada-U.S. Trade, as my colleague just indicated, we just announced further measures this morning to support businesses that are being affected by the unjustified tariffs from the Americans. I have met with a number of these businesses, and my colleague has too. Our ministers, our members are very aware of these difficulties, and that is exactly why we are supporting these industries, and that's why we are there to do more if necessary.
Member for Calgary East.
This Liberal Prime Minister racks up the national credit card because he knows Canadians have to foot the bill. Despite all the Liberal illusions, it's more costs, more taxes, more debt, more on the national credit card, all by the same old costly Liberals. Every time these guys say they're going to change, they end up racking up more on the national credit card, now leaving Canadians with $1 trillion debt bill over the lost Liberal decade. Does the Prime Minister know this is Canadians' money, not his, or does he just not care?
The Honourable Parliamentary Secretary to the Minister of Finance.
Mr. Speaker, the Parliamentary Budget Officer says Canada's fiscal indicators are good, and the Bank of Canada Governor has said he's encouraged by the federal government's efforts. That's because the Canadian economy is stronger and more resilient than anticipated, 11 billion less of a deficit, inflation within the Bank of Canada's target, the highest foreign direct investment in nearly 2 decades. We still enjoy a AAA credit rating. Wages are growing faster than inflation, and the IMF says Canada's got the strongest fiscal position in the G7. Those things don't happen by accident, Mr. Speaker. They're proof that our plan is working.
The Honourable Member for Calgary East.
Does this guy want a gold medal for having the second highest deficit in the entire Canadian history outside of COVID? This Prime Minister skips on the bill while Canadians are skipping meals. More than 1 in 10 Canadians now are living in poverty, and the pain's only going to get worse by these guys piling on more and more debt. The Liberals spend like there's no consequences. It's Canadians that have to pay those consequences. When will he stop the reckless spending? Stop the out-of-control deficit so Canadians can afford to live.
The Honourable Minister of Jobs and Families.
Mr. Speaker, in that member's province alone, the National School Food Program is feeding nearly 60,000 children. And in early learning and childcare spots, Mr. Speaker, families are saving up to $13,700 per child per year, Mr. Speaker. And in fact, we've got the Canada Dental Care Plan in that riding as well, Mr. Speaker, which helps over 155,000 people in Alberta. Mr. Speaker, all across the province that member claims to represent, people are benefiting from Liberal developed programs that are helping with the cost of living and making sure families get ahead.
The honourable member for Fort McMurray Cold Lake.
The Prime Minister claims a new pipeline is more probable than possible. Yet there's no proponent, no start date, no completion date, no route, no timeline, no shovels in the ground, nothing. This after promising to move at unimaginable speeds. Despite the illusions, it's clear the Prime Minister is just another Liberal. If he wants Canadians to believe he's anything other than just another Liberal, will he answer this simple question? What is the exact date construction will begin on a new Pacific pipeline? Just the date.
The Honourable Minister of Energy.
Mr. Speaker, if they would stop focusing on their social media clips and focus on what's happening out there, they would see that Pembina Pipeline is building the Taylor to Gordondale pipeline this summer. They would see that Enbridge is building the Sunrise pipeline this summer. And if they talked to the government of Alberta, they would realize the government of Alberta is bringing forward their proposal this summer.
Member for Fort McMurray Cold Lake.
I'm focused on the people of Fort McMurray Cold Lake. And Mr. Speaker, the problem is this is not yet another Liberal illusion. The biggest barriers that we face in developing Canadian natural resources are imposed on it by the Liberal government here in Ottawa. They haven't repealed a single anti-development law, not one tax cut for the resource sector, not one shovel in the ground through their major projects office. It's the same old story because it's just another Liberal. So the promise to move at unimaginable speeds. So can he just very clearly say, what is the date for this new Pacific pipeline? Just the date, please.
The Honourable Minister.
So here's what is not an illusion, Mr. Speaker. $4 billion going into the Canadian economy this summer. 2,500 new jobs on the Sunrise expansion this summer. $3 billion annually in new GDP from this summer forward. And if they bothered to talk to the Alberta government, they would understand they are bringing their proposal forward this summer for the benefit of the people of Alberta and all of Canada.
Honourable member for Prince George, Peace River, Northern Rockies.
Despite his promises, this Liberal Prime Minister is all about more costs, more carbon taxes, and more of the same. He said last May, Canadians will hold us to account by their experience at the grocery store. Everyone knows when fuel prices go up, food costs go up. From Mike Boylo of the Northwest Company, a jug of milk now costs $2 to $5 more because of higher fuel prices. Why is fuel so expensive? Because of high Liberal taxes, including the newly renamed carbon tax. Will Liberals scrap all gas taxes all year, yes or no?
The Honourable Minister of Veterans Affairs.
Speaker, the member opposite's from British Columbia, and what I know people in British Columbia want is the actions that we are taking right now. They're seeing the steps we're taking with the groceries and essentials benefit. They're seeing us remove 10 cents a litre off fuel, and they're seeing our investments in young people and our economy. Mr. Speaker, we're addressing the things that people in BC want.
Member for Prince George, Peace River, Northern Rockies.
Those empty words won't fill empty stomachs, Minister. Liberals tell you that gas prices are up because world oil prices are at $100 a barrel. But do you know when oil was also at $100 a barrel? The price in 2014, under our Conservative government. The price at the pump then was $1.38 per litre, not $1.99 for gas or $2.29 for diesel like it is today in Fort St. John. Will the Liberal Prime Minister stop the illusion, scrap all gas taxes all year so Canadians can afford to live again?
Honourable Minister of Veterans Affairs.
Mr. Speaker, we're aware of the impact of fuel prices. That's why we've brought them down by 10 cents a litre. We are addressing exactly what our member opposite's talking about. We're also delivering the food and essentials groceries and essentials benefit, and we've made the National School Food Program permanent to help families. You know, we're doing the work that's being asked for.
The honourable member for Edmonton, Griesbach.
Mr. Speaker, Canadians are concerned. The Liberals are on track to add $1 trillion to the national debt since taking office just 11 years ago. And just like our personal credit cards, Canadians know we'll have to pay that bill. This Liberal Prime Minister is not a good steward of our tax dollars. It's an illusion. We have more cost, more taxes, more debt. This Prime Minister is just another Liberal. When will he get serious? When will he end his costly credit card budgeting so Canadians can afford to live?
The Honourable Minister of Emergency Management and Community Resilience.
Thank you, Mr. Speaker. Our plan and our spring economic update is good for Edmonton, but my fellow Edmontonians on the Conservative benches shouldn't just take it from me. Doug Griffiths, President and CEO of the Edmonton Chamber of Commerce, says our update aligns closely with what Edmonton businesses have been wanting to see from our federal government. I hope every Edmonton MP listens to the people and the organizations we represent and gets on board with our plan to build Canada strong.
L'honorable député d'Abitibi.
The Honourable Member for Abitibi-Témiscamingue. Mr. Speaker, the Liberals are taking advantage of their majority to try to stifle the Currim software scandal. After months of denying all the issues with OAS and all of the cost overruns, the government has added $451 for Currim in its economic update. More cost overruns, even though they're saying there were no cost overruns, to fix problems that they also denied. We'll never know why, because the Liberals are using their majority at committee to stifle the Currim investigation. What are they hiding? The Honourable Government House Leader. Mr. Speaker, no one is hiding anything. This is entirely transparent. The procurement process was transparent. The budget is transparent. The budgets were respected. And the Currim software is helping us make life better for millions of Canadian seniors every month. The Honourable Member. Mr. Speaker, there's been cost overruns on 5 occasions. And the Liberals have only had a majority at committee for 1 week, and they've already managed to shut down an investigation on the Currim cost overrun, $7 billion. They also shut down a Drivers Inc. investigation. It seems like they prefer to protect dangerous trucking than to protect Quebecers. They also shut down investigations on health, Veterans Affairs, aerospace, and so on. This is just the culture in Ottawa. Secrecy. When will the Prime Minister finally put an end to this? The Honourable Minister of Employment and Families. Mr. Speaker, $1.8 billion have been invested out of a total budget of $4.8 billion to modernize these systems. Modernizing the OAS system was carried out under the projected budget, which shows that the project was rigorously managed. This information was communicated transparently, and it was reviewed by opposition parties and an opposition-chaired committee. The Honourable Member for Beauce. Mr. Speaker, the Liberals' economic update is just more of the same. More uncontrolled spending, more debt for Canadians. The national debt by 2031 will reach the horrifying level of $1.63 trillion. That's $1,630 billion of Liberal debt. The Prime Minister says that he's a responsible fiscal manager, but he's just another costly Liberal. So will the Prime Minister finally do something about the Liberal credit card? The Honourable Parliamentary Secretary. To the Minister of Housing. Thank you, Mr. Speaker. I know that on the other side, they seem to struggle with facts, especially when they have to do any amount of math. But let me help them. We reduced the deficit by $11 billion. We are the second strongest economy in the G7. And we are attracting more investment than we have for 2 decades. Why? Well, while the Conservatives were wearing themselves out, repeating the same talking points day after day, we are adapting to a changing world, and we are building a strong Canada for all Canadians. The Honourable Member for Beauce. Mr. Speaker, in Beauce, 1 + 1 is 2, not -10, as like if the Liberals were doing the math. And this kind of spending is having devastating consequences for Canadians. More taxes, more Liberal inflation, more interest. That interest will be $3,400 per family per year. While the Liberals pile up the deficits, the costs of all sorts of essential things like housing and gas are just going up. And once again, people in Beauce are paying the price for this disastrous mismanagement. Again, I'm asking, is there any limit to Liberal spending? The Honourable Parliamentary Secretary. Mr. Speaker, the Conservatives have been very clear about their austerity program, but I would still like to know exactly what programs they wish to cut. Do they want to cut our agreement with Quebec, $1 billion for infrastructure? Do they want to cut the investments in the Port of Montreal or the Contrecoeur port? Or do they want to cut the money that we just announced to help people who are in a vulnerable situation? I hope we can get answers. We've been waiting for quite a while. Thank you. The Honourable Member for Richmond Arthabaska. Mr. Speaker, we've had 11 years of this Liberal government, and what's the result? More taxes, more debt, more spending on the national credit card, and more regulations. A chief economist at the National Bank has told us that Ottawa has now added 320,000 new regulations to Canadian businesses. 320,000. And this is at a time when the U.S. is deregulating. And what's the result? Layoffs and plant closures. When will the Prime Minister finally understand that with more regulation, there are more costs for businesses, and once again, Canadians are paying the price? The Honourable Secretary of State, Nature. We are taking action. Mr. Speaker, we are taking action to simplify government operations and also to simplify the relationship between Quebec City and Ottawa. To reduce red tape, we are taking action, we are going to do that, and we are also working hard on issues that affect people every day. The grocery benefit, the various programs we have for children and seniors. We're doing all this to support Canadians during a difficult time. We're doing that, and we hope that our colleagues will cooperate.
The member for Richmond-Arthabaska. Mr. Speaker, it's a very sad state of affairs. Since January, factory closures have been rising. On top of losing their jobs, Canadians are paying the Liberals' credit card bills. There's a company called Savoura. It pays $2.5 million a year in carbon tax and in fines for environmental non-compliance. Surtaxes for growing tomatoes, surtaxes that make it difficult to compete with tomatoes from Mexico that have traveled across the continent. Instead of creating yet another form of corporate band-aid, why not fix the regulations and give our businesses some real breathing room? The Honourable Parliamentary Secretary to the Minister of Industry. Mr. Speaker, Quebec's businesses and Canada's businesses are struggling. What causes these difficulties, though? The tariff war, the unjustified, unfair, counterproductive tariffs that the United States is imposing on Canadian businesses. That's why we need to help businesses. That's why we're supporting businesses, and we are spending what needs to be spent to keep businesses afloat, Mr. Speaker. The Honourable Member for Chicoutimi-Lafjord. Mr. Speaker, don't be fooled. With this Liberal Prime Minister, what we have is more spending, more taxes, more debt, and more on the national credit card. It's always the same old story. He's just another costly Liberal. The Liberal debt has risen to $1,475 billion. Meanwhile, according to the Journal de Montréal, 1 in 3 Quebecers is going into debt just to be able to eat. When will the Prime Minister take the situation seriously and stop his credit card budgets? The Honourable Parliamentary Secretary. Mr. Speaker, the colleague is correct about the debt amount, but it's 41% from the private sector. It's one of the most manageable debt levels in the G7. But here's my question to my colleague. What would he cut? What programs would his party cut? Would they cut old age security? Would they cut the Canada Child Benefit? That's $8 billion, the Canada Child Benefit. So what would they cut? Please tell us. The member should speak through the chair.
For Sackville, Bedford, Preston. No? Okay. The honourable member for...
The honourable member for Orleans. Mr. Speaker, Canada's mission in Afghanistan was the most important military deployment in Canada since the Second World War. From 2001 to 2014, over 40,000 Canadians served with great courage and sacrifice. We honor them. We honor the memory of the 158 military personnel and civilians who passed.
Minister of Veterans Affairs explained why today's groundbreaking ceremony for the National Monument to Canada's mission in Afghanistan is important, and what she hoped this day will mean to CAF members, veterans, families, and Canadians.
The Honourable Minister of Veterans Affairs.
Mr. Speaker, I thank all of my colleagues that were able to join us a short time ago for today's groundbreaking ceremony at the site of the National Monument to Canada's mission in Afghanistan. This is a long overdue step in ensuring that the service and sacrifice of Canadians, notably the 158 Canadian Armed Forces members and the 7 civilians who gave their lives, are remembered. This monument will serve as a place of solemn reflection, remembrance, and learning for generations to come. A place where Canadians can better understand the contributions made in pursuit of peace, security, and human dignity. For all Canadians, this day is an opportunity to come together in gratitude, to honor those who have served, and to reaffirm.
The Honourable Member for Simcoe North.
Mr. Speaker, it's a new week in Ottawa, but the Prime Minister is on international travel back in Europe again. But we already have a free trade deal with Europe. But there is one thing our allies have been asking us for, and that is Canadian liquefied natural gas. Now, one would go to Europe to make a big announcement. So will the Minister confirm that the Prime Minister is indeed in Europe to announce on what date our allies can accept?
You know, I don't think the member is alluding to a specific time when the Prime Minister would be might be leaving for Europe, but we have to be careful not to. We have to be careful. I don't think this. This is really trying to do indirectly what we're not supposed to do directly. But I'll see if anyone wants to take that question. Apparently not. The honourable member. The honourable second question. The honourable member for Simcoe North.
Well, Mr. Speaker, what is the purpose of all the travel and the meetings and the MOUs if there's nothing tangible to show for it? The Europeans have repeatedly asked for Canadian liquefied natural gas. Now, they probably would like to invest in a port or a pipeline to get Canadian energy to Europe. We don't need speeches, we don't need MOUs, we don't need summits, and we don't need a government-run hedge fund. We need investable projects to get Canada's energy to the world.
That's right.
So will the minister announce on which date Canadian LNG will make it to the shores of Europe?
Hear, hear. The Honourable Minister of Energy.
Mr. Speaker, what I can tell the member opposite is we have European governments contracting with LNG facilities today to buy LNG from Canada. And we just saw Shell, a European company, invest $20 billion into Canada because they want to build more LNG here. So maybe they could read the papers.
The honourable member for Calgary-Midnapore.
Mr. Speaker, behind all the talk, this Prime Minister is just another Liberal. He's more expensive, more anti-resource, more misleading. He is well aware that Canada already has free trade agreements with Europe. Those are all in place. What we need is for him and his government to just get out of the way and stop blocking our biggest export. He said we would build at speeds never seen before, but so far, our biggest exports under this government are speeches, handshakes, and photo ops. So does the Prime Minister know when the first shipment of Canadian LNG will arrive in Europe?
The Honourable Government House Leader.
As my colleague, the Minister of Energy and Natural Resources, just said, there is currently liquefied natural gas leaving Canada, hundreds of millions of dollars worth, that does what? Employs Canadians, that gives royalties to governments, that involves Indigenous participation, and that goes with the hundreds and billions of dollars of other major major projects currently being constructed in Canada. We're building big, we're building with Canadians, and we're going to build Canada strong, Mr. Speaker.
The honourable member for Calgary-Midnapore.
Well, Mr. Speaker, let's deal in facts. Fact, the Prime Minister hasn't signed any new free trade deals. He signed empty, non-binding MOUs and burned taxpayer dollars to jet around the world for his chief export, hot air. Fact, Canadians need results, not illusions. They need tariffs dropped and the Prime Minister to keep his promise to protect Canadian jobs. Fact, Europeans have been pleading for a secure and stable source of energy. So while the Prime Minister is overseas, will he tell us when his new pipeline will deliver LNG to Europeans? Just the date.
The Honourable Government House Leader.
Well, the member may have missed the news last week, Mr. Speaker, where $4 billion of capital from Enbridge, including over 10% Indigenous participation, will go to put shovels in the ground this summer on what? A natural gas pipeline, Mr. Speaker, that goes to what? An LNG plant, Mr. Speaker, that goes to where? World markets, Mr. Speaker, creating jobs and wealth and opportunity for Canadians all over this country, Mr. Speaker.
The honourable member for Aurora Oak Ridges, Richmond Hill.
Mr. Speaker, the Minister of Immigration bungled a simple decision to stop a known IRGC terrorist from entering our country. And Canadians still don't have clear evidence that he was actually stopped and turned back. There are reports, in fact, that say he actually just turned himself around and left the country. The Liberals are keeping the Minister from answering questions because they're concerned about what she'll say next. Now, everyone is wondering why the Prime Minister is protecting the Minister and not letting her answer questions. Can he tell Canadians, please, why she still has a job?
The Honourable Minister of Public Safety.
Mr. Speaker, ensuring the safety and security of Canadians is our top priority. I want to assure all Canadians that Canada has rigorous admissibility requirements, and we have been very clear that IRGC members and all senior Iranian officials are inadmissible to Canada. And if they're already in Canada, Mr. Speaker, they will go through a removals process expeditiously. We will continue to work with our border immigration and law enforcement agencies to ensure the safety and security of all Canadians.
Honourable member for Richmond Hill South.
This Liberal immigration minister says she is, quote, accountable but not responsible for dropping the ball when letting terrorists into Canada. Letting in a known terrorist should have set off every alarm bell in this Liberal government. And yet, just last week, the visitor permit of an Iranian regime-linked individual was specifically exempted, and his entry into Canada was rubber-stamped under this Liberal minister's watch. A simple Google search could have stopped this. Worse, this Liberal Prime Minister is letting her keep her job. Does that mean the Prime Minister is responsible but not accountable for the failures of his Liberal immigration minister?
Hear, hear. The Honourable Minister of Public Safety.
Mr. Speaker, I want to assure all Canadians that no IRGC member was admitted into Canada, Mr. Speaker, and our government has been clear that IRGC members and all senior officials of the Iranian government are inadmissible to Canada. We have rigorous processes in place to ensure that anyone in the country that has ties to the IRGC go through a removals process. We will continue to work with our border immigration and law enforcement agencies to ensure the safety and security of all Canadians.
The honourable member for Niagara South.
Mr. Speaker, the media panels have given up on this immigration minister. Bob Fife, the bureau chief of the Globe and Mail, called her performance pathetic and called her incompetent, twice in the same panel. Even CBC's David Cochrane said, when they fall back on privacy, process, and the passive voice, it's usually the sign of some trouble. Immigration is a serious issue, and the Prime Minister is ultimately accountable for her failures. When will the Prime Minister finally take responsibility and fire this minister?
The Honourable Minister of Immigration, Refugees and Citizenship.
Thank you very much, Mr. Speaker. I appreciate the love from the other side. I know they know that we are restoring control, balance, and sustainability and integrity to our immigration system. The facts show this. We have new express entry categories to grow our economy. We've strengthened our rural immigration pathways. We're facilitating work permits to researchers and PhD students. We've surpassed our Francophone immigration targets. We have just, the list can go on. We've 5,000 additional physicians to come to practice in Canada.
The honourable member for Saskatoon West.
Wow, I didn't know we had express entry for terrorists. Mr. Speaker, it's clear that everyone has lost faith in this Minister of Immigration to oversee even the simplest parts of her job. This is the 7th Liberal immigration minister, and Conservatives knew from day one that she would make the mess worse. The media are now calling for this minister to be removed. Liberal MPs have called for this minister to be removed. This is now about the Prime Minister's own judgment. She says she meets with the Prime Minister every week. He seems oblivious to this mess that she has created. Will the Prime Minister end this national embarrassment and fire this immigration minister?
The Honourable Minister.
Thank you very much, Mr. Speaker. Let me continue with my list because I think I need a couple of hours for that. We're bringing our numbers down. We're strengthening oversight. We have an action plan that restores integrity to our immigration system. CBSA has removed 22,000 people last year from the country.
Right.
We brought in C-12, which they opposed in the beginning, but saw the light at the end. That will further give us additional security in the place. We have the foundation. I've also put in place the foundation of an exit tracking system that Canada needs in this country.
The honourable member for Calgary Nose Hill.
Well, today the minister said she would continue issuing tens of thousands of new foreign student permits in spite of millions of non-citizens being in Canada on expired or expiring permits. Her admission that the Liberals have absolutely no way to track whether or not they've left, and fraud still running unchecked in her department, like they can't detect it. When asked what the Prime Minister thought of the failures in committee, the minister claims she has weekly meetings with him and that she talks to him all the time. So that begs the question, does the Prime Minister actually think she's doing a good job?
The Honourable Minister.
Monsieur le Président, parlons.
Mr. Speaker, let's talk about the facts. If you compare the two first months of 2026 to the first 2 months of 2024, asylum claims are down 2/3. Arrivals of temporary residents are down over 70%. We are getting back the control over the system and the viability of the immigration system. The facts are improving, and Canadians can see that.
For Oakville West.
It was great to spend this weekend with all firefighters. With winter ending, we are reminded of the risk of wildfires like the one at Bronte Provincial Park in 2021. And with warmer weather, we are already sadly seeing many communities impacted by flooding. As emergencies have become more frequent, more severe, and more costly, can the Minister of Emergency Management and Community Resilience let us know what work is ongoing to prepare for the upcoming wildfire and flooding seasons to keep Canadians safe?
Good question. Minister of Emergency Management and Community Resilience.
Thank you, Mr. Speaker. It's Emergency Preparedness Week, and this year's theme is Be Prepared, Know Your Risks. Our government is showing leadership by strengthening our emergency preparedness and response capacity. We've increased our aerial firefighting capacity. We're improving federal emergency coordination through our new Government Operations Center. And just this morning, I announced the renewal of the Humanitarian Workforce Program. We're ready and we're focused on keeping Canadians safe.
The honourable member for Langley Township, Fraser Heights.
The Prime Minister claims that his Liberal government protects private property rights and that they will appeal the Cowichan decision. But here's the problem. The Liberals dropped the argument at trial that private property rights come first, making it easier for the trial judge to conclude, and I quote, Aboriginal title is a prior and senior right to land, close quote. So how can the Prime Minister now argue that say that they will argue on appeal the very opposite, that private property rights come first, when they didn't raise it at trial?
The Honourable Minister for Crown Indigenous Relations.
Thank you, Mr. Speaker. Private property rights are fundamental, and our government will always defend them. We disagree with the BC Supreme Court's ruling in the Cowichan case, and we appealed it back in September. Any agreement on Aboriginal title at the federal level has always and will always protect private property. The federal government has been signing agreements with First Nations since the 1970s. No agreement between the federal government and First Nations has ever led to Canadians losing their privately owned land. Our government will continue to advance reconciliation and protect the private property rights of Canadians.
There's a bit of commotion at the back of the House. The honourable members, I don't know what exactly is being said. I can't hear, but I do know that there is commotion. There is commotion when there really shouldn't be. Okay, I please, colleagues. Okay, are we ready? We're ready to get back to it? Okay. The honourable member for Haliburton, Kawartha Lakes. Colleagues, colleagues. Colleagues, we have to move on. We have to move on. The honourable member from Haliburton, Kawartha Lakes has a question.
We want to hear it. Speaker, in 2018, the Liberals and the NDP in British Columbia made a deliberate decision to instruct their lawyers not to defend private property rights in the Cowichan case. Now, years later, that same case is before the courts on appeal, and the government finds itself unable to make the very argument that Canadian homeowners expect, that their private property rights come first. So how does the Prime Minister expect to win on appeal with an argument, the protection of private property rights within the city of Richmond, with an argument he isn't able to make?
The Honourable Minister of Justice.
Mr. Speaker, it's important that we correct the factual record. Since 2017, the federal government has been asking the court to notify private landowners of the case so they may participate. More recently, Mr. Speaker, we've decided to support the Montrose application, which is all about the rights of private property owners, which will allow them to potentially advance arguments that they were not able to make at trial. We are able to walk down the path of reconciliation and protect the rights of private property owners at the same time. Our next argument will be presented when we appeal the decision because we disagreed with the Superior Courts. I hope all members in the House can move forward with the full appreciation of the federal government's position when it comes to the protection of property rights in British Columbia and across the country.
The honourable member for Similkameen, South Okanagan, West Kootenay.
The Cowichan decision has left many residents across our communities concerned about their private property rights. The Liberals are now talking about how they'll defend property rights in court, but they never made this argument in Cowichan before. Appeals are not do-overs. They can't raise new arguments they never argued before. So how will the government lawyers argue what Liberal MPs argue here when they didn't do so at trial?
The Honourable Minister for Crown Indigenous Relations.
Thank you, Mr. Speaker. Preserving the certainty and stability of private property is of utmost importance, and that is why we will advance all viable legal arguments to protect private property. We disagree with the BC Supreme Court's ruling, and that's why we appealed it back in September. We're fully committed to ensuring stability, certainty, and confidence for Canadians who own property while advancing reconciliation. We will continue to pursue this matter where it belongs, in the courts, not on the floor of the House of Commons.
The Honourable Member for Winnipeg South Centre.
Mr. Speaker, on November 21st, 1919, the iconic Golden Boy was hoisted atop the Manitoba Legislative Building, and it points north to signal the prosperity of the region. Mr. Speaker, can the Minister of Arctic and Northern Affairs update this House on the ways in which the federal government is allowing the region to realize that potential? Thank you, Mr. Speaker.
The Honourable Minister for Northern and Arctic Affairs.
Thank
Thank you, Mr. Speaker. I thank my colleague for that important question. Mr. Speaker, the Port of Churchill Plus is a transformative opportunity to connect Manitoba and Western Canadian exports to the world. While early stages mean more work is ahead, the federal government has invested $320 million since 2017, and we're also looking to invest another 150, as you know, to the Port of Churchill and the Hudson's Bay Rail Line. This is to grow northern trade. It will also invest in lowering costs for farmers. It'll stabilize supply chains and support good jobs. So this is how we're making Manitoba a global Arctic gateway once again.
The honourable member for Nanaimo, Ladysmith.
These Liberals have painted themselves into a corner, Mr. Speaker. They failed to negotiate a treaty with Cowichan tribes, so they got sued and lost in Richmond. Now the Prime Minister says he'll advance viable legal arguments to protect private property. But they told their lawyers not to argue the primacy of property rights at trial, and by now it must have dawned on them that an argument not advanced as trial is not viable on appeal, because the Minister just told us he's asking private property owners to do their work for them. And they talk about negotiation, but the failure to negotiate is how we got here in the first place. So what are they going to do, Mr. Speaker?
The Honourable Minister of Veterans Affairs.
Mr. Speaker, let's be clear. The Conservatives are creating uncertainty and fear.
Right.
They are intentionally scaring Canadians, creating uncertainty for investors, and demonizing government. Our government has appealed, and we will continue to defend private property rights in Canada. Mr. Speaker, I'd remind the Conservatives...
Sorry. It's getting a little too noisy. We're getting a little too noisy. Let's take a short break, and then we'll allow the minister to continue. This is a very important issue. The Honourable Minister of Veterans Affairs.
Mr. Speaker, I'd remind the Conservatives that real leadership means actually working to address problems, not fear-mongering for political gain. Real leadership is respecting the Constitution, respecting the courts, and respecting the work of advancing reconciliation.
The Honourable Member for Rosemont-La Petite Patrie. Despite promises that have been made, people are struggling to make ends meet, especially in Montreal. In fact, according to the Institut de Recherche et d'Information Socio-Économique Research Institute, Montreal is the most expensive city in Quebec. For a family of 2 adults and 2 children in Montreal, a livable income is $88,800 after tax. A livable income means being able to meet basic needs with a little extra for unexpected expenses. That's all. But that's not the case for thousands of families. Instead of helping their billionaire friends, when will the Liberals finally take action to ensure that everyone can live with dignity?
Monsieur le Président.
The Honourable Government House Leader. Mr. Speaker, dental care, pharmacare, the school food program, enhancing old age security benefits. Mr. Speaker, the Canada Child Benefit is and will always be there for those who need it the most. And we will always be there for those who need help to make ends meet at the end of the month. The real question, Mr. Speaker, is when will all members in this House fully collaborate with us on that measure, because the Conservatives are always against it?
Being
3:09, we will now move to recorded divisions.
Rappel au règlement.
Point of order.
For Kelowna, let's see. The Honourable Member for Okanagan Lake West, South Kelowna.
Thank you, Mr. Speaker. The Minister of Employment, in response to the member for Calgary Forest Lawn, was clearly reading off notes that had his picture on both sides, clearly making it a prop, making it very easy to be seen on the screen. Mr. Speaker, it's something I think you need to take a look at. It is obviously a planned practice by the government, by that minister, to again present, as she made her comments, giving the example of had the clear photo on there. That is a prop. It is not following the traditions of this place. Not acceptable.
I just saw the minister reading from notes, and I don't know what was on the back of it, to be honest. We'll have a look. We'll have a look at the. We'll have a look at the video. The honourable, and we'll get back to the House if need be. The honourable Chief Opposition Whip.
Mr. Speaker, I would ask that the minister now table those documents in the House. When you look at the video screen, Mr. Speaker, what we see is Conservative members of Parliament headshot, including personal information detailed about that individual, not only their contact information, but what appears to be personal information about the members. Mr. Speaker, I believe that the minister has a collection of these with different members of Parliament's personal information that's now being broadcast on television. I'd ask that the member now table her question period binder.
And I will look at the tape. Does the Honourable Minister of Jobs and Families wish to stand up and say something?
Mr. Speaker, I'm happy to share with the members opposite the number of projects in the riding, the number of people that have received early learning child care, the number of people that have received dental care, the number of people that are getting fed in schools. That's the information on these sheets, Mr. Speaker, by province, by MP, and I will stand up for our record any single day.
The Honourable Chief Opposition Whip.
Mr. Speaker, I believe that what the minister has just agreed to is tabling those documents here in this House. I believe that that is what the minister said. She is standing. She has the documents there. They have the personal information of many members of Parliament on this side of the House. This is a breach, I believe, of the privacy of those members. She's now leaving the chamber with that document in her hands. I'd ask, Mr. Speaker, that you collect those documents.
I will look at the tape. I'll look at the tape and see what we can see.
The honourable member for Mégantic, l'érable Le Bignan. Thank you very much, Mr. Speaker. Mr. Speaker, during question period today, the government avoided answering a question from the member for Simcoe North. Mr. Speaker, the question was legitimate. Please give me an opportunity.
C'est un point de débat.
That's a point of debate. I cannot force the hand of anyone to answer anything.
Rappel au règlement.
Point of order. Go ahead.
Les coutumes de cette chambre.
The customs of this House are such that ministers must reply to questions asked by members of the opposition. It would seem, Mr. Speaker, that no minister chose to answer a clear question. It is a tradition when the question is in order. I found the question to be out of order in its form. Any further points of order? It being 3:15, the House will now proceed to deferred recorded division on Mr. Poilievre. A motion on the business of supply. Call in the members.
The question is as follows. Mr. Poilievre, seconded by Ms. Landsman, moved that given that one, sovereign wealth funds must have wealth that comes from budget surpluses and resource revenues. May I dispense? No. Okay. Two, that this government has run no surpluses, only deficits for the last 11 years and has no funds to invest. Three, the Prime Minister is proposing to put his $25 billion fund on the national credit card, which will cause further inflationary pressure. Four, the Prime Minister has already created 12 new Crown corporations, agencies, and bureaucracies. Five, when government directs capital, it always goes to the potential politically powerful and not the deserving. Six, there is over $1 trillion in pension fund money that Liberals have pushed out of Canada that we could bring back with faster permits, lower taxes, and free enterprise. Seven, the rising cost of fuel and food is already burdening hard-working Canadians who cannot afford to pay more for handouts to Liberal insiders and corporate elites. Therefore, the House call on the government to abandon this sovereign debt fund. La période de 10 minutes.
The 10-minute period for members voting electronically has started, and the House will now proceed to the vote for members participating in person. All those in favour of the motion will please rise.
Mr. Schmale.
Mr. Schmale.
Mr. Brock.
Mr. Brock.
Mr. Bazan.
Mr. Bazan.
Mr. Dentel.
Mr. Deltel.
Mr. Paulus.
Mr. Paulus.
Ms. Lewis Haldeman Norfolk.
Ms. Lewis Haldeman Norfolk.
Mrs. Kuzi.
Mrs. Kuzi.
Mr. Barlow.
Mr. Barlow.
Mr. Chambers.
Mr. Chambers.
Mr. Albus.
Mr. Albus.
Mr. Caputo.
Mr. Caputo.
Mr. Richards.
Mr. Richards.
Mr. Brassard.
Mr. Brassard.
Mr. Moore.
Mr. Moore.
Mr. Beltud.
Mr. Berthold.
Mr. Workington.
Mr. Workington.
Mrs. Cramp-Nyman.
Mrs. Cramp-Nyman.
Mr. Morin.
Mr. Morin.
Madame Vien.
Madame Vien.
Monsieur Godin.
Monsieur Godin.
Monsieur Martel.
Monsieur Martel.
Mr. Cooper.
Mr. Cooper.
Mr. Van Popta.
Mr. Van Popta.
Mr. Kelly.
Mr. Kelly.
Monsieur Généreux.
Monsieur Généreux.
Monsieur Gould.
Mr. Gould.
Mr. Steinley.
Mr. Steinley.
Mr. Zimmer.
Mr. Zimmer.
Mr. Baldinelli.
Mr. Baldinelli.
Mr. Davidson.
Mr. Davidson.
Mr. Muse.
Mr. Muse.
Mr. Waugh.
Mr. Waugh.
Mr. Ho.
Mr. Ho.
Mr. Hardy.
Mr. Hardy.
Mr. Majumdar.
Mr. Majumdar.
Mrs. Goodridge.
Mrs. Goodridge.
Mr. Bragdon.
Mr. Bragdon.
Mr. Arnold.
Mr. Arnold.
Monsieur Malad Kapaskasing Timmins Mushkagawak.
Monsieur Malad Kapaskasing Timmins Mushkagawak.
Monsieur Lefebvre.
Mr. Lefebvre.
Mrs. Gallant.
Mrs. Gallant.
Mr. Allison.
Mr. Allison.
Mr. Diot.
Mr. Diot.
Mr. Macaulay.
Mr. Macaulay.
Mr. Menegakis.
Mr. Menegakis.
Mrs. Wagenthal.
Mrs. Wagenthal.
Mrs. Jansen.
Mrs. Jansen.
Mr. Abu Taif.
Mr. Abu Taif.
Mr. Motz.
Mr. Motz.
Mr. Dowdle.
Mr. Dowdle.
Mr. Cram.
Mr. Cram.
Mr. McLean Calgary Centre.
Mr. McLean Calgary Centre.
Mr. Tolmie.
Mr. Tolmie.
Mr. Patzer.
Mr. Patzer.
Monsieur Groslo.
Monsieur Groslo.
Mrs. Anstey.
Mrs. Anstey.
Mr. Au.
Mr. Au.
Mr. Bexty.
Mr. Bexty.
Mr. Bonk.
Mr. Bonk.
Ms. Kobania.
Ms. Kobania.
Mrs. Cody.
Mrs. Cody.
Mr. Davies, Niagara South.
Mr. Davies, Niagara South.
Mr. Gill, Calgary Skyview.
Mr. Gill, Calgary Skyview.
Mr. Gill, Brampton West.
Mr. Gill, Brampton West.
Mr. Gill, Calgary McKnight.
Mr. Gill, Calgary McKnight.
Mr. Gill, Windsor West.
Mr. Gill, Windsor West.
Mr. Leslie.
Mr. Leslie.
Mr. Kimmich.
Mr. Kimmich.
Mr. Holman.
Mr. Holman.
Mr. Jackson.
Mr. Jackson.
Mr. Kibble.
Mr. Kibble.
Mrs. Kirkland.
Mrs. Kirkland.
Mrs. Conans.
Mrs. Conans.
Ms. Cronus.
Ms. Cronus.
Mr. Mahal.
Mr. Mahal.
Mr. Mantle.
Mr. Mantle.
Mr. McKenzie.
Mr. McKenzie.
Mr. Reynolds.
Mr. Reynolds.
Mr. Rowe.
Mr. Rowe.
Mr. Stevenson.
Mr. Stevenson.
Madame Normandin.
Madame Normandin.
Monsieur Champoux.
Monsieur Champoux.
Monsieur Savard-Tremblay.
Monsieur Savard-Tremblay.
Madame Larouche.
Madame Larouche.
Madame Gaudreau.
Madame Gaudreau.
Monsieur Beaulieu.
Monsieur Beaulieu.
Monsieur Blanchet-Jonca.
Monsieur Blanchet-Jonca.
Monsieur Lemire.
Monsieur Lemire.
Ms. May.
Ms. May.
All those opposed to the motion will please rise.
Monsieur McKinnon-Gatineau.
Monsieur McKinnon-Gatineau.
Mr. Ali.
Mr. Ali.
Madame Diab.
Madame Diab.
Mr. McGinty.
Mr. McGinty.
Ms. Thompson.
Ms. Thompson.
Madame Michel.
Madame Michel.
Ms. Olszewski.
Ms. Olszewski.
Mr. Solomon.
Mr. Solomon.
Mrs. Valdez.
Mrs. Valdez.
Ms. Gould.
Ms. Gould.
Madame Petitpas-Taylor.
Madame Petitpas-Taylor.
Mr. Wilkinson.
Mr. Wilkinson.
Ms. Fry.
Ms. Fry.
Ms. Jacek.
Ms. Jacek.
Mr. Fragascatos.
Mr. Fragascatos.
Madame Provo.
Madame Provo.
Ms. Sahota.
Ms. Sahota.
Mr. Belanger, Desnethy, Mississippi, Churchill River.
Mr. Belanger, Desnethy, Mississippi, Churchill River.
Ms. Chartrand.
Ms. Chartrand.
Mr. Gerritsen.
Gerritsen.
Ms. Alty.
Ms. Alty.
Mr. Sarai.
Mr. Sarai.
Mr. Long.
Mr. Long.
Madame Chenette.
Madame Chenette.
Ms. Latencio.
Ms. Latencio.
Mr. Nakfi.
Mr. Nakfi.
Mr. Housefather.
Mr. Housefather.
Ms. Scrow.
Ms. Scrow.
Mr. Fisher.
Mr. Fisher.
Mr. Dollywall.
Mr. Dollywall.
Mr. Biddle.
Mr. Biddle.
Mrs. Romanato.
Mrs. Romanato.
Mr. Lewis Kitchener-Conestoga.
Mr. Lewis Kitchener-Conestoga.
Monsieur Leitao.
Monsieur Leitao.
Mr. Bardisi.
Mr. Bardisi.
Madame Kayabaga.
Madame Kayabaga.
Mr. Lamoureux.
Mr. Lamoureux.
Madame Brière.
Madame Brière.
Mr. Turnbull.
Mr. Turnbull.
Mr. Kellaway.
Mr. Kellaway.
Monsieur Gay.
Monsieur Gay.
Mr. Hogan.
Mr. Hogan.
Ms. Chi.
Ms. Chi.
Mr. Miles.
Mr. Miles.
Ms. Zarowitz.
Ms. Zarowitz.
Monsieur Elkoury.
Monsieur Elkoury.
Monsieur Fergus.
Mr. Fergus.
Mr. Fonseca.
Mr. Fonseca.
Mr. Maloney.
Mr. Maloney.
Madame Desrochers.
Madame Desrochers.
Mr. Gasparo.
Mr. Gasparo.
Mr. Casey.
Mr. Casey.
Madame Bendayan.
Madame Bendayan.
Mr. Clausen.
Mr. Clausen.
Monsieur Ramsey.
Monsieur Ramsey.
Ms. Church.
Ms. Church.
Mr. McKinnon, Coquitlam, Port Coquitlam.
Mr. McKinnon, Coquitlam, Port Coquitlam.
Mr. Morrissey.
Mr. Morrissey.
Mr. Sheehan.
Mr. Sheehan.
Ms. Vandenbeld.
Ms. Vandenbeld.
Mrs. Zaid.
Mrs. Zayed.
Ms. Yip.
Ms. Yip.
Monsieur d'Entremont.
Monsieur d'Entremont.
Madame Lalonde.
Madame Lalonde.
Mr. Pulowski.
Mr. Pulowski.
Madame Lapointe, Rivière des Mille-Îles.
Madame Lapointe, Rivière des Mille-Îles.
Mr. Baines.
Mr. Baines.
Ms. Hefner.
Ms. Hefner.
Ms. Idlout.
Ms. Idlout.
Madame Lapointe Sudbury.
Madame Lapointe Sudbury.
Mr. Sousa.
Mr. Sousa.
Ms. Akan.
Ms. Akan.
Mr. Al Saoud.
Mr. Al Saoud.
Madame Auguste.
Madame Auguste.
Mr. Chang.
Mr. Chang.
Mr. Clark.
Mr. Clark.
Mr. Connors.
Mr. Connors.
Madame Dondurant.
Madame Dondurant.
Mr. Danko.
Mr. Danko.
Mr. Deschênes-Thériault.
Mr. Deschênes-Thériault.
Mr. Earl.
Mr. Earl.
Ms. Fancy.
Ms. Fancy.
Mr. Fanjoy.
Mr. Fanjoy.
Mr. Greaves.
Mr. Greaves.
Ms. Harrison.
Ms. Harrison.
Ms. Hurtle.
Ms. Hurtle.
Mr. Joseph.
Mr. Joseph.
Monsieur Lavoie.
Mr. Lavoie.
Mr. Ma.
Mr. Ma.
Mr. McDonald Cardigan.
Mr. McDonald Cardigan.
Mr. Mallet Bay of Quinty.
Mr. Mallet Bay of Quinty.
Ms. Miedema.
Ms. Miedema.
Madame Mingarelli.
Madame Mingarelli.
Ms. Nathan.
Ms. Nathan.
Ms. Wien.
Ms. Wien.
Mr. Tumba.
Mr. Tumba.
Ms. O'Rourke.
Ms. O'Rourke.
Mr. Rana.
Mr. Rana.
Ms. Royer.
Ms. Royer.
Mr. Saini.
Mr. Saini.
Monsieur Sari.
Mr. Sari.
Mr. Sawatsky.
Mr. Sawatsky.
Ms. Sodi.
Ms. Sodi.
Monsieur St. Pierre.
Mr. St. Pierre.
Ms. Tesser Dirksen.
Ms. Tesser Dirksen.
Monsieur Villeneuve.
Mr. Villeneuve.
Monsieur Watchorn.
Mr. Watchorn.
Ms. Begum.
Ms. Begum.
Ms. Martin.
Ms. Martin.
Mr. Johns.
And Mr. Johns.
La Chambre attendra maintenant la fin de la...
The House will now wait for the electronic voting period to end before resuming its proceedings. I wish to inform the House that the electronic voting period has ended. If members were not able to vote due to technical difficulties, they may now use the raise hand function, and the chair will recognize them.
Madame Khalid.
Thank you, Mr. Speaker. I just wanted to make sure that my vote was counted. I encountered some challenges with my app.
Counted, apparently. Le bureau va maintenant...
The table will now compile the results of the vote.
Yeas pour 160, 160. Nays contre 175, 175.
Je déclare la motion rejetée.
I declare the motion defeated.
Do the extension thing. But defense.
Mr. Speaker, pursuant to Standing Order 83-1, I would like to table in both official languages a notice of Ways and Means motion to introduce a bill entitled A Second Act to Implement Certain Provisions of the Budget, tabled in Parliament on November 4th, 2025. Pursuant to Standing Order 83-2, I would like to request that an order of the day be designated for the consideration of this motion. Thank you, Mr. Speaker.
Hear, hear. L'honorable député de Saint-Hyacinthe-Bagot-Acton.
The honourable member for Saint-Hyacinthe-Bagot-Acton. Mr. Speaker, I am rising today to speak to the question of privilege raised in the House last Thursday by the member for Peace River Westlock regarding the fact that the annual report of the Canadian Ombudsman for corporate responsibility are not tabled. I would like to state that, first of all, this is about the basic principle that is at stake here. The fact that members of this House need to be properly informed in order to be able to monitor government activities. The Ombudsman, the Canadian Ombudsperson for Responsible Enterprise, is a position that was created in order to consider complaints having to do with possible breaches of rights having to do with Canadian businesses' activities abroad, especially in the mining, oil, and gas sectors. This is an independent organization because Parliament has recognized that these issues require credibility, transparency, and distance from the executive. The Ombudsperson's annual reports are the main mechanism that would enable that independence to be verifiable. They are supposed to inform Parliament about the nature of the complaints, about the sectors and regions, and how the reviews are being carried out, and propose recommendations. Without these reports, the House does not have essential information about these complaints about Canadian businesses abroad. There are a number of issues that are often raised about international supply chains. Child labor is one of these issues. International organizations and nonprofits and even the UN have documented serious allegations of child labor in some mining contexts abroad. And when there's a complaint of this nature that is made against a Canadian business, these allegations need to be looked at. These are about allegations that are being looked at by an arm's-length organization. These are not legal conclusions. And indeed, the Ombudsperson's role is to cast light on these things and make recommendations. But if these reports are not made available to the House, members cannot know if these complaints are received, they cannot know how they were dealt with, and they cannot evaluate whether the Canadian framework is adequate to prevent possible abuses. Parliament cannot debate the matter because it's not informed. The member for Peace River Westlock informed the House that the government, through the Minister of International Trade, has failed to do what it was supposed to do, not one, not two, but 3 times, 3 annual reports by the Canadian Ombudsperson for Responsible Enterprise. This is not about the content of a specific report or even of its conclusion. This is a matter of the House's fundamental right to be able to have the documents necessary to exercise its functions. The Ombudsperson position was created to serve the public interest, to help with transparency and accountability. Canadian businesses abroad need to respect the values that are dear to the hearts of members of the House of Commons and the population they represent. These annual Ombudsperson report play a key role for Parliament. They ensure that there is transparency. They enable the House to understand how these complaints having to do with possible violations of human rights abroad are dealt with. They enable parliamentarian examination of the situation without being officially tabled. Members cannot ask informed questions and propose adjustments to public policy or hold ministers accountable. These reports are supposed to describe complaints against Canadian companies who might be violating human rights abroad. These are arm's length reports of allegations, and for that very reason, Parliament needs to be able to examine how these complaints are being dealt with and what obstacles were met with and what recommendations have been made. So preventing the House from accessing these reports is to prevent it from evaluating whether the mechanisms that the government has put in place are actually working. Parliament cannot play its role properly if it doesn't get the information. When it doesn't get a report like this, that means that there's a possible breach of privilege. And that's exactly what's raising the question of privilege that we're debating today. This is about a fundamental question. The right of this House to access reports that are made to it. As the member for Peace River Westlock pointed out, there is precedent confirming that not respecting this type of obligation could be a breach of privilege. On February 5th, 1992, Speaker Fraser stated that when a document is presented, members are thus made officially aware of its existence. He underscored the fact that this is not merely an administrative formality, but rather a procedure that has a serious objective. He also underscored that tabling of documents is one of the essential mechanisms that enables members and committees to fulfill their functions. So without tabling documents, there is no mechanism to make the House formally aware of the context, no automatic referral, no committee study, and no real accountability. In conclusion, the House of Commons has decided to create this ombudsperson role in order to oversee the conduct of Canadian businesses abroad, and therefore the government also needs to respect the laws and obligations having to do with this, including parliamentary accountability. Systematic tabling of annual reports is not a formality. It's an essential basis for respecting this House, democratic transparency, and Canada's international credibility. Parliament created the ombudsperson position in order to help members hold government accountable. The minister has the obligation to table these reports, but that has not been done for 3 years. And the fact that this has not been done is a breach of parliamentary procedure, and it prevents members from doing their work. So in that spirit, I would invite the chair to seriously consider this question of privilege. Thank you.
Merci beaucoup. Je désire informer la Chambre.
I wish to inform the House that because of the recorded division, the period for government orders will be extended by a further 12 minutes. For a total of 42 minutes.
Dépôt de documents.
Tabling of documents. Introduction of government bills. Statements by ministers.
From interparliamentary delegations, the Honourable Member for Vancouver Centre.
Merci, Monsieur le Président. Conformément.
Thank you, Mr. Speaker. Pursuant to Standing Order 34.1, I have the honour to present in both official languages the following report of the Canadian delegation to the Organization for Security and Cooperation in Europe.
Parliamentary Assembly, 21st Autumn Meeting in Yerevan, Armenia, from November 18th to 20th, and the Canadian delegation to the Organization for Security and Cooperation in Europe's Parliamentary Assembly, 23rd Autumn Meeting in Istanbul, Turkey, from November 17th to 19th. Thank you, Mr. Speaker.
Presenting reports from committees, the Honourable Member for Egmont.
Thank you, Mr. Speaker. Mr. Speaker, I have the honour to present in both official languages the 9th report of the Standing Committee on Human Resources, Skills and Social Development and the Status of Persons with Disabilities in relation to Bill C-20, an act respecting the establishment of Build Canada Homes. The committee has studied the bill and has decided to report the bill back to the House without amendments.
Introduction of private members' bills. Mr. Falk, Provencher, seconded by Mr. Généreux, moves for leave to introduce a bill entitled An Act to Establish a Framework for the Continued Access to and Use of Cash in Canada and to make related amendments to other acts. The motion is deemed adopted. The Honourable Member for Provencher.
Thank you, Mr. Speaker. It's an honour to introduce the bill that establishes a national framework to protect Canadians' ability to access and use physical cash, and to ensure that no central bank digital currency can be created without the express authorization of Parliament. In recent years, digital transactions have grown rapidly, but millions of Canadians still depend on cash for daily life. Seniors, Indigenous communities, newcomers, people living in poverty, those in remote rural regions, and victims of financial or domestic abuse rely on cash because it's accessible, reliable, and safe. Cash is the only form of payment that does not depend on the internet or the electrical grid. Cash does not fail. It works every time, in every circumstance, for every person. The framework this bill establishes will ensure that cash infrastructure remains resilient. Cash protects privacy at a time when government, corporate, and financial sector data collection is expanding dramatically. It is also the only truly anonymous payment method. This bill amends the Bank of Canada Act to require parliamentary approval before a central bank digital currency can be developed or issued. This legislation ensures that future digital systems remain optional, not forced, and that Canadians retain control over their own finances. It protects privacy, strengthens resilience, and defends those who depend on physical currency. I am proud to introduce this framework on the access to and the use of cash. I urge all members to support it. Thank you.
We require a seconder who is present in the House. I don't know if the Honourable Member for Edmonton Griesbach. Okay, Mr. Falk Provencher, seconded by Mr. Diot. Carrie Diot. Moves that the bill be now read a first time and be printed. This motion is deemed adopted. When shall the bill be read?
First reading of this bill. Première lecture de ce projet de loi.
When shall the bill be read? Second. At the next sitting of the House. First reading of Senate public bills. Motions. Presenting petitions. The Honourable Member for Hastings, Lennox and Addington, Tyendinaga.
Thank you, Mr. Speaker. I am rising today to table a petition spearheaded by a constituent of mine aimed at bringing tax fairness to our Indigenous partners. This petition calls on the government to simply rectify an overlooked error in the current tax filing regime that results in the comparative overrepresentation of tax reassessment claims of Indigenous Canadians by updating and modernizing the T4 RIF, the T4 RSP, and T4AP tax slips. Update CRA contribution tracking methods, ensure efficient handling of tax-exempt returns, including those of Indigenous Canadians, and implement a team of First Nations tax specialists within the CRA. Thank you, Mr. Speaker.
For Simcoe Gray.
Thank you, Mr. Speaker. I rise today again with a petition from the good residents from Simcoe Gray that are opposed to the over-the-horizon radar system. If you can imagine for a minute, Mr. Speaker, they're going to have up to close to 4,000 acres when the project is done, when all phases, and it will be totally flat. Every farm, every house, every barn, everything knocked down, all wooded lots in the middle of a municipality. The municipality is against it, so the residents are calling for to stop the building of the over-the-horizon site on the already purchased property, prevent future acquisition of prime farmland, including building of the over-the-horizon site on the prime farmland of Clearview Township, and register the previously purchased property, which is roughly 750 acres, with the Ontario Farmland Trust to preserve its agricultural status. Thank you, Mr. Speaker.
Member for Newtecumseh, Gwillimbury.
Well, thank you, Mr. Speaker. On behalf of the people of Simcoe County, and of course to support my colleague from Simcoe Gray, we are calling on the government, because prime farmland is now under attack again. The Department of National Defense has purchased 700 acres of prime farmland overlapping wetlands, Mr. Speaker. They've also, this is on the preliminary site, they've also got a requirement potentially to purchase another 2,600 acres of prime farmland in Clearview Township. to build the over-the-horizon radar, Mr. Speaker. The petitioners are calling on the government to stop the building of the over-horizon on the already purchased property, prevent further acquisition of prime farmland that obviously Canada and Ontario relies on, register the previously purchased property with the Ontario Farmland Trust to preserve its agricultural heritage. Thank you, Mr. Speaker.
The honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. A petition on behalf of my constituents who are deeply concerned about abuses of human rights and environmental protections. This is a petition that deals with the activities of a Vancouver-based mining company, Pan American Mining. It is a silver mine called the Escobal Mine in Guatemala. Now, the Guatemalan courts interceded and instructed the mine to stop operations and adequately consult the Xinca indigenous peoples of the area. After the people said no, the mine has continued operations. The petitioners are affronted. They ask the Government of Canada to please take action. We have a vacant seat for the so-called commissioner for the Canadian ombudsperson for resource exploitation. The petitioners ask Canadian consular officials to protect Xinca land defenders, fully implement the report of the Voices at Risk and the principles of UNDRIP. Thank you, Mr. Speaker.
Questions on the order paper.
Yes, thank you, Mr. Speaker. I would ask that all questions be allowed to stand at this time, please.
Agreed. Orders of the day.
Government orders, government bills, commons, resuming consideration of the motions in Group 1 at report stage of Bill C-11, Military Justice System Modernization Act.
For Thornhill has about 2 minutes and 50 seconds left.
I'm going to continue from where I left off. The bill that we are in question now addresses the appointment process for the Canadian Forces Provost Marshal, the Director of Military Prosecutions, and the Director of Defence Counsel Services. Positions that the court justices specifically identified as needing independence from the chain of command. We also added consequences for unreasonable delays in transferring evidence. We strengthened the independence of legal actors so prosecutions are fair and impartial. We improved supports for victims, including the ability to request victim liaison officer when trust breaks down, because that, in these cases, that is very much the currency. We address the fairness for the accused, ensuring access to defense counsel, regardless of which system hears the case. And I think that is the most important change. And we included the clause for future review, because these changes must be monitored, they must be measured, and they must be revisited when it's necessary or when they don't work. Taken together, Mr. Speaker, these amendments represent a serious effort to fix what is broken and to build a system that is more responsive, more accountable, and certainly more just. But these amendments have to be approved by this House, and it seems that they're not even going to be considered. All of that work in committee, not even considered by the government. That's not really how it's supposed to work. Conservatives and the NDP and the Bloc agree that these changes are all necessary, but the government has the power to strip these amendments, and that's really what's at the crux of this conversation today. In doing so, they are going to weaken the accountability of this. They're going to ignore the voices of survivors, and they're going to remove the very improvements that the victims themselves asked this Parliament to make. We certainly hope they will reconsider, because without these changes, it is not about making life better for those who serve. It's going to be about making life better for the politicians and the bureaucrats who oversee this. And it's a very, very different thing. Mr. Speaker, the men and women in Canada's armed forces don't work 9 to 5. They serve without limit, and we owe them this in return. I urge every member of this House, including the members that now sit in the opposite benches who worked on this piece of legislation in committee, to reconsider, to stand with survivors, and to support the brave men and women in uniform today and every day in this country.
Questions and comments, questions et commentaires. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. You know, it is
disappointing in the sense that the Conservative Party of Canada has made the determination to fight this legislation, not recognizing the former Chief Justice Arbour and the phenomenal work that she did. And it's only over the last couple of weeks where we have the Conservative Party coming out against the legislation as much as it has. And I think it's, at the end of the day, we have a government that is recognized and pushing forward a number of agenda items dealing with the Canadian Forces, whether it's the 2% GDP or it's the increase in overall interest in joining the forces, 30-year high in terms of numbers of people wanting to come in, all forms of ways. We are improving the conditions of the military, and C-11 is a part of it. I wish the Conservatives would get on side.
The Honourable Member for Thornhill.
Speaker, I'm going to speak directly to the men and women in uniform who are watching this, who had a committee change this bill with the amendments that they themselves, both the survivors of sexual violence and the veterans of our military, asked for. And I want them at home to witness that the government is paving over all of those amendments, the amendments that their own members made to this legislation, where Justice or Board didn't even come to committee and they waited 11 years to bring this legislation forward. I want them to witness that they're ignoring the will of this House and the will of the members in uniform.
Questions and comments? Questions et commentaires. L'honorable député de...
The Honourable Member for Abitibi-Témiscamingue. Thank you, Mr. Speaker. I've been following the bill and its progress, but something shocking has occurred. Liberals have been incredibly arrogant because there were committee discussions, there were amendments, there were debates which honored the Justice's report, especially when it comes to getting a process in a reasonable time frame. The Bloc Québécois moved an amendment, and the majority rejected those amendments. How does my colleague feel about the fact that arrogance is so visible in a context that the Canadian population did not vote for, because it's actually because of floor crossers?
More than arrogance, I think you're seeing the beginnings of a very authoritarian streak with a manufactured majority that the Liberals now have. It is members that sit now in their benches who worked on this report. And this is just one example. They've now shut down committees in 4 different committees, going outside of cameras to have discussions that Canadians ought to know about. I think this is a bad start to a majority, and I think Canadians will start to notice.
Questions and comments? Questions et commentaires. The Honourable Parliamentary Secretary, Government House Leader.
So thank you, Mr. Speaker. And again, I would implore the Conservative parties, when the member opposite appeals to members of the Canadian Forces, I too would appeal to the members of the Canadian Forces that would be following the debate on this. And this has been a long time in coming. One of the members earlier this morning commenting on the bill saying, what's taking so long? Why isn't the government taking so long to bring forward legislation on the issue? So we are being criticized. Canada elected a new Prime Minister, a new government a year ago, and already we're advancing, as I say, a total package to reinforce how important it is that we have respect within our forces and we grow the forces, and it's going to be there. It's a part of our national security, and we have a government that's committed to advancing it. Why do the Conservative Party want us to drag our feet, whether it's this, financing of our forces, or any other measure that we propose to the House of Commons, it seems?
Woman for Thornhill.
Mr. Speaker, this report has been sitting on a shelf for 11 years. He had the chance to appeal to members of the armed forces, to give them an environment free of harassment, free of discrimination, free of abuse. He had the opportunity to appeal to them, to give them exactly what they asked for in committee, exactly how this bill was changed, exactly the amendments that are before the House. Instead, he chose not to and defend the indefensible of his own government.
Before we resume debate, I hear a lot of noise around the House. Could we ensure that those who are outside the House do not interrupt proceedings in the House? That said, I will wait another few moments because I hear conversations outside the House, and I'm certain that the Sergeant-at-Arms will ask them to be silent. And now, resuming debate, the Honourable Member for Saint-Jean. Thank you, Mr. Speaker.
I'd like to begin by going over the timeline of C11, which we are debating today. The government has passed time allocation and has undermined the thorough work done in committee by government members and opposition members in committee alike. When it comes to modernizing the military justice system, well, in the recent past, this all started with the Deschamps report about 15 years ago, and the report was absolutely scathing when it came to misconduct in the armed forces. At that time, Jonathan Vance was named Chief of the Defense Staff under a Conservative government at that time. Then, soon after that, a huge scandal broke out in February 2021. It was a scandal about Jonathan Vance. Through the media, we found out that the government had received information as soon as 2018 about sexual misconduct by him, but they kept a lid on that. Then the Chief of the Defense Staff retired in 2021, just before the scandal broke out. In April 2021, Justice Fish's report was published. It contained recommendations to clean up the Canadian Armed Forces to make it a healthier work environment. There was a lot of filibustering by Liberals in committee, but the Liberals still tried to keep secret the Vance files. But Justice Arbour was asked to do the work again, even though it had already been done. That's what she replied, that she had already done so. But she decided to go through Justice Deschamps' report and included Justice Fish's reports and published a full report with recommendations about how to improve military justice. At that point, I was a member of the Defense Committee. We hoped that one day there would be legislation to change the armed forces legal system. Now, that took a long time, but that day did finally come. In March 2024, the government finally tabled C-66, an act to amend the legal system. We thought that the bill would end up debated in the House because it was so incredibly important. We had been talking about it for a long time. It had been a long time coming, but we were waiting and waiting. We knew that the bill would end up before the committee. So the bill was introduced in the House in March, but only in September 2024 did we get to debate the bill. There was only one round of questions in committees for the main parties at the time, Liberal, Conservative, NDP, and Bloc Québécois. We sat in committee from September through December, but the bill never got back to committee. Then the Prime Minister resigned, the House was prorogued, we had a general election, and here we have C11, a new version of C66. The Liberals wasted a lot of time. Here we are with this legislation before us again, but now we're faced with a time allocation, and that is shocking. The committee did a lot of work on this bill. One thing we heard from many witnesses was in the government's decisions based on Justice Arbour's recommendations and based on the modifications to C11, one of the most important things would be to transfer from court-martial to civil court. And what we heard from most witnesses is that victims would like to be able to choose which court would hear their case. Some witnesses, some victims told us that it would be important for some to remain in the military system for reasons of delays, for reasons of not re-victimizing a victim who had already had to go through the hearing, or for reasons related to the complexity of the system or confidence in the system. So for all kinds of reasons like these, victims said that they wanted to have the choice. That's why the Bloc Québécois suggested that we find a fair balance The Bloc Québécois amendment was victims of offenses listed in any of these subsections. Anyone acting for the victim or the victim can choose whether the victim will have the case heard in martial court or in civil court. We wrote that up as a provision. We suggested that through legislative amendment that a civil court consider the nature of the offense, the circumstances under which it was committed, and other factors in deciding whether, following a victim's request, it should indeed be a court martial which should hear the case. So we had that legislative suggestion to give victims the choice. One victim might decide to go through court martial, another through civil court. We respect the victim's right to choose. Even the NDP agreed. I remember the member for Nunavut, she also tabled an amendment for victims to be able to choose which court would try or hear their case. Today, though, the government is taking advantage of its majority to totally upend the work that was done in committee. There was a vote to approve the Bloc Québécois recommendation, which was a great one. And now the member for Nunavut, who supported our amendment when she was still with the NDP, I wonder how she will vote now, if she will support it, because she also came to committee and made the same recommendation to give people free choice over which court would hear their case. And now that she's on the other side, I wonder how she will vote. There was also a Bloc Québécois proposal to create an Inspector General's office to deal with the misconduct, but we were told that that went beyond the scope of the legislation. That's what the committee chair ruled. And all members of the committee, including Liberal members at the time, decided to overrule the president's ruling, the chair's ruling, but now they're going back on that again to go back to the original version of the bill. The Bloc Québécois had another proposal so that military judges would cease to be members of the Canadian Armed Forces by default as soon as they became appointed judges, for independence reasons, so that they would still be independent. And that was a recommendation made by Quebec's bar, which came directly from the Fish report. So that recommendation is not random. The idea also to create an Inspector General's office, that was a recommendation from Michel Drapeau in committee. The committee did its work very seriously, thoroughly, and conscientiously. In committee, we heard witnesses. This bill, this legislation is for them. So I am flabbergasted to see how the government is doing things today. They extended an open hand to us after the 3 by-elections on April 13th. They said, we will consider opposition parties' opinions. We will work as a team. We will work in cooperation. But no, they've done a 180 and they've decided to unilaterally change committee composition, which in committees is supposed to be the most consensual thing in Parliament. Historically, it's been done based on consensus, but they absolutely did the opposite.
So we're not really surprised even that they did this to us, but I find it very, very sad for people who are the intended beneficiaries of this bill, victims who came to testify at committee, and now the government is telling them what you said is not enough, and we're also going to gag you as well. So, Mr. Speaker, if I was a victim today, I would be outraged by the way the government is acting, and I hope they know that. And I still hope that they will go back on their decision about our amendments, and we'll see how we will vote on this bill then, which is crucial and should have been conducted otherwise.
Comments, questions et commentaires. The Honourable Parliamentary Secretary to Government House Leader.
Yes, thank you, Mr. Speaker. And, you know, I think in terms of the background of the former Chief Justice Arbor and the work that she had conducted. We're not talking hundreds, likely going into 1,000 plus, both direct and indirect. An incredible woman who is virtually recognized for human rights beyond Canadian borders, and ultimately came up with the recommendation. I suspect in all the consultation of former CAF members, current CAF members, that she came up with a recommendation that she truly believed was in the force's best interest. That's what the legislation is putting into place. I'm wondering if the Bloc would see that maybe we should be giving her more recognition for the work that she did.
Here, great question.
The honourable member for Saint Jean. As I said, the Bloc's proposal was along the same lines of what Justice Arbor was recommending, but still taking into account of the requests of several victims heard at committee, and Justice Arbor witnessed on at 65, and her work was done 5 years ago. So it would have been interesting to hear from her again at committee, but we weren't able to ask her questions again. But as I said, the Bloc's proposal was along the same lines of Justice Arbor's recommendation, but it also allowed, in the current case, victims to have a choice, so that they could have some reflection in a nonpartisan fashion. But the government scrapped all the committees worked on this, and this is unacceptable.
The Honourable Parliamentary Secretary to Government House Leader.
Yes, thank you, Mr. Speaker. And again, I would emphasize that given the collective opposition that we're seeing today on Bill C-11, I think it was important that we advance and move forward with the legislation, given the government, in particular this new Prime Minister. Last year, Canadians elected a new government, and we made a commitment to the Canadian forces, the CAF members, whether it was hitting the 2% GDP, Mr. Speaker, whether it was reinforcing supports for the Canadian forces. We have now legislation to build upon the respect that's necessary amongst forces, CAF members, and it's starting to see results. We actually had over 7,000 people last year, a record high in 30 years, Mr. Speaker, that actually put their application in to become members of the Canadian Force. I believe we're going in the right direction. This legislation is a part of a bigger package that this Prime Minister and government is actually proposing, and I would encourage members to revisit maybe their thinking on the legislation and recognize it for what it is.
The honourable member for Saint Jean. I find that really rich to hear the government say we had to move fast, even though this has been dragging on for 11 years. They tried to put a cover on the sponsorship scandal. Well, our work at committee, since it didn't suit them, that's when they instaured the gag, and then they overturned the committee's decisions, one of which was unanimously voted on, including by government members. So at the end of the day, we see that what's not important in them is not the foundation of this bill. It's just they should have taken account of the opinions of the opposition parties and as well as of the many witnesses who testified at committee who made reasonable and justified requests. And we proposed a justified and reasonable amendment, and they just washed their hands of this and said, we know better than you. And unfortunately, this doesn't leave a good impression for the next 3.5 years to come.
Questions and comments. Nous avons le temps pour...
We have the time for a quick question.
Resuming debate. Reprise de débat. The Honourable Member from Moose Jaw, Lake Centre, Lanigan.
Well, thank you, Mr. Speaker. I was actually going to ask my colleague a question there. She is, I did my officer training, I'm pretty sure, in her riding in Saint Jean, and it's a beloved area in my life. Some of that I wanted to forget because of the grueling training, but I do appreciate my colleague's speech and her passion for our military and her passion for Quebec en belle Provence, and je me souviens, and I apologize.
And I remember
my French, but I am practicing, and I have to overcome my own fear, and I will do that by speaking with my French colleagues. Mr. Speaker, I want to talk about what the Minister of National Defence tabled last week and why it matters to people who trusted this place to get it right. The Minister tabled report stage amendments that undo months of committee work, not just Conservative work, but committee work. Bloc and Conservative members of the Standing Committee of National Defence sat together, listened to witnesses, and built something worth passing. The Minister swept it away. And not satisfied with tabling those amendments last week, the government has now moved time allocation to limit how long this House can even discuss them. Survivors came forward twice and made themselves vulnerable twice. I've been asked to speak to this bill because of the work that I've done on the Standing Committee on Veterans Affairs. In the last Parliament, ACVA undertook the largest study in its history, 23 meetings, and nearly 100 witnesses on the experience of women veterans. In this Parliament, we're studying suicide prevention and MST services as a driver in many meetings. The two files are not separate. As part of both studies, the committee undertook dedicated work on trauma-informed practices, what trauma does to memory, to reporting, to the way survivors present themselves in institutional settings. I don't raise that claim to expertise. I raise it because I find myself wondering whether the officials who drafted these report stage amendments or the members now standing to defend them have spent comparable time in those rooms. Many of the women who spent months testifying before the Veterans Affairs Committee later came before the National Defense Committee to speak directly to this bill. They showed up twice. They made themselves vulnerable twice. The minister's amendments are his response. The cross-party amendments to clauses 7 and 8 gave survivors the right to choose which military or which system, justice system, handled their case, military or civilian. That reflected what witnesses asked for directly. And please forgive me on my pronunciation, but Donna Van Leusden told committee, for many years, survivors in the Canadian Forces had limited or flawed options, but they still had options. Until this bill, survivors are given none. Everything has to go directly to civilian police and civilian courts, regardless of what the survivor needs, prefers, or feels safe with. That is not trauma-informed, and that is not survivor-centered. She's right, and she's not alone. The Provost Marshal General testified that over the last 5 years, 270 out of 735 files stayed with the military police because victims specifically asked for them to stay there. There's more than a third of all cases. Sorry, pardon me, that's more than a third of all cases. Real people making informed choice. The minister's amendments eliminate choice entirely. On civilian capacity, the picture is equally concerning. Sexual assault cases exceeding Jordan deadline limits rose from just over 15% in 2016 to 2017 to more than 30% in 2022 to 2023. Nearly half of those cases were stayed or the files were withdrawn. The civilian system is struggling with its existing caseload. The Canadian Association of Chiefs of Police was direct in their written submission. They said the proposed provisions would deny victims the ability to express a preference as to how their complaint is investigated. And this departs from the victim-centered and trauma-informed principles that underpin best practices in policing. They recommended maintaining concurrent jurisdiction. The people who would be executing this mandate said it doesn't work. The minister made his amendments anyways. It's worth noting what the minister himself acknowledged at committee. He has not spoken to Justice Arbour, Fish, or Deschamps on this file. When asked how many victims his office consulted when drafting the bill, he said he'd have to get back to the committee. He hadn't spoken to any provincial justice ministers since taking the portfolio. Jordan framework delays weren't in his briefings. He is implementing a mandatory jurisdictional transfer into a system he has not even consulted. Without the resources to support it, over the explicit objection of survivors, the Director of Military Prosecutions, and the Chiefs of Police. There are real consequences to getting this wrong, and they are playing out right now. A decade ago, the Canadian Armed Forces set a target of 25% women in uniform by 2026. Today, after 10 years of stated commitment, the number sits at 16.7%. The recruitment commander said last week the target is now impossible to reach. In the past fiscal year alone, 1,070 women left the military, the highest rate in 5 years, despite pay increases. You cannot recruit and retain women in an institution where they know before they sign up that if something happens to them, the system will not put their choice at the center. That is precisely what Bill C-11, as the minister has now amended it, fails to do. The government set a target of 25% women. It couldn't reach a force of 67,000. What exactly is their plan for 500,000? When I spoke to this bill at an earlier stage, I said I hoped that by the time my daughters are adults, parliamentarians wouldn't still be debating how to get this right for people assaulted in the forces they choose to serve. I'm standing here at report stage. Nothing has changed. If anything, Mr. Speaker, I'm less optimistic than when I was then. But I haven't stopped believing it's impossible. The committee did the work. The result was something worth passing. What the minister tabled last week is not an improvement. It is the government substituting its own preference for the survivors. That is paternalistic. And it is further just disenfranchisement of the people who have already been rendered powerless at once. Conservatives will continue to fight to restore those amendments. The choice provisions must stand. Civilian capacity must be resourced before jurisdiction is transferred. And survivors who came forward twice, who trusted twice, deserve better than this. We can do better than this. Mr. Speaker, how much more time do I have?
The member has less than a minute.
Thank you, Mr. Speaker. As I said, I am the father of 2 daughters, and I hope and pray that the work that we've put in to make their lives better would be heard by those on the other side of this aisle. We can do better, Mr. Speaker. We owe it to the next generation. We owe it to those that want to join. And I thank you for your time.
Questions and comments, questions et commentaires. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. And, you know, over the last year, I believe there has been significant gains when I think of the Canadian Forces as we try to build up that trust and faith and support for our members of the force. And we have seen some very encouraging signs. One of the best ones was the fact that we had well over 7,000 people that actually applied to join the Canadian Forces. You know, that's a 30-year high. And part of that is making sure that we have a respectful workplace. This legislation that's being brought forward is based on a recommendation from a former Chief Justice Arbor, who literally directly and indirectly consulted with well over 1,000 people, I suspect, Mr. Speaker. And this is the core of her report. And I'm wondering if...
I have to interrupt the member to give the chance for the member from Moose Jaw, Lake Center, Lanigan to respond.
Well, thank you, Mr. Speaker. It's my colleague from across the aisle ran out of time, and so really didn't get a question in, which is surprising. But here's what I've seen in the last year. The Liberals are pounding their chest, saying that they've had over 7,000 applications, but that doesn't show how many have not made it through. That doesn't show the failure rate that's happened within the military. But not only that, what they're doing to fail women that need options and choices when travesty happens to them in the military.
Questions and comments. Questions et commentaires. L'honorable député de...
The honourable member for Drummond. Mr. Speaker, I'd like to congratulate my colleague from Saskatchewan for his speech, particularly for the few words he said in French, and I'm convinced that he will succeed in a short while to make a speech or perhaps even answer questions in French. But I congratulate him for his speech. And on this very important issue, the government is treating this issue as a legislative formality, even though for 11 years, victims have been waiting for this to move forward, this file. And the Liberals have a majority now, and they're taking this file without any consideration for the victims, who are very vulnerable. They're directly affected by this. I'd like to know what my colleague thinks. Does he agree that we should take the time to reconsider the amendments that were voted, some of which unanimously at committee, to do work responsibly and respectfully?
The honourable member from Moose Jaw, Lake Center, Lanigan.
Oui.
Yes.
Merci pour la...
I'd like to thank the member for his question.
We need to go through this with a fine-tooth comb. And my colleagues have already done the heavy lifting. They've already done that. They've already come forward with recommendations that are already being ignored. And that is how the victims feel. They feel ignored, and that's what the Liberal government is doing to them. They're ignoring their pleas. They're ignoring the challenges that they've faced, and it's unacceptable.
Questions and comments. Questions et commentaires. The honourable member for Calgary, McKnight.
Mr. Speaker, thank you. First, I want to thank my honourable colleague for his wonderful speech. Mr. Speaker, witnesses at the Committee on National Defence made it clear that many survivors want a choice between the military and civilian justice system. Could the member explain why preserving that choice is so important?
Honourable member from Moose Jaw, Lake Center, Lanigan.
And I thank my colleague for that wonderful question. It comes down to the victims having the choice. They need to feel safe. They feel betrayed, and they want to be able to have options because they want to be heard. They want to be heard, and this is what I'm saying. The Liberal government is ignoring and shutting them out, and they've already been traumatized. We've seen that time and time again, not only in the Defense Committee, but in Veterans Affairs Committee. It's not time to shut people out. It's time to give them options. It's time to let them be heard.
Resuming debate, reprise the débat. The honourable member for Hastings, Lennox and Addington, Tyendinaga.
Thank you, Mr. Speaker. I'm very grateful to be able to rise today to speak to Bill C-11. In the previous Parliament, I was able to speak to this legislation's successor, C-66. In that speech, I spoke about how the two committees I primarily sat on during the previous session, Status of Women and National Defence, which I was able to provide a unique perspective as it related to what was at the time Bill C-66. At FIVO, we studied a number of issues related to violence against women. The committee studied violence against Indigenous women in the context of resource development, interpartner violence, and coercive control. Prior to that, when I sat on national defense, we studied transparency in the Canadian Armed Forces. During that study, we did hear testimony about how complicated and daunting the entire investigative process can be for armed force members, I will now re-enter into the record the testimony of Patrick White. First of all, you need to put yourself in the perspective of the most vulnerable kind of person. Respectfully, that's actually not me. I'm an attorney. I have some legal knowledge. I'm not the most vulnerable kind of person. The most vulnerable kind of person may be the 16-year-old who gets parental consent to join. They may be the person who is so affected by aggravated sexual trauma that they can't even put their hand on the doorknob to get into work, or may vomit when putting on their uniform. That's not just an example. If you design a system so that the individual like that can navigate it rather than requiring us to be Rory Fowler or Michael Drapeau, you will succeed in having a system that works for everyone. He continues to say the grievance system as it stands requires individuals like me and others to spend our limited part-time or our free time to fight a system that is paid and employed full-time to fight back. That's the challenge I have. I'm not an expert on military regulation, military law, etc., but they have access to all of those resources. They also have access to legal advice on those issues. Members don't. What particularly struck me was something Mr. White said after the meeting. He highlighted the labyrinth of regulations and the myriad of hidden file numbers and the thousands of initialisms and acronyms and faceless department nooks and crannies in the depths of DND that you had to know the name in order to get the paperwork. Patrick was a lawyer, a former staffer, someone who is intimately familiar with the machinations of bureaucracy. He knew where he needed to go and what he wanted, and he found it nearly impossible, Mr. Speaker. In any event, C-66 never got beyond the second reading in this place before dying on the order paper due to the previous election. But I am very happy to see an ever slightly so amended version tabled in this place, and even happier to be able to speak to it today. While reviewing the initial draft of this speech, I took the time to briefly go over the testimony of survivors and experts at National Defense when they studied C-11. It was refreshing to see all parties working collaboratively, especially on such a serious and sensitive issue. This was echoed by the member for Selkirk Interlake Eastman on April 23rd when he spoke in this place about C-11. What he also spoke about was the series of unilateral changes brought forward on the day prior by the government. Those changes, only achievable because of a newfound majority, unilaterally changed the determinations of that committee, government members included. In response to his poignant speech, the member from Lac-Saint-Jean asked the member from Selkirk Interlake Eastman that if he could save one portion of the original pan-partisan C-11, what would that be? My Manitoban colleague responded, Mr. Speaker, the key pieces of the bill that we have to maintain are clauses 7 and clause 8, as the bill came back from committee and report stage. Those clauses would instill and enshrine the rights of choice for victims of military sexual misconduct and military sexual assault. Those choices, especially as they fall under the definition of sexual assault in criminal code, would need to be dealt with in both systems. With regard to what Clause 7 and Clause 8 would do now, with the amendments brought forward by the Minister of Defense, the Minister would be taking away all authority and all investigations and prosecutorial powers from the military and giving them solely to civilian courts and civilian police forces. That is travesty, and it ignores the rights of victims. And the testimony agrees, Mr. Speaker. On November 18th, Dr. Karen Breek stated, the bill removes choice, mandating the transfer of all 28 listed sexual offense charges, regardless of its severity, is not people-centered. It will reduce reporting. Many would prefer a quick internal military resolution, especially for low-risk cases. I've spoken to many people who fear being labeled disloyal or overreacting if they were to involve civilian police, particularly for the lower-risk sexual assault cases. Colonel Bruce McGregor, retired, similarly reminded us that the expectation that victims would be completely satisfied with the criminal justice system is aspirational and not realistic. Many allegations of sexual assault, if not most, within the military are what we would characterize not as rape, but what may be considered as a lower level physical violence. Saying this is in no way an attempt to minimize the impact on victims. Christine Woods, a CAF veteran, was unequivocally clear in her testimony. She said, "I'm absolutely opposed to the transfer of military sexual offenses to the civilian justice system. I support the creation of an independent system of justice for sexual crimes within the military. I support it because the CAF must uphold their own good order and discipline. That responsibility is essential for transparency and accountability. Limiting survivors to a single pathway to justice weakens our agency rather than strengthening it. We want choices." The director of Survivor Perspectives Consulting Group, Donna Van Leusden, states, "This bill removes choice from survivors and reduces flexibility. For many years, survivors in the Canadian Forces had limited or flawed options, but they still had options. Under this bill, their criminal code sexual offenses committed in Canada, survivors are given none. Everything has to go directly to civilian police and civilian courts, regardless of what the survivor needs, prefers, or feels safe with. That is not trauma-informed, that is not survivor-centered. It may offer less flexibility than the military system ever did." Mr. Speaker, the consensus is strikingly clear. As anyone who has ever sat on a committee here knows, there is almost always a multitude of sides to any piece of legislation or study that a committee does. It is shockingly rare to have dozens of witnesses across all walks of life spread over nearly a dozen meetings, a full day of testimony be near unanimous in their calls for specific change. Mr. Speaker, this isn't some regulatory change. This was a call for help from brave survivors who have battled a rotted system designed to silence and diminish them. The very thing C-66 and C-11 was supposed to change. And for a while, Mr. Speaker, there was hope. The committee heard the witnesses. They worked collaboratively. They introduced amendments to C-11. For 62 days, these men and women brought change, and they thought change was coming. From the day the report was tabled before the House up until April 22nd, when the government tabled a battery of amendments, they undid months of collaborative work, completely revoking these changes. One of the first things the government did with their newly secured majority, even before the 3 new members even took their seats in this place, was table a sweeping set of changes that eliminated that hard work. Not only is this insult to witnesses who were strong enough to come out and give their testimony, it is disrespectful to the members of committee, including the members of the government sitting on that committee. Mr. Speaker, what this government did was worse than simply not listening. What they did was tell these witnesses and the thousands, if not tens of thousands of survivors, that we hear you. We quite literally brought you before a standing committee of the House of Commons to listen. We sympathize with you. We even amended the legislation, but we no longer need you. Mr. Speaker, this is not collaboration one bit soever. This is dismissal. Thank you.
Comments, questions et commentaires. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. As the member was reflecting in terms of this whole majority issue, I remember very clearly on the day in which we actually acquired the majority in terms of membership on the floor of the House of Commons. One of the very first actions that had taken place that day was collaboration, where we saw a opposition Conservative bill actually pass through. And that's with the majority. I think the collaboration has and will continue to be on the table. I think we need to recognize that the work and efforts put in by former Chief Justice Arbour were significant. Everyone seemed to be on side with that. At least in the last couple of weeks, possibly, we've now seen the Conservatives in opposition to the legislation. My question to the member opposite is in regards to the...
I have to interrupt the member to give a chance to the member for Hastings, Lennox and Addington Tyndall to respond.
Mr. Speaker, when I brought up in my remarks the mention of the machinations of this manufactured majority. I was speaking to the relevance of how this is impacting this legislation in this House. We are speaking about victims here. We are talking about C11. Mr. Speaker, Member Cross mentioned that of Justice Arbour. I'd like to note that she was indeed invited to committee. She denied ability to speak at committee. So let us put this into perspective. Things have changed since she wrote this report upwards of 7 years ago, and so has the system. Thank you.
Questions and comments? Questions et commentaires. L'honorable député.
The Honourable Member for La Pointe de l'Île. Thank you, Mr. Speaker. Why is the government so stubborn in not wanting victims to have the choice of being judged or of going before a military or civilian court? Why have they completely ignored the amendments that seem to be unanimously approved of by the opposition? How can she explain this?
Member for Hastings, Lennox and Addington, Tyendinaga.
Merci pour votre question.
Thank you for the question.
We can do better, and it is absolutely essential that we must do better. For those of you listening at home, we are talking about the Military Justice System Modernization Act, C11. We are currently at the report stage. Countless numbers of witnesses testified strongly. This committee heard the voices of these victims. They collaborated, they were moving forward, and then, whoa, there's a hard stop. What's the change? Why is the change happening? We need to do better in this place. Victims are needing government to speak up and represent. This is not the case with the way the government is acting.
Questions and comments? Questions et commentaires. The Honourable Member for Cowichan. The Honourable Member for Cowichan, Malhat, Langford.
Thank you, Mr. Speaker. Thank you for the intervention from my colleague. And my question for the significant majority of military sexual misconduct cases that will not meet the civilian threshold of the civilian justice system, and of the few of those cases that do meet that threshold for the civilian justice system, the civilian justice systems have testified that they only have a capacity to deal with just a fraction of those cases. So perhaps my colleague could speak to, is this going to just make culture in the military worse and be a free pass for predators? Thank you.
Honourable for Hastings, Lennox and Addington, Tyendinaga.
Thank you, Mr. Speaker, and thank you to my honourable colleague for a compelling question. Look, we could speak for hours and debate this bill, but we have to really think hard about what survivors have asked for. Why has this debate not been allowed to go further than the short time today? Supporting victims, supporting survivors is what we need to get justice, and that's clearly not the place here. So I don't understand why the government is rushing to shut down this debate before clear consensus and concerns are heard, and in addition, ignoring that and contradicting that of the actual testimony that was heard. Thank you.
Before we return to debate, alors, conformément à l'article.
It is my duty pursuant to Standing Order 38 to inform the House that the questions to be raised tonight at the time of adjournment are as follows. The Honourable Member for Algonquin, Renfrew, Pembroke, Finance, the Honourable Member for Cloverdale, Langley City, Justice, and the Honourable Member for Yellowhead, Taxation.
Debate reprise débat. The Honourable Member for Bruce Grey, Owen Sound.
Thank you, Mr. Speaker. It's an honor to rise here again. The last time I rose at second reading on this bill, I talked a bit about my military background, but I really focused on why it's so important that we get this bill right, especially for the victim and the accused. This bill does a number of things, and in fact, parts of this bill, C11, are actually very good and a step in the right direction and needed. And I don't want to debate those, and that's reference, the independence around the Director of Prosecution, the Provost Marshal, etc. Nor do I really want to focus in on any amendments to the Sex Offender Information Registration Act. I want to focus really around this transfer of jurisdiction of offenses of a sexual nature to civilian authorities when the offenses take place in Canada, and what this is really going to mean for our Canadian Armed Forces, somewhere where I had the privilege to serve for 25 years. Today I'm wearing, Mr. Speaker, I'm wearing my Royal Military College tie, whose motto is truth, duty, valor, something that I think is essential with this bill, but as well the tie clip of my regiment, which is the motto is pro patria, for country, but the slogan is what I want to focus in, which is never pass a fault. And I have to feel we're in a position right now where the government is making a mistake. I'm going to try to lay this out. There's a few things just for all listeners here, because I'm going to use some slow, jargon, maybe your acronyms. Criminal Code Sex Offenses, CCSO, if I refer to that, that's what that means. When I say MPs, I mean military police, not members of parliament. I likely say police of jurisdiction, but POJ, and we'll go through that. So let's back up a little bit. Prior to November of 2021, because in 2021, that's when the Director of Military Prosecutions in the Canadian Armed Forces Provost Marshal decided to transfer all criminal code sex offenses to the civilian jurisdiction. This was a result of Justice Fish and Arbour's, and it was sort of as an interim directive to, go forward. However, prior to that, there was concurrent investigations by both civilian authorities and the military police. And that resulted in some cases prior to 2021 ending up being tried in civilian cases. However, when this interim direction then came into place in 2021, that ideally all CCSO or criminal code sex offenses were being transferred, that was the intent. That direction was clear. However, what did the military find out? They found out local police of jurisdiction weren't accepting the files. Military police then were able to do very much a victim-centered trauma sort of analysis. They could conduct the investigations, and because there's a number of reasons. So the civilian police of jurisdiction, A, they don't have the capacity or the resources to deal. Their threshold is much higher than the standard that the Canadian Armed Forces expects. And as well, there's a lot larger gambit of tools available within the Canadian Armed Forces for both disciplinary and administrative action that allowed all of this to take place. Part of the reason, too, they pushed back, they actually believe the military police are more than capable and competent to do this. We've seen this with public states of affirmation from the Canadian Chiefs of Police Association, the Ontario Chiefs of Police Association, of the incredible professional competency of our military police. And as well, some of these cases being brought forward, the civilian police look at it and say, there's not really no public interest in moving forward because some of it might be historical or the public safety right now is not being dealt with. Further, in this interim time frame, the Declaration of Victims' Rights has now been implemented. What does this mean, Mr. Speaker? This means that actually not really on purpose, but because of an interim direction in 2021, we now have a choice for victims. Victims are actually getting the best of both worlds. You have the military police, which have fixed and addressed many of the shortfalls that had existed historically in our system, and that they are now able to do this in collaboration with the victim, with the police of jurisdiction, and to make a case and actually deal forward. So I actually think the way the system is functioning today, when it comes to dealing with criminal code sex offenses, is actually right. However, now let's talk about what happens if this bill passes with the amendments that the Liberal government is now basically putting through to change what was passed in committee. First off, for the first time ever in Canada, a police force, i.e. the military police, is going to lose jurisdiction to investigate criminal offenses within their own jurisdiction. The military police are the police of jurisdiction for the Canadian Armed Forces. As well, now, as soon as the military police, during an investigation, finds any suspicion of a criminal code sex offense, they must contact / transfer or refer this to the local police of jurisdiction. Literally, they're going to get a victim coming to them that's a CAF member and go, here's the phone number for the OPP, or here's the phone number for the Ottawa Police Services. Not ideal. And the police of jurisdiction are not compelled to actually do anything about it. The Canadian Armed Forces chooses to go ahead with administrative actions. The problem we have now is that they're not allowed to investigate. The whole Section 70 of the National Defence Act, which lists all these sort of tied sexual offenses that are tied to even the criminal code ones, their hands are tied and they won't be able to investigate. And right now, the way the local police of jurisdiction are dealing with this, Mr. Speaker, they're very slow or not really keen on sharing that information with the military police. So we're basically taking this choice away from the victims. It's not going to be clean. You know, this could be something as simple as a lower level harassment issue that maybe shouldn't be criminal in nature. It's not necessarily meets that threshold, but because it falls under that the changes that are now being forecasted to pass in C11, if the government gets its way, that they're not going to be able to do anything. Removal of this is going to fundamentally undermine the reputation of our military police. And as I mentioned earlier, our military police are experts. Since 2022, all these former cases that used to be done by summary trial are now being dealt with court-martial, must be investigated by the military police. And as I mentioned earlier, we got the civilian police acknowledging the incredible capability. And in fact, if I had enough time, Mr. Speaker, I could share stories where victims have actually been so happy that they've been dealing with military police as their situation's been investigated instead of local police. Outside of Canada, really quickly, right? So I'm not talking about a host nation perpetrator or victim based on a guy. I'm specifically talking about where military police can investigate a CAF members, whether they're a victim or the perpetrator with a Canadian victim. Latvia is a good example, right? So in this case, military police are going to investigate, they're going to lay the charges, whether or not they end up in the military or the civilian justice system, because they can still do that, and they're going to maintain that skill set. But I would argue the type of operations we're doing now in places like Latvia, where family members, where there's D&D members, we're actually going to see the potential for a higher level of these type cases, because again, the CAF isn't perfect, that are doing that. But my point is, you could do something in Latvia, you'll be charged for it. You do the same thing in the CAF here in Canada, and you may not be charged for it. So ultimately, Mr. Speaker, as I sort of wrap this up in the final minute and a half or so, this is what's concerning me. Victim-centered, trauma-informed approach is not happening as the military police lose this concurrent jurisdiction. More charges are going to be dropped. There's going to be less accountability within the Canadian Armed Forces. The current civilian system's already overloaded, and as I mentioned earlier in my speech, they have a much higher threshold. We're actually seeing this in jurisdictions like Ireland right now, which went through this sort of step. They're now trying to figure out how to undo what they did, because they are getting into trying to fix the situation they're in. And this is breaking trust with our military police, within the CAF, and it's basically an abdication of responsibility and leadership in my viewpoint. This bill, no matter what, Mr. Speaker, needs a sunset clause, because this is what concerns me. We're going to be back here 3 years, 5 years, 6 years from now as a parliament going, we messed up, where we're going to be apologizing to the victims themselves to say we didn't get it right. And we're not going to be able to fix that harm that we caused. And I say we here as the Parliament of Canada, as this chamber and the other place, where these people, these victims, are going to be trying to seek. So it's not going to do them justice. Mr. Speaker, I think it's important that we get this right. I really plead to the government, we need to do this right. If we can't fix it here in this place, I'm praying that the other place will be able to fix it, because I have legitimate concerns that we're making a mistake if this bill passes as the government wants to amend it.
Questions and comments? Question and commentaire. The Honourable Parliamentary Secretary to Government House Leader.
Yes, thank you, Mr. Speaker. Former Justice Arbour was an incredible Canadian, whether a jurist, a prosecutor, human rights advocate. It even went beyond Canadian borders in terms of a lot of the fine work that she did, all somewhat related, directly or indirectly, with the issue. There's 48 recommendations that came out in that report. If you take a look at recommendation number 40, and I quote specifically from that recommendation, transfer the jurisdiction to investigate in sexual misconduct and prosecute its perpetrators to civilian authorities. The essence of the legislation is to meet that recommendation. And I think we've already done 35, 36 of those 48 recommendations. It's an important recommendation. I suspect that she, in all of her consultation, she knows what it is that's being proposed, and I'm wondering if he could provide his thoughts on the justice, former judge.
The Honourable Member for Bruce Grey, Owen Sound.
Thanks, Mr. Speaker. In responding to the Parliamentary Secretary, Justice Arbour, Madam, things have changed, right? In previous speeches, we've outlined this. The Victims' Bill of Rights that's no longer there. We have a Sexual Misconduct Resource Centre available. The independence that's gone forward. The military police have actually fixed and addressed the key things that allowed those situations for Justice Arbour to make her recommendations. I would challenge, and I mean, it was brought up previously in the debate, unfortunately Justice Arbour chose not to show up at committee to testify. Things have changed. In the military, the last thing we do when we do our mission analysis is, has the situation changed? The situation has changed. As I highlighted during my speech, since 2021, based on recommendations that came out of Fish and Arbour, we're there. The system's actually pretty much there. Let's use the rest of Bill C11. This transfer, I think we're getting it wrong.
Question et commentaire, l'honorable.
The Honourable Member for Saint-Hyacinthe Bigot Acton. Thank you very much, Mr. Speaker. I'm a member of the committee that undertook the study for weeks and weeks, and that was able, with our Conservative colleagues, because we had a majority at the time, to pass amendments. Amendments that improved the bill in a major way based on witness testimony. We did our work passionately for weeks and weeks. We heard from witnesses who said, this is what you have to do. I think that we succeeded in getting the bill going in a good direction. What does the colleague call a government who doesn't respect the verdict of parliamentary democracy, which has decided to change the bill and now is trying to undo it?
Owen Sound.
I could use a really derogatory term, Mr. Speaker, but I won't. My point is it's a government that's making a mistake. Ultimately, I think we need to get this right. This is about the victims. The committee did so much hard work. The witnesses testified. And I'm not taking away against anything that Justice Arbour has made forward. Look, this is a tough position for the CAF and the senior leadership of the CAF, but I dare say if you go back and review the testimony that got put forward at committee by the Canadian Forces Provost Marshal, by the Canadian Military Director of Public Prosecution, or prosecution, I should say, the military prosecution, they have laid out their concerns with this. And again, this is ultimately about taking care of the victim. And I don't think this government's going to get it right if they remove everything that the committee and the hard work that the committee put forward as recommendations.
Questions and comments? Question et commentaire. The Honourable Member for Windsor West.
Thank you, Mr. Speaker. Mr. Speaker, as a police officer, retired police officer, I can tell you only 5 or 6% of sexual assault cases in the civilian world are brought forth. Probably less so in the CAF world. So my question is, policing also depends on a lot of clarity, evidence, integrity, and when you transfer these between two bodies, civilian and CAF, it's not going to work out. So how is this going to work out, practically speaking, and if there's a mistake, who is going to be held accountable? Is it going to be the civilian world, or is it going to be the CAF world? That's what I'd like to know.
Honourable Member for Bruce Grey, Owen Sound.
You know, it is a great question. I don't know if anybody's going to be held to account, and that's going to be the problem with this, because ultimately this is, and this is what I highlighted in my speech, this is an abdication of responsibility and accountability within the CAF. By handing this off and saying, police, you're able to do this, as this member noted, they're already overloaded. Their threshold is much higher than what the military has, and ultimately, I think we're not going to do the victims justice. And they're going to be the ones to suffer from this. And as I mentioned, we'll be back at this trying to fix this mistake a few years from now.
Reprise de débat.
Resuming debate, the Honourable Member for Laurentides-Labelle. Thank you very much, Mr. Speaker. On October 8th, I was able to speak here in the House, so it wasn't that long ago, on Bill C11. My background in psychosociology allows me to have a very specific perspective when it comes to victims and on the acts that have been perpetrated on victims and the impact of those actions. And I'd like to salute the work done by my colleague from Saint-Hyacinthe Bigot Acton because they at committee had the opportunity to meet with victims, and that allowed us to see that the recommendations in the report from Justice Arbour must be applied. Well, so I thank him on behalf of all our armed forces personnel, but also on behalf of veterans, many of whom are victims as well of reprehensible criminal acts. I'd also like to share the experience of a female veteran, Mr. Speaker, and obviously I will withhold her name, but I want to commend her resilience. This veteran was the victim of multiple rapes while she was in the Canadian Armed Forces. At the sight of a uniform or of medals, she breaks down. And when I say that she breaks down, well, she demonstrates behaviors that are disorganized, if I can put it that way. And we've understood that it was a vision of masculine authority. I saw it, I was there, that sets off feelings that are indescribable, and that she was able, in that instance, after 5 minutes, to explain to us. And she said that she's been dealing with that since the day, but she knows that even with therapy and with telling her story many times, because there have been in many instances there was the administrative officials, etc. You have to repeat your story time and time again, and she knows very well that she's going to have to deal with that for the rest of her life. So I salute her resilience. What great courage she has in telling her stories, and I talk about it here as a psychopsychologist, or psychosociologist. So she has to bear this suffering day after day, but this female veteran, must now rebuild her life, knowing that there's a system that isn't working, and that's what we're talking about. How long have we been talking about? How long has this been an issue? 10 years. 10 years. Now, I'm vice chair of the Veterans Affairs Committee. We've just finished a study, and the report was tabled last week, a report on the unacceptable high levels of suicide with veterans. Right now, we're studying how the rehabilitation program for our veterans is working. LifeMark. And it's something that has to be reviewed because the contract has to be renewed after 6 years. And there are some veterans who've received good service, but there are lots of failings as well. And that's what I'm so worried about, because if the justice system doesn't do the work that it needs to do to look at what's happening in the Canadian Armed Forces and bring it out into the civilian world, and I'm speaking here in a general way, but the committees looked at this. There were recommendations that were made. And I heard my colleague who sits on the committee say that there were unanimous votes. And, I think we're starting to see what we saw in 2015 to 2019. It's the same thing over and over again, where people aren't aware of what happens when there's closure vote after closure vote. And, they're afraid that there will be more and more scandals that will come out. We saw it earlier with Curem, and I'm also seeing it in my other committees. Right now, the order of the day is, let's be as unclear as possible. Transparency? Forget transparency. And, the government said, oh, listen, it's not just because there are going to be 7 members on each committee that, we're going to have an overwhelming majority, that we're not going to work together. Well, Mr. Speaker, 7 days later, it's false. And it's terrible. Normally, I have a hard time, getting through each day because I'm so busy. But now, committee meetings, they're lasting 20 minutes. They're canceled. things are delayed. Tomorrow there's going to be votes. I'm convinced that the majority, the committees are just going to say, for an hour we'll just cancel the meeting. What's happening with democracy here, Mr. Speaker? And here, we have victims who are saying loud and clear what needs to be done. And, it's not just individuals who are saying things need to be fixed. There are factual situations. There are reports. But what is the government afraid of? And, we'll have more to say about this later. But now I want to speak about one amendment in particular, which was presented by the Liberals. And I'll quote that Bill C-11 in Section 17, I know I'm going to put you to sleep, but it's important, be amended by substituting on line 8, page 10, the following. 17.1, subsection 165.17, 3 in parentheses, of the Act is replaced by the following. And here, this is the part that you have to listen to. 3. The minister may, in writing, establish guidelines or issue instructions regarding a specific prosecution. Now, let me explain what that means, Mr. Speaker. It means the Liberals are changing something that hadn't even been amended by the committee and that wasn't even discussed at committee. Wow. That's what's happening, Mr. Speaker. And even worse, they would go so far as to give power to the minister to issue instructions regarding a legal or criminal prosecution. I don't understand the logic, Mr. Speaker. I really need to have that explained to me, and people need to be aware of this. And, we need to respect our democracy, even though we have a government that's a majority in front of us. So, Mr. Speaker, as I have very little time left, the bill is written and presented with the direct aim of dismantling a system where people protect themselves or where complaints are suppressed, a system where victims do not feel heard. They don't feel believed or respected. And, Mr. Speaker, is that what we've heard from victims? Have we truly listened to the victims? Did the government and the reports, there's the Louise Arbour report and the Morris Fish report, have they been read? Once those questions are answered, well, I can say that military culture has to change to reflect the 21st century. Military culture has to recognize that there are women in the forces, and yes, we can accept them. But we have to adapt. The forces have to adapt. We have to understand that they can be victims. We have to ensure that we create a justice system that does not tell them in advance that the die is already cast and that the system is rigged, or at the very least, give them that impression. So I think of all those female veterans that I've met in my role as spokesperson for Veterans Affairs. I see them, I hear them, and Mr. Speaker, I believe them. Thank you.
In comments, questions, commentaires, the Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. And part of the issue that I've been raising today is the holistic approach that the government and our new Prime Minister has put into play that actually has seen significant improvements in our Canadian forces. The 2% to the GDP, the military industry and the growth of that industry here in Canada, the number of people applying to become part of CAF today, record numbers. We also have now before us Bill C-11, something that's been called upon for a long time now. It's been, before this, it was Bill C-66. Opposition has been saying pushing and pushing and pushing. I cannot recall whether it's a Bloc or Conservatives a month ago even raising the issue, yet it's been here for a long time, raising the issue that they're raising now. And I'm wondering if the member would recognize the hard work of former Justice Arbour.
The Honourable Member for Laurentides-Labelle. Mr. Speaker, well, first, I'm trying to make a link, but when we talk about investment or building Canada strong, we hear this everywhere at election. with the government's announcements. Well, I can tell you that Veterans Affairs in the budget saw a 15% cut. We want to hear you and believe you because you absolutely do not want to help our veterans.
Comments, questions et commentaires. The honourable member for Chatham, Kent Leamington.
Thank you, Mr. Speaker, and thank you to my honourable colleague from the bloc. I note, while I wasn't personally involved, the cooperation between our side of the House and the bloc in getting amendments on basis of the witness testimony. As I've been following the debate today, the question I keep asking myself is why? Why are the victims? Why is all the testimony being ignored and the amendments that the committee worked so hard to put through? Why, if I could ask my wife if she could take a venture as to why the government is taking this route as opposed to following the hard work of the committee.
The honourable member for Laurentides-Labelle. Thank you very much. I'd like to thank the honourable member for the question. When you make an effort, you listen. You could even say, we heard a lot of witnesses and they were re-traumatized, and I heard a lot from them. But when you realize that this is not an isolated case, then, well, we don't want things to get out of hand. And then they have nice powers and they start cutting and they avoid dialogue and they ignore what they've heard. So, Mr. Speaker, I have hope, and I truly do hope that they'd make a 180-degree turnaround. I hope that the official opposition and the bloc, well, we do have constructive proposals. We need to be heard. The honourable member for Saint-Hyacinthe-Bagot-Acton. Thank you very much, Mr. Speaker. I'd like to thank my colleague who does excellent work on this file at her committee, which is Veterans Affairs. I also work on defense, which is a similar connected file. But we heard many victims who talked about the need, because one of the big proposals in this bill is putting all of these cases of people who want to have a choice between military court or civilian court. And now what the government is seeking to do is not to give them a full choice, but in some cases, if the civil court believes that a file would be better to stay in military court, that they could allow this. Well, it doesn't seem to be the end of the world. What does she think of this? The honourable member for Laurentides-Labelle. 45 seconds. Thank you very much, Mr. Speaker. I also appreciate my colleagues' work. Well, on a case-per-case basis, we could listen, make a proposal, do a pre-study, evaluate, and then we could move forward based on needs. What's proposed on the table? When we all agree, and then they say, no, that's not true, we forget everything you've said, and we tell the minister that he'll have the right to do whatever they want. We have to change this, and we'll do this together.
Reprise débat. L'honorable député de Bourassa.
The honourable member for Bourassa. Thank you very much, Mr. Speaker. Colleagues, we are gathered here today to debate a bill which is very close to my heart and whose implications transcend partisan divides. Bill C-11, Act to Modernize the Military Justice System, is a concrete, structured, and long overdue response to realities we can no longer ignore. I rise to address an issue that concerns public trust, the dignity of those who serve their country with courage, and the very integrity of our institutions, namely the profound and lasting transformation of the culture within the Canadian Armed Forces. For too long, members of the CAF, particularly women, but not exclusively women, have borne a silent burden. Courageous testimonies have brought to light disturbing realities: sexual misconduct, abuse of power, a climate of fear, and at times a sense of persistent impunity. These testimonies are not exceptions to the rule, they reveal the rule itself, and they reveal a systemic problem. And in the face of a systemic problem, Ad hoc responses are no longer enough. What is needed is a profound transformation, one that is courageous, well thought out, consistent, and enshrined in law. And that's precisely what Bill C-11 proposes, supported by Recommendation 5 from former Supreme Court Justice the Honourable Louise Arbour. Bill C-11 proposes significant amendments to the National Defence Act. Its objective is to modernize a military justice system that, in some respects, has not kept pace with the evolving values and expectations of our society. Fundamentally, it strengthens accountability, reinforces institutional independence, and ensures compliance with the standards of fairness that Canadians expect. As presented, Bill C-11 removes jurisdiction from the Canadian Armed Forces over sexual offences under the Criminal Code committed in Canada, transferring it to civilian authorities for most investigations and prosecutions. This approach is not new. It builds on the interim directive adopted in December of 2021, following Justice Arbour's interim recommendation. Since then, all new charges of Criminal Code sexual offences have been referred to the civilian justice system. The directive has proven its worth. Bill C-11 enshrines it and makes it permanent. Any attempt to dilute or undo the progress made over the past 5 years would constitute an unacceptable step backward and a direct affront to the victims and survivors who had the courage to come forward. The Liberal government has chosen to take action, not with symbolic gestures, but with a clear and measurable commitment to bringing about lasting change. This has resulted in the strengthening of independent reporting mechanisms, improved support for victims, greater transparency in disciplinary processes, and a renewed commitment to accountability. But let's be clear. Changing an institutional culture cannot be changed through legislation alone. It requires time, consistency, and above all, political courage. The courage to challenge structures deeply rooted in an institution's history, particularly in the military institution. And it's against this backdrop that Justice Arbour's report marked a turning point. This report did not merely identify the flaws, it charted a path forward, a demanding path, but a necessary one. Amongst its recommendations, Recommendation 5 stands out for its scope and clarity of the message it sends to all of Canadian society. Mr. Speaker, some might wonder why the transfer to civilian jurisdiction is so fundamental, and the answer is simple, but it touches on the very essence of what we mean by justice. Mr. Speaker, justice must not only be done, it must be seen to be done independently and impartially. However, in a system where the chain of command plays a central role in every aspect of a service member's professional life, there exists, whether we like it or accept it or not, a structural perception of conflict of interest. And for a victim, this perception may be enough to discourage any reporting. Imagine having to report an assault in an environment where your career, your evaluations, and your professional future depend directly or indirectly on the very structure handling your complaint. This is not merely a procedural issue. It's a matter of fundamental trust, and without trust, there can be no justice. By transferring these cases to the civilian system, we introduce an essential institutional distance, true independence, that strengthens the credibility of the process and sends a clear message to victims that their voice matters, their safety matters, and their case will be handled with all the rigor and impartiality it merits. To those who cite the unique nature of the military context to justify retaining internal jurisdiction, I would say this. When it comes to serious criminal offenses, and particularly sexual offenses, it is precisely the highest standards of independence and expertise that must prevail. The civilian system possesses these standards. It has the resources. The civilian system has specialized training and, above all, the necessary experience to handle these cases with the sensitivity and rigor it requires. A strong chain of command does not rely on absolute control. It hinges on trust, a trust that is built on justice, transparency, and accountability. And above all, transparency and accountability are essential for trust. And with respect to Recommendation 5 into law, it does not weaken our military institutions. It strengthens them, Mr. Speaker. It recognizes that certain functions must be carried out outside of the chain of command to ensure their integrity. And integrity is the very foundation of any trustworthy institution. I repeat this sentence. Integrity is the very foundation of any trustworthy institution. For a strong military is not defined solely by its ability to defend our borders. It's also defined by the respect it shows to each of its members. It's defined also by its ability and, above all, its willingness to evolve. Mr. Speaker, in conclusion, refusing to change means accepting that the same injustices will persist. And we have a collective responsibility here to not accept that. Today we have a real opportunity, an opportunity to rise above partisan lines and to turn our commitments into action, an opportunity to say clearly that dignity, safety, and justice are non-negotiable. Behind every reform, there are people, men and women, who have chosen to serve this country with courage and dedication, and they deserve more than our gratitude. They deserve a safe environment. They deserve a fair system. They deserve an institution that reflects the values they uphold. Mr. Speaker, that's precisely what we have the responsibility to build here. Thank you very much for your attention.
Questions and comments? Questions et commentaires. The Honourable Member for Cochin, Malahat Langford.
Thank you, Mr. Speaker. Clearly, the member opposite does not understand the bill nor military chain of command. And removing the committee's amendments, ignoring overwhelming evidence of the experts in MST survivors, and even worse, adding amendments without going to committee. This is not democracy or transparency or collaboration. So my question, knowing for the significant majority of military sexual misconduct cases that will not meet the threshold of civilian jurisdiction, and furthermore, of those cases that do meet the threshold, the civilian justice system has testified that they only have the capacity to deal with a small fraction of those. What is the Liberals' plan to prosecute these cases and bring justice to the majority of these cases? And are they just going to give a free pass to predators? Thank you, Mr. Speaker.
Honourable Member for Bourassa. Thank you, Mr. Speaker. I'd like to thank my colleague. Perhaps he doesn't share the same point of view as me, but like he said, and I'd like to thank him, we don't have the same vision. What we're saying in this case is that someone who's in the chain of command and hamper someone else's career, we want to keep a certain independence. If this person wants to file a complaint, they have the freedom to do so, and they should feel comfortable in doing so once they've tabled a complaint. We're always open, nevertheless, to any proposals, but once again, we don't necessarily have the same comprehension on both sides. The Honourable Member for Saint-Hyacinthe-Bagotte-Acton. Thank you, Mr. Speaker. I heard what the intentions are behind this bill, and we agree. We voted to send this committee. But we also are listening to victims. I heard my colleague, and I agree with what he said in terms of civilian courts. We have to rely on their expertise, and I agree entirely. Nevertheless, if civil courts, in some cases, with this very expertise, say that in this specific case, we think it would be better for it to be tried in the military court, and given their expertise, our amendment allowed for them to do this. And with this Liberal Amendment number 5, which will erase this, they will no longer be allowed to do this. The Honourable Member for Bourassa. Thank you, Mr. Speaker. I'd like to thank my colleague across the way. I hear what he's saying, but except for one particular element, we don't want to raise this. We don't have the same understanding on this side of the House, but with all due respect, on the contrary, the civilian courts have the necessary expertise and knowledge and experience. We want to work with both sides and all parties here to give all of the victims the freedom to lodge a complaint.
The Government House Leader.
Yes, thank you, Mr. Speaker. I appreciate the comments of my colleague in regards to the significance of the legislation. And when I think of the former Justice Arbour and her report, there was like 48 recommendations. I believe we've done 36 of those recommendations or possibly more. The essence of this legislation is to implement the core of what it is that Justice Arbour was actually asking us to do. To transfer it into civilian process. And that's what the legislation has done. She consulted and listened to, worked with, I suspect directly and indirectly, well over 1,000 people, many of them direct victims. And I think that we need to look in terms of being respectful of what it is that's before us and see it ultimately pass. And I'm wondering if he could provide his thoughts in regards to why it was important to not only receive the report from former Justice Arbour, but also to follow through with it. And that's exactly what this legislation is doing.
The Honourable Member for Bourassa. I'd like to thank my colleague, the member from Winnipeg, and what I can say quite simply is that what we see here and what we've just presented is fully aligned with Justice Arbour's recommendation and also fully aligned with what we heard from testimony at committee. And once again, we're a responsible government. We are one that wants to give plaintiffs the opportunity to file complaints, and we want to give military personnel justice, and one that is perceived by all people who work there. Resuming debate.
The Honourable Member for Calgary-Midnapore.
Merci. Thank you very much. I'd like to thank all my colleagues. It's always a pleasure to be here in the chamber to speak as the critic for the people of Calgary-Midnapore.
To speak on behalf of the incredible people of Calgary-Midnapore, who of course reside in the wonderful province of Alberta. And I'm going to start my speech today with great words that came out of a campaign in Alberta in the year 2015. And those words are, I believe you. I believe you. This was a campaign created in 2015 by the Alberta Sexual Assault Service in Alberta to support the victims of sexual assault. Because when someone comes forward and claims that they are a victim of sexual assault, there should be no other response than, I believe you. Yet 97% of sexual assaults go unreported. 97% of persons who have been the victims of sexual assault don't have the courage to go forward and to tell someone their story, what happened to them, because they are unsure that they will hear the words, I believe you. And this is the one line that a survivor of sexual assault needs to hear. So what we are hearing today from this government, what they are saying to victims of sexual assault is that they don't believe them. They need to say to these victims that they believe them. This was the crux of this incredible campaign that came out of Alberta. I believe you. Because, of course, Conservatives are proud of and support all of our men and women in uniform who serve Canada. And we believe that we must continue to address sexual misconduct as well as discrimination, racism, and other forms of harassment, because all military members deserve to have a safe and respectful workplace. And the greatest way that we can do that today is by saying, regarding C-11, I believe you. We believe you. This House believes you. Now, the previous Conservative government accepted all recommendations from the Deschamps report to eliminate all forms of sexual harassment from the CAF. But yet, after 11 long years of Liberal government and 2 more reports from Supreme Court justices, victims of military sexual misconduct are still no closer to having their cases dealt with properly. The Liberals' only idea on military sexual misconduct is to force those cases into the overburdened and even slower civilian justice system without providing resources to local police forces or provincial courts to deal with military cases. So when victims of sexual assault hear that these processes are being delayed, that they are being pushed off by the federal government, what they are hearing is, I don't believe you. And what these victims need to hear is, I believe you. Liberals are trying to do what is politically expedient and want to punt this off to the provinces and municipalities by pushing sexual assault cases off their table into an already overburdened civilian police and court system. And we have seen this time and time again, Mr. Speaker. I think of a great example in my incredible riding of Calgary-Minnepoor of cell phone towers that constituents are very concerned every time another cell phone tower goes up. And so they create a petition, they bring it to my attention, and I go forward to the Minister of Industry. I say, Minister, my constituents are very concerned about these cell phone towers, about the impacts that they will have on their safety and well-being. And what the minister does is he punts it off to the municipal level of government. She puts off making a decision, taking responsibility for the actions of a government, particularly in an issue which is so relevant to the health and well-being of Canadians, certainly as much as the issue being discussed here today is. But this is what Liberals do. They deflect responsibility. They try to muddy the waters by not taking jurisdiction of the decision, and instead they try to diffuse this decision-making process to avoid this responsibility. And that is what we are seeing here today. And instead of listening to legal experts and increasing independence in the military justice system, they want to ensure that they can politically interfere with ministerial directives and ensure that the Director of Military Defense Council Services, the Director of Military Prosecutions, and the Provost Marshal General stay under the thumb of the General, the chain of command of the chief, if you will, here. And that is what we are seeing. And it is essentially the Minister of Defense saying, I don't believe you. So Conservatives carefully studied Bill C-11 to ensure concerns from all stakeholders were taken into consideration, and we are proud of the progress that we made at the Standing Committee on National Defense to improve Bill C-11 and to ensure the voices of victims and survivors were heard and considered in the studying and amending of this legislation. But most of the witnesses at committee are asking for victims of military sexual assault to be given the choice of what justice system they made their report to. And isn't that the very least that we can do to these victims, these individuals who have received the greatest offense that a person can possibly go through, to be violated, to have your person violated? And the very least that we can do is to give them power in the decision to decide how this abuse of trust will be handled. And this government isn't willing to do it. They are essentially saying, I don't believe you. The brave men and women of the Canadian Armed Forces have put in the work for decades to ensure that no one else has to experience what they went through. And it is time for all of us to stand up and to be allies for them and to say, we believe you. And we need to do what we know is the right thing for the next generation of both our sons and our daughters not only serving in the CAF, but across Canada. And as the mother of a son, I will tell you, my husband and I have had this conversation with him, and we hope that he will carry it forward with him in all of the decisions that he makes. But in removing victim choice on how to report sexual offenses, it does nothing to solve the problem. It only deepens it. And after 11 long years, the Liberals are once again letting down the brave men and women of the Canadian Armed Forces by saying, "We don't believe you." If this Parliament is serious about doing all it can to support those who serve, then all members of Parliament must retain the ability for military victims to choose which reporting path is the safest, most credible, and most operationally workable for them, regardless of where they are in Canada. We need to speak with one voice as a House and say to them, we believe you, we recognize what you have been through, and we honor you by giving you the choice with how you are going to deal with this violation that has occurred to you. We believe you. In closing, I want to share another incredible story about Alberta, and it is the Not in My City campaign, which was created to deal with the also horrific problem of human trafficking. We have seen the incredible Ambassador Paul Brandt and his message of Alberta Bound also extend beyond his musical capabilities. Him and his wife are true songbirds to advocate for those who are the victims of human trafficking. But we should say each and every day, not only in my great province of Alberta, but across Canada and in this chamber, we believe you. I believe you. We believe you, and you should be given the opportunity to make your decisions as such. Thank you very much, Mr. Speaker. Merci beaucoup.
Questions and comments, questions et commentaires. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you. Mr. Speaker, the member made reference to the federal government wanting to punt the responsibility off to provinces. And nothing could be further from the truth. The reality is that the motivating factor behind us doing this in the very first place is to deal with the issue of harassment of all forms to sexual violence that was taking place in the Canadian Forces. That's the reason why the former Justice Chief Arbour was brought in. That's the reason why 48 recommendations were done. That's one of them, that 40th recommendation, talked about transferring it into the civil administration, the civil process, as opposed to the military. That's the essence of the legislation. So listening to the survivors is important. I'm wondering if she might want to revisit history.
The Honourable Member for Calgary-Lyndeport.
Yeah, thank you very much. It's very hard to hear this member talk about harassment when he sits with ministers who have actually not only been accused but found guilty of harassment. That's disgraceful. So I don't like to be lectured by a member of a party whose ministers have been found guilty of harassment. And I will mention, Mr. Speaker, that Arbour's knowledge of international law is questionable as her understanding of morality. As is her understanding of morality. That is a direct quote from Harvard law professor Alan Dershowitz, a well-regarded international jurist. He said this in 2006. He should think about who he is referring to as an example, Mr. Speaker.
Questions and comments, questions et commentaires.
The Honourable Member for La Pointe de Lille. Thank you very much, Mr. Speaker. I was listening to our colleague. I'm wondering, the government rejected our amendments. Is it to try and not shake the military hierarchy too much? We had amendments that would create an Inspectorate General for complaints. There were amendments that would allow veterans to be appointed justices and judges. What does my colleague have to say about these amendments that were rejected?
Oui, merci beaucoup.
Yes, I'd like to thank my colleague for his question. Yes, I know that the Bloc and the NDP worked very hard with our members of the Justice Committee to make this bill move forwards. And I am very pleased to see that the member from the bloc continues to fight for C11, but unfortunately we lost the NDP member who unfortunately decided to cross to the Liberals. But my point is that as a Conservative, myself and our members share similar ideas to allow C11 to move forward, and that includes the amendments. Thank you.
Questions and comments, questions et commentaires. The honourable member for Long Range Mountains.
Thank you, Mr. Speaker, and I want to thank my honourable colleague for that powerful speech, and I just want to give her an opportunity to put a fine point on this powerful message that she's communicated with respect to I believe you and communicating that to victims, and how choice is so important to empower them in these situations. And as it relates to this legislation, I want to give her that opportunity because it's such a powerful point. Thank you, Mr. Speaker.
Honourable member for Calgary-Windapore.
Thank you very much for this opportunity. Again, there is no before doing this campaign of I Believe You, the researchers talked to numerous victims of the most heinous crime a person can receive, to have themselves violated as a person. And what they were told time and time again was they just wanted to hear someone say, I believe you. Right now, this government is not saying, I believe you, to the victims of sexual assault, and that needs to change, and it starts with C11.
Reprise de débat, resuming debate. The honourable member for Pitt Meadows, Maple Ridge.
Thank you, Mr. Speaker, and thank you to the previous speaker for her comments. And this debate is an important debate. But I was reflecting as I was making my comments here, about the new Liberal majority, and thank the members of Parliament who double-crossed the voters and who elected them 1 year ago. But anyways, we're in a situation now that the Liberals have their cherished majority government, and I was thinking of this new age, and I had a flashback of when I was in grade 3 and living in a small military base up in North Vancouver Island called Hoburg. And I was a proud member of the Gary's Singing Worms. And we had one of the songs, and it was that we sang. You may be, you're probably too young for that to remember, Mr. Speaker, but it was The Age of Aquarius that came out. It was a hit Broadway, the production Hair. Some of us are losing our hair since that time. But I won't sing it. I know, okay. But you might know the words, and I'll refresh your mind. It came out in 1969, a flower power era, love, peace. And so some of the words are, this is the dawning of the age of Aquarius, Aquarius, harmony and understanding, sympathy and trust abounding, no more falsehoods or derisions, golden living dreams of visions. And I have some words here that could very well have been penned by our Liberal Prime Minister that have the same tune, but it's the dawning of the age of majority. Our majority, Liberal majority, harmony, we can stop pretending. Questions asked will be met with no bending. More secrecy and more derision, one-party rule with tunnel vision. Committees bring recommendations, we Liberals will ignore consultations. No more listening or debate, just whip votes, no need to wait. Lovely majority, Liberal majority. I'm surprised that Liberal colleagues here are not clapping at that, but seriously, Mr. Speaker, we have moved into a new realm of secrecy, of control. I know that the Liberal members sigh, oh no, you see, as if it's not true, but he knows it's true. But what did the Liberals do? The first thing they do when they got their majority last week? Well, they moved several committees into in camera and secrecy, shut down debate, things that are uncomfortable for them. Even the liberal media organ, CBC, now that the Liberals are established, are perplexed and critical of this move, says it's sending the wrong message. We're seeing the same attitude by the Liberals in forcing closure to this debate on this important bill. They've shown their true colors towards victims of sexual harassment in the military with how they've pushed through and are pushing through Bill C-11 without the amendments that were passed within committee. And that's very unfortunate. And really, it boils down to control, secrecy, and we'll talk a bit more about that. Mr. Speaker, this debate should not be about procedure. It must not be about politics. It must be about the survivors. It must be about veterans and serving members of the Canadian Armed Forces who came before the Standing Committee on National Defence and did something extraordinarily brave. They relived some of their most painful moments of their lives publicly and on record because they believed that Parliament was finally prepared to listen. Try having to testify about one of the worst experiences of your life and then have the government refuse to listen to your voice. They testified about sexual assault. They testified about betrayal by institutions they trusted. They testified about being silenced. And above all, they testified about choice. The right to choose which justice, whether military or civilian, that would be most effective and where they could see justice served. So I ask the House, why is this government now moving to shut down debate on Bill C-11 before those concerns are fully and honestly addressed? The government tells Canadians that this bill is about supporting victims and restoring trust. If that's true, why are the ministers afraid of scrutiny? Why impose time allocations and legislation that directly affects survivors of military sexual trauma? If the government is confident that the bill reflects what the survivors want and need, then let the Parliament test that. Let the arguments be heard. Let victims know that their voices matter, not just at committee, but here in the House where laws are made. Mr. Speaker, this is about choice. They ask for a system that treats them with dignity, not suspicion. And at committee, we listened. Conservatives worked constructively across party lines with colleagues from the Bloc, NDP, and to approve Bill C-11. And together, we brought forward amendments rooted directly in witness testimony, especially the near universal request that the victims of military sexual assault be able to choose which justice system they report to. This is what collaboration looks like. That is what respect for survivors looks like. But that stands in stark contrast to this Liberal government's approach. For months, the bill has sat idle. The government did not act. It did not engage meaningfully with the victims. And then, only after securing a political, procedural advantage, it moved to rush the bill through and undo the very amendments that survivors fought for. This is not leadership. This is political expediency. And I can understand why the Liberals are this way, because they've gotten a lot of trouble on the issue of sexual harassment within inside of the military. I think of the Harjit Sajjan, and he was censured publicly at the House of Commons in 2021 on the issues of the cover-up on sexual harassment. This is a shame. And what are the Liberals doing? Well, there's an expression, plus ça change, plus c'est la même chose. Plus c'est pareil. Merci beaucoup. More it changes, the more it's the same. It's the same old, same old. Actually, it's not the same old, same old. It's actually getting worse. It's getting worse. They're giving the minister the power now to intervene and have his way. You know, it's superseding justice. That's not good. It isn't good because it's political expediency, political cover-up, and this is not what Canadians need, and it's not what the members of the armed forces need. It's a shame, Mr. Speaker. And instead of increasing the independence of military prosecutors, defense counsel, and the provost marshal, the minister is ensuring that these roles remain under political and institutional control. This does nothing. Did I say that? I said nothing to prevent sexual misconduct. It deepens the mistrust. An expression by British Prime Minister William Gladstone that said, "Justice delayed is justice denied." What does that mean? He was a Prime Minister of the UK during when time Confederation of Canada, 1860s. And it says basically that if legal remedy comes too late, it effectively means that there's getting no justice at all. And that's what's happening. They're putting it to the civilian courts, and it's already clogged up. The courts are clogged up. I had a home show in Maple Ridge over the weekend, talked to hundreds of people, including police officers and people in justice, and they're telling me that. They're just saying, they're being arrested, and the prosecutors aren't moving it forward because they're jammed full, and it's just so long. They're releasing people. And this is what their solution is, the Liberals, just to put it through into a jammed up system where they can bury it and protect themselves. This is about self-protection, self-preservation, and I just say, shame on them. Let's get a bill that really reflects what has been brought forward by the witnesses, and to protect and to help our armed forces and those that have suffered sexual assault. Thank you.
Questions and comments, questions et commentaires. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, Mr. Speaker, first to address that very quickly, the first thing that happened last week when the majority of the seats came to the Liberal Party was we actually, in collaboration, passed a Conservative motion. That's the first thing that had taken place. Now, if you take a look at today, we have a very important piece of legislation that transfers from the military justice system into the civilian justice system, which is a reflection of a report that was provided to the government a while back, Mr. Speaker, which made it clear that's what was being requested of it from an incredible individual. My question to the member, based on what his comments are, does he support the civil process at all dealing with military sexual abuse files?
Honourable Member for Pitt Meadows, Maple Ridge.
Yes, Mr. Speaker, we support choice for the victims, where they can see the quickest route to justice. Because right now, under the civilian system, it's really clogged up. But what we believe is a choice, not just for those in Canada, but from internationally also in the military. And you made reference to the report. You mentioned a few times, Madame Arbour.
I have to interrupt the member. You can't speak directly to another member. You have to speak through the chair. So I invite the member to complete his comments.
That's a rookie error, but I'm not a rookie. Okay. No, okay. But the report, Madame Arbour, she was asked to come to committee to testify. She did not come to committee. We wanted to respond to the reports, to witnesses, also to other reports have also been done, Deschamps and the Fish reports. You would not respond to this right here. Thank you.
Questions and comments, questions et commentaires. L'honorable.
The Honourable Member for Saint-Hyacinthe-Begot-Acton. Thank you, Mr. Speaker. I'd like to thank my colleague who did a great summary of a government that wasn't supposed to be a majority, which has become a majority and which is showing its complete arrogance, particularly by dismantling the amendments that were passed by a majority of parliamentarians at a committee, because that was the composition of the committee. That's what democracy wanted, that there was a majority of opposition members in this House and at that committee at that time, before certain people crossed the floor. And now to add on top of that, not only have they lost on that, they're trying to take it apart with their amendments now that they're a majority. But on top of that, they're imposing closure. And since, earlier they said, oh, listen, we're open to, discussing with others, and here they're shutting down debate. Is that not scandalous? On top of this, the cherry on the cake is that it's, it's closure on such a sensitive issue as this. Well, the member is absolutely right with his comments. And it's terrible what the Liberals are doing here with something as serious as this. They're putting politics ahead of crimes, ahead of justice, and it's just, to protect themselves. And through you, Mr. Speaker, it's really, really terrible what they're doing.
Questions and comments? Questions et commentaires.
The Honourable Member for Louis Saint Laurent, Akiawenrek. Thank you very much, Mr. Speaker. I'd like to thank my colleague for his interesting speech with a lot of historical references, except when he talked about the song Aquarius from the 1960s. For me, Aquarius is more the name of the Apollo 13 lunar module, which saved the lives of the 3 astronauts of Apollo 13. Now,
about that. When we talk about ethics, the member rose a lot of issue about ethics, and this is very difficult when we are talking about a new cross-floor government with a majority, with those people who cross the floor. So my question is to the member: Est-ce que le député?
Is the member surprised to see that the Liberal Party at the Ethics Committee appointed someone who was a floor crosser?
Committee, we are talking about someone who crossed the floor.
The Honourable Member for Pitt Meadows, Maple Ridge, in 30 seconds. Well, in English we would say that it's poke you in the eye. It's really, it's what we see when the floor crossers, they put them right beside the Prime Minister. It's really just to say, oh, listen, look, our trophy. Look at our trophy. They have no shame. They have no shame, those who've crossed the floor. But also the Liberals have no shame.
About the Honourable Member for Cambridge.
Thank you, Mr. Speaker. I rise today on behalf of the people of Cambridge with a deep sense of responsibility to those who have served and those who continue to serve in the Canadian Armed Forces. These are men and women who have committed their lives to protecting our freedom and preserving peace, often at great personal cost. When they raise their right hand to serve our country, they deserve to know that Canada will protect them in return, not only on the battlefield, but with the very institutions they trust for support, justice, and dignity. We are here to debate Bill C-11, an act to amend the National Defence Act and other acts, legislation that speaks to a serious responsibility, how we address sexual misconduct in the military and support those who come forward. At the Standing Committee on National Defence, Conservatives, the Bloc Québécois, and the NDP worked constructively across party lines, guided by the testimony they heard and by a shared understanding that we needed to get this right for survivors. At the core of this issue is a principle that should unite us all. Every victim of sexual violence deserves justice, safety, and dignity. They deserve a system that works for them, not against them. Mr. Speaker, I also want to speak directly to the survivors who came forward and shared their experiences with this Parliament. You did not have to do that. You did not owe us your stories, your pain, or your trust. You came because you believed that if Parliament truly listened, change was still possible, that trust matters, and it carries an obligation in all of us. That is why Conservatives have remained focused on standing with survivors of military sexual trauma, and why we believe meaningful reform must begin by listening to those with lived experience. Unfortunately, the government has not demonstrated that same willingness to listen. Mr. Speaker, the Minister of National Defence acknowledged at committee that he did not personally consult victims in developing this legislation. Instead, the government has relied on external reports without ensuring that those perspectives were fully tested through the legislative process. The Liberals delayed this bill and are now moving to advance it in a way that risks undoing the very improvements that were made at committee. That approach raises serious concerns about whether the final legislation will truly reflect the needs of those it is intended to support. At the same time, key witnesses made it clear that removing choice would have real consequences. What survivors asked for was not privilege or special treatment. They asked for one thing: choice. The ability to decide which system they felt safe disengaging with, which process they understood, and which path would allow them to be heard with dignity and respect. Survivors spoke about access to language, to support systems, and to processes they understand. They spoke about trust and how critical it is in determining whether they feel safe coming forward at all. The government's approach in Bill C-11 is to move cases of sexual assault into the civilian justice system. While that may be appropriate in some circumstances, it cannot be the only path forward, particularly given the current pressures facing that system. Across Canada, civilian courts are dealing with significant backlogs. Delays have significant impacts. They are a reality that affects victims. And when cases are delayed beyond acceptable timelines, they risk being dismissed. We have seen this happen. Cases are not always resolved on their merits, but instead are halted because the system cannot meet the timelines required. For victims, that is not just frustrating, it is devastating. And yet the government's proposal would add further pressure to that already strained system without providing a clear plan for additional resources or capacity. That raises a fundamental question. How does this improve access to justice? Mr. Speaker, witnesses also warned us that this is not an imaginary concern. We heard evidence about capacity on the ground. In one study examining cases at CFB Esquimalt, hundreds of incidents were reviewed, yet only a small number met the threshold for referral into the civilian system. Even then, prosecutors indicated they had the capacity to proceed with only a handful of cases each year. And that reality matters, because when capacity does not match policy, the result is not more justice. It is fewer cases moving forward and fewer perpetrators held to account. When policy ignores those realities, the impact is not abstract. It risks re-traumatizing those who have already been harmed and reinforces the very institutional barriers survivors have told us keeps them silent. Mr. Speaker, several witnesses cautioned against exactly this approach. They warned that removing the military's role entirely could reduce accountability, weaken discipline, and ultimately fail to deliver justice to survivors. Others pointed to the importance of maintaining concurrent jurisdiction, allowing both systems to operate, and allowing victims to choose the path that best supports them. That is the balance that was reflected in the amendments brought forward at committee. It is also important to recognize that the Canadian Armed Forces have taken steps in recent years to improve how these cases are handled within the military system. Those efforts are not perfect, but they should not be dismissed outright. Reform should build on progress, not regard it. Mr. Speaker, meaningful reform must also be about culture change. Survivors have told us clearly that systems which remove choice or create dead ends can reinforce institutional trauma rather than reduce it. The Arbor Review played an important role in advancing this conversation, but it was written before key changes were fully implemented, including the removal of the duty to report and the strengthening of survivor-centric support mechanisms. It should not be used as a static justification for reversing progress that is still taking hold. If reform undermines trust or reduces the likelihood that cases proceed at all, then we are not fixing the system. We are weakening it. Mr. Speaker, this is not about choosing one system over another. It is about recognizing that both systems have a role to play and that victims deserve the autonomy to decide which is right for them. Removing that choice does not simplify the process, it limits it. Mr. Speaker, addressing sexual misconduct in the military is not a simple task, and no single reform will solve it entirely. But we do know that progress requires more than good intentions. It requires listening, collaboration, and a willingness to incorporate the perspectives of those most affected. That is why the work done at committee is so very important. Conservatives are proud of the progress that was made alongside colleagues from other parties to improve this bill. The amendments that were brought forward were not partisan. They were grounded in the testimony of witnesses and the practical realities of the systems involved. Our position is clear. Support for this legislation must be tied to maintaining those improvements, particularly the principle that victims should have the autonomy to choose the system that best meets their needs. More broadly, Canadians expect us to ensure that both the military and civilian justice systems are equipped to handle these cases effectively. That means not only determining where cases are heard, but also ensuring that whichever system is used has the capacity, resources, and structure to deliver timely and fair outcomes. Mr. Speaker, the men and women of the Canadian Armed Forces serve this country with professionalism and dedication. They deserve to work in an environment that is safe, respectful, and accountable. Survivors of sexual misconduct within the military have spent years advocating for change. Many have done so at great personal cost with the hope that future generations will not face these same challenges. Survivors did not come to Parliament as partisans. They came as human beings asking to be heard. Respecting that courage requires more than sympathy. It requires that we act in a way that honors what they told us. If this Parliament is serious about supporting those who serve, then we must ensure that Bill C-11 reflects what we have heard, that victims deserve to be listened to, that they deserve timely access to justice, and that they deserve the autonomy to make decisions about how their cases proceed. Mr. Speaker, that is the standard we should be striving for as members of Parliament. Thank you.
Questions and comments. The Honourable Parliamentary Secretary to the Government House Leader.
Yes, thank you, Mr. Speaker. And I don't have a problem in saying that is the standard in which the government has been hoping to be able to achieve. If you take a look at the recommendations, it's not just one recommendation that came from the former Chief Justice, Mr. Speaker. 48 recommendations in order to deal with a very serious issue. And that issue, I believe it's over 3 dozen have actually been implemented. This is one which is absolutely critical. And then when I reflect on the fact that we have an incredible Canadian that presented a report based on a lot of consulting, working with victims and CAF members of all in many different capacities, coming up with this recommendation that C-11 supports. I'm wondering if the member can tell us when was it that the Conservative Party changed their position on transferring over to the civilian court only?
The Honourable Member for Cambridge.
Mr. Speaker, choice is putting the empowerment back in the hands of the victims. At the heart of this very bill is a very simple issue: choice for victims. Survivors who appeared before committee were clear, and they want the ability to decide whether their case proceeds through the military justice system or the civilian justice system, based on where they feel safest, best supported, and most likely to be heard. The approach that came forward respected that by allowing both systems to continue to play a role, rather than forcing survivors down a single path. What the government now is proposing would remove that choice by shifting everything to the civilian system. You know, and that just undermines the trust from the very people we are asking to come forward. We need to get it right, not just get it done quickly.
Questions and comments. The Honourable Member for Abitibi-Témiscamingue. Thank you, Mr. Speaker. I'd like to thank the member for Cambridge for her sensitivity, because she started her speech and ended it by talking about those who served our country and who have come out of this with physical issues and trauma, and they need help. And we heard about this at committee. And I'd like to hear from my colleague if she thinks that one of the political repercussions of this, because they ignored these voices, even though they were brought by members of the committee at voices and even adopted at committee, and they were just ignored. What message are we sending to these people who have served our country?
Mr. Speaker, I thank the member for his question to me. The amendments that were proposed at committee reflected what the survivors were saying, and we need to respect their voices and ensure that those who serve are protected, the same way that we expect them to protect us during wars. Conservatives will always stand up and support this choice. It's the victims that can decide where they'd like their case to be heard, not the government.
Questions and comments. Questions et commentaires. The Honourable Member for Windsor West.
Thank you, Mr. Speaker. Mr. Speaker, it's clear for anyone to see that this government is engaged in neglect of duty on this file and others. Through you to my honourable colleague, what message is this debate sending to the victims who have already come forward and are watching this show? What message does it send to future soldiers, sailors, and airmen and their families who are probably wondering if they ever are a victim, will they be taken seriously? And will their complaint heard properly?
The Honourable Member for Cambridge.
Mr. Speaker, I thank my colleague for his great question. It's a very important one. And what I keep coming back to and what should matter to all of us is what veterans or survivors have been telling us. Some had the courage to appear before committee, which is hard enough to do on its own. Others have shared their experiences in different ways. But in every case, they did so because they believed their voices would matter here. We cannot acknowledge those voices and then move forward in a way that leaves people feeling their input was heard politely and then set aside. That sends the wrong message, especially to the veterans and survivors who already struggle with whether it is safe to come forward at all. Respect means more than listening once. It means taking seriously what they said, especially about trust, choice, and feeling safe in the process. If we want people to keep coming forward, we must show what they shared actually matters in the decisions that we make here.
Time for a short question and comment. Nous avons temps pour une courte question.
Time for a quick question or comment.
Cowichan, Malhat, Langford.
Thank you, Mr. Speaker. It's curious the party opposite has the same person ask the same question. They're dogmatically hanging on, be it in the House or in committee and debate, on the Arbor report while overwhelmingly ignoring the plethora of evidence and reports. And so maybe the member could speak briefly. Why are they ignoring this so much and hanging on one dated report? Thank you.
The Honourable Member for Cambridge.
Mr. Speaker, great question, but it's really hard to determine what's going on here since the government now has their manufactured majority. But the Arbor report has been an important part of this discussion, but it should not be treated as the final word. Madame Justice Arbor was invited to appear before committee so members could ask questions and examine her recommendations in light of today's reality, but that did not happen. Since then, the Director of Military Prosecution has told committee that the military has adjusted and is prepared to handle these cases. Reform has to reflect where the system is today and not where it was many years ago.
Resuming debate. Reprise de débat. Resuming debate. Reprise de débat. Is the House ready for the question? I see the member for Nanaimo Ladysmith rising on debate. The Honourable Member.
Thank you, Mr. Speaker. Bill C-11 was supposed to improve how justice works inside the Canadian Armed Forces. There have been serious and persistent concerns that misconduct, especially sexual misconduct, has not been handled fairly or independently in our military. The government dragged its feet for years. There were 3 reports done on this matter for over a period of 7 years. Finally, with the tabling of this bill, the government appeared to be addressing these issues. The initial draft of the bill proposed to move serious cases, including sexual assault, into the civilian courts. Many expected this move to be welcomed and to be seen as a serious step towards better accountability and stronger protection for victims. The committee system in the House of Commons is designed to allow members of Parliament to examine legislation in depth. Committees act as the engine room of this place, Mr. Speaker, and every so often we find out in our committees that we were wrong. That is what happened with this bill, because it turns out that our military did not wait for government to act. In the years between the release of the Deschamps, Fish, and Arbour reports, our military implemented mandatory duties to report. They trained the chain of command, military, police, and healthcare providers. They implemented a victims' rights charter and provided access to independent legal supports and access as well to victim liaison services. They haven't solved all of the problems, Mr. Speaker, but they took some pretty big steps forward that make military tribunals the forum of choice for some victims. An incredible and very credible group of witnesses came to the Defense Committee hearings on this bill and told us so. In response, Conservative members of the Defense Committee worked with members from all opposition parties to improve this bill, to respond to the reasonable proposals by survivors and experts that military sexual assault victims be allowed to play a role in determining whether their cases will be investigated and heard in civilian or military courts. They asked for choice, and the committee worked to embed that choice into this bill. And then, a few days ago, the Minister of National Defence tabled amendments to this bill at the report stage that ignored that advice, dismissed the testimony heard over weeks at committee, and effectively restored much of the original drafting. When I last rose to speak to this bill, I tried to drive home the point that this debate is about more than just legislation. It's about trust. It's about whether those who don a Canadian military uniform and serve this country can trust that the system will protect them, that they can trust it to be fair, that they can trust it to deliver just outcomes. Yesterday, I spoke at a ceremony in my community commemorating the 81st anniversary of the Battle of the Atlantic. We had more than 50 Air and Sea Cadets participate, more than 50 young souls that are the future of our military, souls that Canada may yet send off to war. And the cadets were excellent, Mr. Speaker. They participated in the color guard. They stood sentry at the cenotaph. They helped dignitaries lay wreaths. One played the last post and the lament on her bugle. Another read the prayer for the Air Force. And another read the roll call of ships lost, while yet another rang the bell. It was beautiful and inspiring, and our community is so very proud of them. Today, as we debate this bill at report stage, the question of whether or not those cadets and the many others who serve our country can trust the system still hangs over this chamber. Have we earned that trust? If the answer depends on this version of Bill C-11, the answer is unfortunately a resounding no. Members of this House worked in good faith across party lines to improve this bill, and we stand by the wisdom of the committee with respect to choice for survivors of sexual assault in the military. My support for this bill is contingent on the Liberal government upholding not only the amendments made by Conservatives at the Defence Committee, but also those made by the other parties, including the member of that committee that has since crossed the floor to join the Liberals. Will she now vote against her own amendments and those she supported? The Liberals have chosen to use their new majority in this House to undo the work of this committee, Mr. Speaker. And in that, they have chosen to double down on what we now understand to be a poor choice to push sexual assault cases onto an already overburdened civilian police and court system without providing the resources that local police forces and provincial courts need to deal with military cases. And instead of listening to the experts and increasing the independence of the military justice system, the Defence Minister wants to preserve his ability to interfere with ministerial directives to ensure that the Director of Military Defence Council Services, the Director of Military Prosecutions, and the Provost Marshal General stay under the thumb of the chain of command. These decisions are all ill-advised, Mr. Speaker, and they will do nothing to improve conditions in our military at a time when our military needs our support. If there is even a perception that decisions can be influenced by the chain of command or by political considerations, confidence in the military justice system will remain fragile. My honourable colleague from Cowichan, Malahat Langford, who served our country faithfully as a Navy commander, spoke to that human cost in a way that should stay with all of us. He reminded us that behind every policy gap, behind every delay, there is a person, someone who stepped forward to serve, who put on a uniform, and who deserves better from their country. Every time this government fails to protect victims, it means another member of the Canadian Armed Forces is left wondering whether it is worth coming forward. It means another survivor weighing the risk of speaking out against the likelihood of being ignored. It means another erosion of confidence in an institution that Canadians should be able to believe in without hesitation. The Minister of Defence admitted at committee that he did not consult victims himself. He admitted that he did not consult with Justices Arbour, Fish, or Deschamps on this file. He admitted that he did not consult provincial justice ministers or provincial or municipal police officers in the more than a year since this chamber considered Bill C-66, the predecessor to this bill. This reflects a disturbing trend that we see through the Liberal approach to our justice system, where government legislation seems to consistently prefer the accused over victims. It also reflects the approach that this government took to Bill C-3 at the report stage, when they again used their relationships in this House to undo the work of committee. In the context of the way that our military has progressed these issues, the request by witnesses for choice in deciding whether to engage the civilian justice system or the military tribunal system makes sense, because in some cases, the military system will have conflicts of interest or other issues created by proximity or relationships. In other circumstances, the civilian justice system just won't have enough people with the lived experiences to be able to deal with the facts of a particular case when situated within military culture. In one case, a witness to committee testified that as a francophone, she would like to be able to choose the military pathway to ensure that she would be able to have access to services and proceedings in French, rather than having to follow proceedings in English, as she would have had to do through the serendipities of locations should she find herself in an Anglophone province serving. And cases are going to move to civilian, and if cases are going to move to civilian courts, Mr. Speaker, there is work to be done up front with the provinces to make sure they can absorb these cases. If the federal government simply moves these cases by fiat without ensuring that the system is ready, we risk serious failure, the kind of delay that increases the risk that cases collapse before they are heard and further frustrates those seeking justice. Canadians have heard promises from this government before. They have seen announcements. They have seen commitments. But too often, they have not seen results. My honourable colleague from Selkirk Interlake Eastman has been persistent in pressing this point. Mr. Speaker, this is not an abstract policy debate. It is about real people and their real pain. And the government has a choice to make. And my vote hinges in the balance with that choice, Mr. Speaker. Thank you.
Questions and comments. Questions et commentaires. The Honourable Member for West Hamilton, Ancaster Dundas.
Thank you, Mr. Speaker, and I appreciate the speech from the member opposite. I too was at the commemoration of the Battle of the Atlantic over the weekend at HCMS Star, speaking to the commander about the generational investments our government is making in the military, increasing recruiting, seeing the youth, the recruits, the men and women in the reserves, the veterans. And this bill is all about supporting those in the military and ensuring that the victims are supported and trusted. Working with Justice Arbour's recommendations, she mentioned civilian courts. I was wondering if she could expand on what needs to be done specifically, provincial courts. What more needs to be done at the provincial level to make sure that prosecutions that are done at the provincial courts are successful? Thank you.
Honourable from Nanaimo, Ladysmith.
Thank you, Mr. Speaker, and I commend my honourable colleague for his desire to support the military. But as he was in committee, what he would have heard is that people in the military need this choice in order to be supported. And while Madam Justice Arbour's recommendations were right for the time in which they have made, the government took so long to act that there are better ways to address this, Mr. Speaker. Thank you.
Questions and comments. Questions et commentaires. L'honorable.
The Honourable Member for Saint-Hyacinthe-Bagot-Acton. I'd like to thank my colleague for her speech. She talked about the work we did at committee, and it showed that when they had a minority government, because that's when how they were elected a year ago, they didn't have a majority government. It showed that they were able to do something together. And I'm a block member of this committee. I worked a lot with my Conservative members and the NDP member on this. They proposed similar motions to what we ended up adopting. But what does she think about the fact that now this consensus is threatened by a government that is no longer a minority government, even though it's pretending that it's extending a hand to us, and now they are ending debate. I'd like to thank my honourable colleague for his great question.
That I really struggle with, Mr. Speaker, because we face allegations every day in the House from our colleagues across the way that we are obstructionists, that we are standing in the way. And yet, this bill offers a phenomenal opportunity of the way that members of all parties work together to listen to Canadians to make a bill better. And it hurts my heart that they would use their majority in this way to, quite frankly, strip this House of the good work that was done at committee.
Questions and comments? Questions et commentaires. The Honourable Member for Selkirk, Interlake Eastman.
Thank you, Mr. Speaker. I want to thank my colleague from Nanaimo, Ladysmith, for her very strong speech and taking the time to actually review the testimony that we heard in committee and using that in her debate today on Bill C-11, and now that we have closure on it. The Liberals continually are using the Arbor report as their shield on why they're plowing ahead with these changes, which the military and justice experts and veterans are saying that they do not want. The interesting fact in this is that the committee heard from the very survivors of military sexual trauma who also talked to Justice Arbor, and they've discovered that over the last 5 years, since they brought in the choice in the system and got moved over into the civilian system, that they were not receiving justice because of the Jordan framework, because of the higher thresholds to actually prosecute. And at the end of the day, there is no accountability within the chain of command. Will my colleague please comment on that as well?
Honourable Member for Nanaimo, Ladysmith.
Thank you, Mr. Speaker. I want to thank my colleague for that question because I actually happen to have had the privilege, before I was elected to this place, of being able to work with Madam Justice Arbor for a year when I worked at the ICTY in The Hague. And I know the kind of work that she does, and there is no doubt in my mind that had that the work that she did and the report that she provided was one of the things that allowed the military, our military, to be able to make progress with respect to the issues that are addressed in this bill. I only wish that the Defense Minister had taken the time to listen to people the way that Madam Justice Arbor does, and possibly to consult with her so that we would know so that we could have avoided the mistakes that were made with this bill. Thank you.
Resuming debate, reprise de débat. The Honourable Member for Fort Saskatchewan, short report for Saskatchewan.
Thank you, Mr. Speaker. I want to begin my speech today by just sharing with members that before coming to the House a few minutes ago, I was at a screening on the Hill of the documentary film Traces, which is about the issue of conflict-related sexual violence in Ukraine. It's a great honor to have with us on the Hill the director of that film, who shared directly with us about her own experience being a victim of conflict-related sexual violence and the work she's done on this film. And I think it's important for the House to know and to reflect on the fact that as part of the illegal, genocidal, ongoing invasion of Ukraine, we are seeing the systematic use of sexual violence as a tool by the invaders for terror, and it should underline our knowledge of the horrific nature of this invasion and the need for ongoing Canadian support for the Ukrainian people. Mr. Speaker, we have before us today Bill C-11, which is a bill that makes changes to the military justice system in this country. And fundamentally what we're seeing in debate at this stage of this bill is the tragic implications of the Liberals seizing an undemocratic majority and what they are doing with that majority to undermine the important collaborative cross-party work that was done on legislation in this chamber prior to the seizure of that undemocratic majority. Now, this is a bill about a somber, serious subject, protecting victims or trying to protect victims of sexual violence. And it's an issue on which parties should be able to work together. And from what I understand, I'm not a member of that committee, but work happened at committee on this bill, bringing together people from different party backgrounds to try to incorporate all of the feedback that was received by survivors to make this legislation effective. It's not and it shouldn't be a partisan issue, which is why Conservatives, New Democrats, members of the Bloc listened to the testimony, came together, put forward amendments to this bill that reflected that testimony, that strengthened that framework, and established through those amendments a framework that would have really worked and gone as far as possible to protect these victims and survivors. From what I understand, even government members on the committee supported some of those amendments that the opposition worked on together. And at the time, the member for Nunavut was with the NDP caucus and was her party's defense critic, working with other parties on this legislation. That was the cross-party work that happened, and really that has to happen in a minority parliament. In a minority parliament, one party cannot dictate the outcome of legislation, which requires negotiation, which requires listening to witnesses and listening to each other. In the context of a minority parliament, this legislation was an example of that collaboration at its best, of members of parliament rising to the occasion, working through the difficult issues, listening, and coming to conclusions. And then what do we have? What do we have now? Mr. Speaker, the government has systematically, regardless of worldview, lured and then neutered members of the opposition to join and give them a majority government that Canadians did not vote for. And now they are using that undemocratic majority to undo the work that was done at committee. They've moved motions in this House to undo the work that was done painstakingly at committee, listening to survivors, strengthening the legislation. That work has all been ignored and undone through a motion proposed by the government. They believe now that they can rely on all the members of their newly formed undemocratic majority to undermine the collaborative work that was done on this issue at committee. Shameful. And the member opposite, I believe, from Ajax is heckling me to say majority prevails. Mr. Speaker, Whitby, I'm sorry, I do want to make sure he's held accountable for heckling during a speech about protecting victims of sexual violence. The member for Whitby says majority rules. Well, this is a majority that Canadians did not vote for. And this is a majority that, in the first instance, they are using to undo collaborative committee work on protecting victims of sexual violence. You know, they want a majority, they say, to move at speeds unseen in generations. Mr. Speaker, they are moving at speeds unseen in generations to dismantle collaborative committee work to protect victims of sexual violence. That is what they are, the first opportunity they have using their majority to do. And I have to wonder what the member for Nunavut is thinking in all this. Individual members, whatever caucus they sit in, are still personally accountable before their voters and before whatever other institutions they see themselves as accountable in front of, for the decisions that they make in this House, for the votes that they cast in this House. And when you sit as part of the NDP and work collaboratively on amendments to strengthen legislation to protect victims of sexual violence, and then you join a caucus that is systematically undoing and ignoring the work that was done, it's hard for me to understand the dissonance. Whether a person just changes all of their opinions at once, or whether some members of the government intend on standing up against the efforts of the minister and the front bench to dismantle this legislation. At the end of the day, every member controls how they vote when the time comes. And they will have a chance to specifically vote on the decisions of this minister and this government to undo the work that was done. But Speaker, this is the real concrete outworking of the Liberal seizure of an undemocratic majority. It is that it now gives them, in practice, the ability to ignore what witnesses say, ignore collaboration, ignore the work that can be done across parties, to actually analyze an issue from different angles and get to a result. They can completely ignore that, and the Prime Minister can just act as a kind of executive and direct all of the affairs that happens in this place. That's not how it should happen. That's not what Canadians voted for in this last election, but it seems that's what they want. And their first test case for this is undermining protections for victims of sexual violence. It's shameful what's happening, Mr. Speaker. It is undemocratic, it is wrong, and it will have serious negative implications for survivors who are seeking justice in the future. I want to commend the members of the committee who worked hard on this. I want to commend our Shadow Minister for Defense, as well as members of other parties who worked collaboratively on this process, but who sadly saw all of that work undone when the government decided to move these motions rejecting these amendments. Mr. Speaker, in this context, with this undemocratic majority, we will continue to use all of the tools we have to hold the government accountable and to fight for what is right. And government members, ministers need to hear from their constituents. They need to hear demands from their constituents that the government reverse course and stand with victims of sexual violence. I think the member for Nunavut needs to hear from her constituents on this, asking her to stand with the work she previously did on committee.
And veterans.
And I think we need to see a response from the public that holds the government accountable for what they're doing right away with this undemocratic majority.
Questions and comments? Questions et commentaires. The Honourable Parliamentary Secretary, the Government House Leader.
Yes, thank you. Mr. Speaker, Madam Arbour did an extensive consultation with victims, with members of CAF, many other stakeholders, and came up with an incredible report, 48 recommendations, in order to deal with the complexities of the issue. 36 of those have already been implemented. Wow. The Government of Canada has been listening and has taken action. This very piece of legislation is an enactment of recommendation number 40. I believe, taking a look at the bigger picture and the support since the last year with this Prime Minister, whether it's 2% of the GDP, whether it's huge numbers, a record number of people applied to join the forces last year. I believe we are on the right track. When was the last time the Conservative Party...
I have to interrupt the member to give a chance to the member for short report for Saskatchewan to respond.
Thank you, Mr. Speaker. That was a question that went madly off in all directions. Yeah. This is a bill about protecting victims of sexual violence. And we can have a conversation about military spending and capabilities and all these other issues. But fundamentally, here's the point. The committee heard directly during its deliberations from victims, from experts, for those who know this process best. A majority of that committee, representative of the House of Commons that Canadians elected, chose amendments to strengthen the bill and respond to the testimony they heard. Then Liberals used an undemocratic, stolen majority to try to undo all that work.
Question et commentaire, l'honorable. The Honourable Member for La Pointe de l'Île. Thank you. Yes, when we listen to the members of the government, sorry, there's a little bit of chattering happening. When we hear government members say that they want to consult and they want to work with the opposition, and then they do this kind of thing, they just kick out all amendments, it kind of shows how hypocritical they can be. And I think that's what feeds criticisms against them, and it makes people rather cynical about politics as a whole. The opposition wanted there to be an office of an Inspector General that would study sexual misconduct in the armed forces. That will be abandoned as an amendment. I don't understand how the government can defend that decision. What does my colleague have to say about that decision?
L'honorable député de Sherwood-Port for Saskatchewan.
Merci, Monsieur.
Thank you, Mr. Speaker. I agree. From the bloc, I would like to thank him for the work that we were able to do as opposition parties. He mentioned hypocrisy in the Liberal ranks. They tried to eliminate the need for cooperation, and immediately thereafter, they decided to completely change this bill. It's true. It's a show of Liberal hypocrisy.
Questions and comments. Honourable Member for Long Range Mountains.
Thank you, Mr. Speaker, and I want to thank my colleague for his incredible speech, and I just want to draw attention to the fact once again, the heckling and the comments about majority rules while he's trying to communicate during his speech. And I just want to give the member an opportunity to speak to what further message that sends to victims and other people who may be looking to see what the government's response is on this important piece of legislation. Thank you, Mr. Speaker.
For Sherwood-Port for Saskatchewan.
Well, thank you, Mr. Speaker. This certainly is the sort of issue where we would hope for cross-party collaboration and hope to not have a spirit of partisanship. And from what I understand, that spirit of collaboration was what prevailed at committee. And it prevailed in a context where cooperation was required because of the minority conditions that Canadians voted for. Okay, if you win a majority at the polls, fair enough. You've got a mandate from Canadians to proceed as a majority. But if Canadians vote for a minority that necessitates cooperation, and then you try to throw that out the window, and then you act in this ultra-partisan fashion, we're trying to advance solutions for victims, that's inappropriate.
Resuming debate. Reprise de débat. Resuming debate. Reprise de débat. Est-ce que la Chambre est prête pour la question?
Is the House ready for the question?
La mise aux voix porte sur la motion numéro 1.
The question is on motion number 1. Mr. Bazin, seconded by Ms. moved that Bill C11 be amended by deleting the short title.
In person wishes that the motion be carried or carried on division, or if a member of a recognized party I see the honourable member for Selkirk Interlake Eastman.
Mr. Speaker, we'd like to request a recorded vote.
So stands deferred. The question is on motion number 4. A negative vote. I have to. The recorded division on the motion stands deferred. I need the other one. There are more motions. So the question is on motion number 4. A negative vote on motion number 4 requires the question to be put on motion number 5. Mr. Bazan, seconded by Mrs. Wagenthal, moved that Bill C11 be amended by deleting Clause 8. If a member participating in person wishes the motion be carried or carried on division, I see the honourable member for Selkirk Interlake Eastman.
Speaker, I'd ask for a recorded division.
The recorded division on the motion stands deferred. The question now is on motion number 2. A negative vote on motion number 2 requires the question to be put on motion number 3. Mr. Bazan, seconded by Mrs. Wagenthal, moved that Bill C11 be amended by deleting Clause 7. If a member participating in person wishes that the motion be carried or carried on, I see the honourable member for Selkirk Interlake Eastman.
And Mr. Speaker, again, I'd like to request a recorded division.
So that recorded division also stands deferred. The question is now on motion number 6. A vote on this motion also applies to motions number 7, 8, and 10 to 12. Mr. McGinty, seconded by Mr. Fuhrer, moved that Bill C-11 in Clause 9 be amended by deleting lines 6 to 13 on page 8. A member participating in person wishes that the motion be carried or carried on division, or I see the honourable member for Selkirk Interlake Eastman rising.
Mr. Speaker, I'd like this motion to also be a recorded division.
The recorded divisions, the recorded division on the motion stands deferred. This part here will also apply. I have to read this part here again. The recorded divisions will also apply to motions number 7, 8, and 10 to 12. The question is on motion number 9. Mr. Bazan, seconded by Mrs. Wagenthal, moved that Bill C-11 in Clause 18 be amended, A, by replacing line 24 on page 10 with the following. Officer or non-commissioned member or former officer or non-commissioned member who is a barrister. B, by replacing in the English version line 26 on page 10 with the following. Province and who has been or was a member of the Canadian. Now, if a member participating in person wishes that the motion be carried or carried on division, or if a member of a recognized party I see the honourable member for Selkirk Interlake Eastman rising.
Yeah, I'd request that the be a recorded division as well, Mr. Speaker.
So the recorded division on the motion stands deferred, and now pursuing Standing Order 45, the recorded divisions stand further deferred until Tuesday, May 5th, at the expiry of the time provided for oral questions. I see the Honourable Parliamentary Secretary for the Government House Leader rising on a point of order.
Yes, thank you, Mr. Speaker. I suspect if you were to canvass the House, you'd find unanimous consent at this time to call it 7:12, so we can get into the late show.
The members have heard the terms of the motion. Are the members agreed? Sure. So agreed and so ordered. Order. In accordance with Standing Order 38, a motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn. The honourable member for Algonquin, Renfrew, Pembroke.
Mr. Speaker, I'm pleased to rise on behalf of the answer-seeking Canadians in the riding of Algonquin, Renfrew, Pembroke. Last week, I asked the government if they would end the corporate welfare spending spree and balance the budget. The response from the Parliamentary Secretary for Minister of Defence, Finance, was a misogynist personal attack. This has become a recurring talking point from the Liberal Bro Caucus. They can't defend their terrible policy, so they resort to invoking the hysterical woman trope. This sexist pattern comes straight from the top. The Prime Minister does not like to be questioned by women. He gets chippy and condescending when pressed. He even deployed a classic gaslighting technique when he told Rosemary Barton to look inside herself when she asked about his conflicts of interest. Mr. Speaker, let's be clear. I'm not raising a point of privilege. This is no place for a thin skin. I'm happy to throw partisan haymakers, and I can appreciate a sharp, devastating rejoinder. The Secretary's ad hominem attack was just blunt and boring. It was less Cicero in the forum and more Archie Bunker in the lazy boy chair. After 11 years of failure, all these Liberals have left are tired, worn-out personal attacks. This shouldn't be a surprise considering their policies are just as tired and worn out. The Liberal Sovereign Debt Fund is just repeating the failure of the Clean Growth Fund. The Clean Growth Fund is just repeating the failure of the Canadian Infrastructure Bank. The Infrastructure Bank is just repeating the failure of the Supercluster Strategy, and the Supercluster Strategy was just the Liberals doubling down on the failure of the Cluster Strategy. The Liberals continue to fail over and over again, yet never learn a fundamental lesson. You can't beat the market. It doesn't matter if you have a PhD in economics from Oxford. No one is smarter than the collective decision-making of 40 million Canadians. Unfortunately, while no one person can outsmart the market, you can outsmart a government. Call this the Enron Brookfield business model. Rather than compete in the market, you lobby government to regulate a market into existence, then regulate out the competition. You don't need a secret cabal to execute this strategy. Just put the word sovereign before your business pitch and watch the CBC lobby for you. Rebrand your concrete slab into a sovereign spaceport and wait for the government to give you a 10-year exclusive sole source contract. Unlike the arrogant liberal approach, our conservative economic plan is based in humility. We can't know the future, so we let 1,000 flowers bloom. We create the conditions where anyone with a sound business plan has a chance to build a successful venture. We won't pick and choose who gets special political exemptions from liberal red tape. We'll cut the liberal red tape and lower taxes for everyone equally. This is the same approach millions of Canadians take to investing. They don't try to pick individual stocks. They purchase exchange trade funds to buy the market. This agnostic approach to economic growth has proven to be superior to the Liberals' faith-based approach. Unfortunately for Canadians, they're stuck living in the church of climate socialism for the next 3 years. This is the choice Canadians will face next time. Our conservative approach, rooted in reality and humility, or the liberal approach, based on economic arrogance, defensible only through personal insults.
The Honourable Parliamentary Secretary, the Minister of Finance.
Okay, well, I'm really glad to be here this evening to answer the member's question, the member for Algonquin, Renfrew, Pembroke. Wow, she's very, I would say, entertaining in her remarks. Canadians know that these are uncertain times and that global volatility is something that our government takes seriously. Responsible leadership is really what matters more than ever. Around the world, inflation, conflict, economic volatility are putting pressure on families and governments alike. In response, our government is focused on what we can control, which is managing public finances responsibly while investing where it matters most. Mr. Speaker, that's exactly what the Spring Economic Update delivers, or at least shows progress. Canada enters this moment from a position of strength. Our economy has proven more resilient than anticipated in the face of global disruption. Inflation remains within the Bank of Canada's target range, and investment and business confidence are recovering after two massive shocks, one being the oil price shock and the one before that being the tariff war. These strong fundamentals that we've reported on in this Spring Economic Update allow us to make smart, targeted choices without compromising fiscal discipline. Fiscal responsibility means making sure every dollar works harder for Canadians. That is why our government is preserving fiscal sustainability for future generations, keeping debt manageable, maintaining Canada's long-standing fiscal advantage among G7 countries. The member opposite will note that the IMF has recently said that Canada has the strongest fiscal position in the G7. We had that confirmed by the Bank of Governor today in Finance Committee, who said the same, that we are the envy of many other countries. Mr. Speaker, our government is committed to reducing spending on government operations. We generated $60 billion in savings over 5 years to ensure public funds are focused on high-impact priorities rather than administrative costs. We also have moved forward with a capital budgeting framework so that a greater portion of the investments that the government is making can be seen to be revenue generating and can be separated out in terms of reporting so we can understand what impact those have. So we're focused on high impact priorities, including building more homes, advancing major nation building projects, strengthening our defense industry, unlocking private investment across the country. We're really seeking to catalyze $1 trillion in investment. We're well on our way. We've seen lots of commitments to invest in Canada, with the UAE committing $70 billion. Australian investors committed $10 billion, about $125 billion for 15 major projects that we'll see creating about 60,000 or more jobs across Canada. These are results that Canadians can bank on. We're also seeing some of the results of this with productivity and boosting deductions that we've offered to businesses that are investing in R&D, IP protection, new technology, information technology within their businesses, etc. There's a number of different tax deductions that we've offered which are allowing businesses to invest in themselves, in turn boosting productivity in the economy. We're seeing wages double the pace of inflation. That's a trend that's been continuing to increase year over year for 3 years now. And that's good news for Canadians, because I know we all can agree that productivity is and needs to continue to rise in order to see that standard of living rise as well, which is what Canadians all want to see. Thank you.
The Honourable Member for Algonquin, Renfrew, Pembroke.
Mr. Speaker, it's clear from this old Liberals' response that they're incapable of rising to the occasion. They've become a broken record of vapid slogans. The Liberals are spending more, leaving Canadians to invest less. They're growing the economy from the heart out, the elbows up, the eyes down, but always against the fight for freedom. Dare to question them, and they suggest you're mentally ill. Or, like the Nationalist Fedmore minister, they'll accuse you of hating your country. This illustrates the choice Canadians have. They can choose the nationalism of the Liberal Party, which treats criticism as treason, or they can choose the patriotism of the Conservatives, which seeks to repair what's being broken in the country we love. That's the choice, Mr. Speaker. We choose patriotism over nationalism. We choose humility over arrogance. We choose Canada strong and free.
Honourable Parliamentary Secretary to Minister of Finance.
The member has adopted the Canada Strong message on behalf of the government. I appreciate her finally contributing to a plan that I think will make our economy stronger. As I said, we are moving forward from a position of strength. That gives us the fiscal capacity to do the things that we've proposed to do and that we're actually implementing. Major investments in defense, infrastructure, housing, boosting innovation and productivity across the country. But again, the spring economic update shows very clearly that there's progress being made. 11 billion less of a deficit. The average yearly increase of government spending has come down from 8% to 2%. Over the next 3 years, we'll come to 0% increase. We also see lots and lots of change within the economy. Highest foreign direct investment in almost 2 decades. A member opposite should understand that those things are really good news for this country and for all Canadians as we build a prosperous Canada.
The Honourable Member for Cloverdale, Langley City.
A country that can't keep its streets safe is a country that is totally losing control of its future. What's happening in my community of Surrey and Cloverdale should be a warning to every member of this House. Quiet neighbourhoods are being hit by gunfire. Families are wondering whether they're safe in their own homes. Businesses are being threatened, and the rule of law is being challenged in broad daylight. This is not inevitable, but if we don't act with seriousness and resolve, organized crime will continue to test the limits of our justice system and intimidate law-abiding Canadians in their own communities. Let's begin with what happened just last week. In the residential neighbourhood of Sullivan, shots were fired into a vehicle. One 25-year-old man was killed and another was seriously injured. Investigators have confirmed that it was a targeted act tied to the ongoing BC gang conflict. This is a neighbourhood where I door knock in regularly, and it's the second gang execution there in a month. What is most troubling is not only the violence itself, but the facts around it. In late April, Surrey Police confirmed that officers from the gang unit had been reassigned to deal with the surge in extortion. When organized crime required focused and sustained pressure, specialized resources were being pulled in another direction. That should concern everyone. When enforcement is stretched too thin, criminals look for openings. When pressure is not sustained, organized crime adapts. And when police are forced to shift limited resources from one serious threat to another, innocent Canadians are the ones left in the crosshairs. What happened last week was not some isolated gangland shooting in a back alley. It happened in a quiet neighbourhood filled with families. People who had nothing to do with this violence and are now left wondering what could happen next. We need to be clear about what we're dealing with. This is a web of rival gangs and sophisticated organized crime networks increasingly tied to extortion. The violence is not contained between criminals. It is spilling into our neighbourhoods, our businesses, and our streets. When a multi-agency task force was empowered to go after these criminals, there were signs of progress. More than 30 active investigations, close to 100 judicial authorizations. and coordinated action across agencies. Over 100 individuals were being examined for immigration violations linked to those networks. That's what it looks like when the full weight of the system is applied. But that pressure has to be constant. Organized crime doesn't disappear because of one announcement or one operation. It has to be confronted every day with sustained enforcement, specialized policing, and real consequences. At the same time, we cannot ignore the pattern of leniency in the system itself. Individuals with serious criminal histories remain in this country when they should have been removed. Offenders breach conditions, reoffend, and continue to benefit from delays, reduced sentences, or rulings that allow them to stay. Judges have warned of a two-tier justice system where penalties are softened to avoid deportation, while Canadians face the full weight of the law. Even people under deportation orders are facing serious allegations, have been able to exploit the gaps and disappear from oversight or avoid consequences. That is not right. It sends a dangerous message to criminals that the rules are negotiable and the consequences are minimal. If we want to turn this around, we need sustained support for law enforcement. That means specialized units that remain focused, officers on the ground who are not pulled away at the first shift in priorities, and tools like air support that help police monitor suspects, coordinate responses, and stop offenders from operating freely. So will this government finally stop with the rhetoric, restore mandatory minimums, repeal their catch and release laws, and ensure criminals face real consequences?
The Honourable Parliamentary Secretary, Minister of Finance.
Well, Mr. Speaker, I welcome the opportunity to rise today on an issue that Canadians are no longer willing to tolerate, and that's the surge of extortion that is targeting our communities, our businesses, and our families. Crime has evolved, and frankly, our laws did not keep pace quickly enough. That is a reality, but unlike the members opposite, we're not interested in pointing fingers and walking away. We're taking responsibility and fixing the issue. This is why we introduced Bill C-14, the Bail and Sentencing Reform Act, and Bill C-16, the Protecting Victims Act, two of the most consequential reforms to the criminal code in a generation. Bill C-14 gives tools to provincial judges and police officers to put repeat and violent extortionists in jail where they belong. It mandates strict bail conditions for those accused of extortion and organized crime, including weapons prohibitions and geographic restrictions. It introduces a reverse onus for extortion involving violence, shifting the burden so that those accused must justify their release instead of the Crown doing so. And it ensures that sentences for extortion and arson are served consecutively, because escalating violence deserves escalating consequences, period. Bill C-16 goes even further by addressing how these criminal networks operate. It creates a new standalone offense to target those who recruit young people into committing crimes like extortion. These criminals are not just breaking the law, they're grooming young people to do their work for them. We're shutting that pipeline down before more lives are pulled into it. But here's something that Canadians must know. These bills were introduced last year. Canadians expected urgency, but what they got from the Conservatives is delay, obstruction, political gamemanship, and all while standing in this House pretending to be tough on crime. And now the same pattern is repeating itself in the Senate, where a Conservative senator has recently claimed there's no timeline to pass Bill C-14 and bring it back here to the House for final stage. And that despite overwhelming support from all 10 premiers, from police chiefs across the country, frontline officers that I've talked to, and from business leaders across this country who are dealing with extortion in real time. So let's be clear. The only thing standing between Canadians and stronger protections right now is Conservative delay. If the member opposite truly cared about victims of extortion, she would use her rhetoric and her actual influence inside her party to make sure that these bills get passed. Tonight, when she goes home, we hope that she'll pick up the phone and tell her Conservative colleagues in the Senate to stop blocking these bills, which you've been doing, and urge them to pass C-14, both at committee and at third reading, before the end of this week, before Friday, Mr. Speaker, where she will continue to say one thing here while her colleagues ensure that nothing actually gets done. The legislation is here. The solution is here. The only question is whether the members opposite will finally stop their obstruction and start standing with Canadians and the victims of extortion.
The Honourable Member for Cloverdale, Langley City.
If this government is serious about restoring safety for Canadians, then it has to act with clarity and resolve. That begins with consequences. Serious, repeat offenders, particularly those engaged in extortion and organized crime, must face meaningful jail time, not symbolic penalties, but sentences that deter and protect. The new Liberal legislation to make it criminal to shoot a gun from a moving car is completely unserious. These criminals already know they're committing a crime. We also need bail rules that put public safety first, not last. We need to close the loopholes that allow non-citizens involved in serious criminal activity to manipulate the refugee system, remain in this country when they shouldn't. And we need to end the leniency that allows those convicted of serious crimes to avoid removal. We desperately need, at the same time, to work with police, provinces and communities, providing sustainable support to dismantle those networks properly, restore confidence where it has been lost. What is the reason this Liberal government doesn't take this issue seriously?
The Honourable Parliamentary Secretary and Minister of Finance.
That's exactly what we've been doing, which is working with law enforcement, working with police associations across the country. We've had tons of testimonials over and over and again for these two bills. I've talked to my police association, my father, who is an ex-homicide detective, and many other police across this country who've been asking to pass these two bills. Also, the women's organizations in my region have been asking to pass the Protecting Victims Act, and they support the work of this government. Why does the member opposite continue to claim false things in this House that we don't care when we've put the solutions on paper, that we've done the work in committee, that we've passed the bills through this House, and we see Conservative senators blocking this legislation and trying to slow it down. They've been slowing it down for way too long. You know, get out of the cheap seats and actually do something to help Canadians.
The Honourable Member for Yellowhead.
Thank you, Mr. Speaker. Over the past year, I've sent various reports and updates to households and businesses across my 35 communities of my beautiful riding. Yellowhead, this last election, has significantly changed boundaries, incorporating areas from 5 previous ridings. One of the mailers was a tax guide to help individuals, families, and businesses to help keep more of their hard-earned dollars. One of the many have found this mailer very helpful. However, hundreds, if not thousands, of my constituents did not receive it due to a lack of coordination between Canada Post, Elections Canada, and the House of Commons printing services. To those watching, I encourage you to visit my website and review my monthly updates, but please know that my team and I are actively working with all parties involved to resolve these delivery issues so that you receive the information you expect from your Member of Parliament.
That's right.
People have the right to hear from their elected officials. Taxpayers are paying for the service, and it's unacceptable that my constituents had not receiving it. Mr. Speaker, as the only CPA with a public practice experience in the House, every day I hear from law-abiding Canadians and professional accountants. People are struggling to navigate an increasingly complex tax system. Individuals with limited internet and those lacking computer skills are being discriminated against when dealing with CRA with their access. Now, recently, a report out of British Columbia is deeply concerning. A Canada Revenue Agency employee has been charged after allegedly compromising sensitive tax information and now is facing charges including breach of trust, identity theft, fraud following a multi-year investigation. While honest taxpayers are being burdened, cases like this raise questions. Canadians expect the CRA to protect their sensitive financial information. Instead, we see situations where bad actors within the system are able to access and misuse and abuse the data for years before being caught. Tax fairness is not about just how much you pay, it's about ensuring the system treats everyone equally. That means going after the wrongdoers while respecting and supporting the millions of Canadians who follow the rules. Now, Mr. Speaker, in April, there was a response to my question regarding removal of all taxes. The Liberal minister said that Albertans are looking for the government to provide solutions and claimed that her government is delivering. What is true is that Albertans are looking for change. What is lacking is any proof that the government is actually delivering. Real action would mean scrapping all federal gas and diesel taxes for the rest of the year, not pausing a third of the taxes for a third of the year. That is not delivery, that's a headline. Statistics Canada has confirmed that Canada continues to have the worst food inflation in G7, and even with the temporary pause of the excise tax, Canadians are still paying nearly 15% more at the pump than Americans due to the higher taxes and our weaker dollar. Families feel this every day. Higher fuel costs drive up the prices across the board, forcing Canadians to choose between filling their tank and filling their grocery cart. So I ask again, if the government knows everything, energy costs drive everything else up, why won't they remove all the federal fuel taxes and deliver real relief?
Honourable Parliamentary Secretary, Minister of Finance.
Well, clearly, Mr. Speaker, Canadians are navigating a rapidly changing and increasingly fragmented and sort of volatile global economy, one that is more complex, more unpredictable, and for many more costly as well. And in response, our government continues to focus on what we can control, which is building a strong Canadian economy, diversifying our trade partners abroad. We see signs of progress with 20 new trade and security agreements signed and a 36% increase of non-U.S. trade, which is significant. We're also focused on delivering responsible fiscal management and supporting Canadians who are under pressure from everyday expenses. Just last week on Friday, I had the opportunity to list 19 different tax cuts that our government has made. No response from the Conservatives, of course, because they didn't support 99% of those. I think there might have been one that they allowed to pass, but I'm sure if they could have blocked them, they would have done so. Because that's exactly what we see in this House, them obstructing and voting against the very things that help Canadians, whether it's childcare, whether it's a national school food program, whether it's a groceries and essentials benefit, whether it's an income tax cut, whether it's suspending the fuel excise tax, on and on and on. Every single measure that we put forward that actually helps tangibly reduce the cost of living pressures on Canadians, they vote against and oppose. I don't know how they can stand up in this House and say that they actually care about households and cost of living. The other thing is the member opposite suggested that the tax system has become more complex. It's true that as we offer investment tax credits for businesses and we waive or increase deductions for certain kinds of expenses, or we help tradespeople who are moving across the country for work, relocating for work, we allow them to deduct more of those expenses. It is more complex for Canadians. But we've also moved forward with an automatic tax filing system and initiative that will allow millions of Canadians who, for many of whom, accessing federal benefits and supports rely on actually filing their taxes. And knowing full well that those help simple tax filings also means that other Canadians will be able to get access to benefits because it better utilizes the government resources to help those with the simplest tax filings actually be able to access the tax benefits and the federal benefits and payments that they're eligible for. So, we are stepping up to help out. We have a fiscal strength. The IMF has said recently that we have the strongest fiscal position in the G7 and that we should use our fiscal capacity. That's exactly what the federal government is doing. I know Conservatives would never invest in Canadians. They don't believe in Canadians. They don't believe in boosting the economy. That's not the Liberal Party's position. Our position is to use our fiscal capacity to boost our economy. We see those investments coming to fruition and manifesting good-paying jobs for generations to come. That's the prosperity we're building. That's how you build Canada strong. And we're not going to back down just Conservatives talk a good game in this House.
The Honourable Member for Yellowhead.
Thank you, Mr. Speaker. 3 years ago, before the crisis got worse, Conservatives called upon the Liberals to suspend gas taxes for the summer so Canadians could afford a simple road trip. The Liberals voted no. Now, after years of inflation, higher grocery costs, and during an international energy crisis, we're calling on a stronger measure, removing all federal fuel taxes for the rest of the year. Once again, the Liberals refused to act. Instead, the Prime Minister offers a half measure, cutting a third of the taxes for a third of the year. It might have helped back in 2023, but not now. Canadians are struggling. The cheapest gas around is reaching at $2 a litre. People cannot afford a government that is constantly behind. When will this government stop pretending and help and actually deliver real relief?
Honourable Parliamentary Secretary.
Well, Mr. Speaker, actions speak louder than words, and what we see is the words of Conservatives in this House do not match how they vote. They don't support any of the measures that our government puts forward. Just recently in the spring, how are they going to vote on the spring economic update? That's what I would like to know. With 80 to 100,000 new skilled trades workers hanging in the balance in terms of support. That's $10,000 of an incentive for a small to medium-sized company to hire an apprentice, $400 a week up to about $16,000 for a new apprentice, plus a completion bonus of $5,000 for 80 to 100,000 workers. How are they going to vote? So what they've said in this House is that they don't support those investments in the workforce in Canada. How can they not support workers across this country while standing up and saying that they care about families, affordability, and industries that are affected by tariffs that the United States has put on us? How can they not support workers? How are they going to vote?
It being 7:08 p.m., the motion to adjourn the House is now deemed to have been adopted. The House stands adjourned until tomorrow, Tuesday, May 5th, at 10 a.m., pursuant to Standing Order 24-1.